No, I guess I need to do that. Okay, that's really.
I had a long day yesterday. I was supposed to have a 2-hour Zoom in the afternoon because she knew this one was coming up today. And somebody got sick, and I wound up going at a doctor in the morning and then a job in the afternoon. I didn't get home till 7 o'clock. I'm like, okay, so much for a short day.
Oh no. Well,
Glad I could help somebody out.
yeah. Well, you never know. It's going to be you some days. All right.
Knock on wood.
Yeah.
I haven't had to ever cancel.
That's great. Yes, I appreciate that. All right, here it comes some people. Let's see.
Okay, sounds good.
All right. Well, good morning, everyone. Just starting our system up here and getting people checked in. Looks like I've got a number of people already in the system with their party affiliations identified. So good to go on that end. And just to let you know, we're live streaming now, which is a little unusual, just in case people are lining up to greet us by on YouTube. They'll see us here already, and they won't just be waiting until 10 to try to join. Um, but yeah, so we'll get started at 10. So just sit tight for now, and we'll be checking people in as we need to and getting things set up here.
I'll be right back.
Okay. Okay. Oh, yeah. Screen share. Forgot about that. Get that going too. Well, I don't have anything for around. Huh. Mm. Maybe. Oh, that's what it is. Ah.
Good morning, Judge Newmark.
Good morning. I hear you. Let me get the screen up in front of me here. Okay. So, will that be the attorney seat you're in there?
Yes, Your Honor. Occasionally, we might have a second attorney in the other camera, but mostly the other one will be witnesses.
Witnesses. Okay, perfect.
I need a bigger screen or stronger glasses. Everybody's names are really small now.
Uh-oh. Just had a great update come into Zoom, so hopefully nothing's changed too much.
This is why I don't have Zoom downloaded.
Yeah, it didn't look like any of the settings were changed, I hope, but you never know. Find out when you least expect it. So it's after 10, but we're still checking people in. Our live stream's already going in case we were at people who were anticipating the hearing, wanting to observe. So welcome to everyone who's on the live stream. And we'll get started in a minute or so. Just want to get people in the Zoom, parties and staff who will be allowed to participate by Zoom. And then members of the public, if you can stay or either stay. Yeah, no, we have no one in Zoom right now who's not a party or staff. So just have people who are observing only public members just stick to the live stream. Hope everyone was able to connect okay. Usually people get in here before 10, before the stated time at the beginning of the hearing. I'm not sure why we're seeing so many people coming in late. So my apologies to everyone who's waiting. So I just let in a person identified on Zoom as Alex. I'm assuming that's Alex Tetzloff from International Union of Operating Engineers. Just let me know if I got that right. I'll change your screen name.
Yes, it is, sir.
Okay, great. Perfect.
Your
Thanks.
Honor.
So it looks like I labeled both pub services, Zoom connections, WPSC attorneys. So one of them I'm not able to change at this point. I'm not really sure why, but we'll have to play it by ear. Maybe I can do it when we start taking witnesses.
Sounds good, Your Honor, and we can change it on our end. I think
Okay.
you
All right.
usually
Yeah,
try
that'd
and
be
change
great.
it to the witness's name when they sit
Oh,
down.
okay. That would be great. Well, if you can, yeah. Would you guys be able to do that? That would be great.
I think so. Yeah, yeah.
Okay.
We'll I don't promise we'll be perfect on it, but we will certainly try.
Person in here, we can get started. I think we have all the parties represented. I'm not sure if we have everyone connected we're expecting today, but that might not be the case at the beginning. So like I mentioned, live stream's already running and looks like that's good. I think we can get started. All right. Okay, great. All right, let's get on the record. So welcome everyone. This is Docket 6690 WR128. The application of Wisconsin Public Service Corporation for authority to adjust electric and natural gas rates. I'm Michael Newmark, the Administrative Law Judge for the PSC. We're connected through Zoom with parties and commission staff in attendance, and we are here to create the record in terms of the party and staff evidence. We'll receive that today, as well as make witnesses subject to cross-examination. And just gonna let people in as they get here. So just a note about our hearing process. This is the like I said, the party hearing session, and we'll be holding a public session to take public comments on Thursday, October 10th, 2 p.m. and 6 p.m. at the Ashwaubenon Community Center Activity Room. So we'll be up in that area of the service territory to receive public comments from members from public comments. We're also receiving written public comments. They'll be due Monday, October 14th. That can be filed through the internet or by U.S. mail. And the details on how to do that are on the notice of hearing. Also right now displayed on the screen share, so they'll be part of the live stream and the YouTube recording of this session. All right. So first order of business, just getting our appearances set on the record. And I'll just display our service list. And in alphabetical order, we'll have the parties and staff identify their appearances. So we'll start with Citizens Utility Board.
Good morning, Your Honor. Kara Coburn Ferris with the Citizens Utility Board. And I have with me our three witnesses, Mr. Corey Singletary, Dr. Steve Keim, and Mr. Tom Content.
Okay, thank you. IUOE Local 420.
Good morning, Your Honor. Alex Tetzloff, Business Manager for Local 420.
Thanks. Public Service Commission.
Good morning. Attorney Evan Whites on behalf of the Public Service Commission of Wisconsin.
Okay. Renew Wisconsin.
Good morning, Your Honor. Ori Walsvik on behalf of Renew Wisconsin.
Okay. Roundies.
Good morning, Your Honor. Kurt Boehm appearing on behalf of Roundies.
Great. Sierra Club.
Good morning. Good morning, Your Honor. Megan Walkspress appearing on behalf of Sierra Club.
Okay.
And it'll just be me today.
Yes. Okay. And okay, you have a witness though.
Yes, Ms. Metz, our witness, is here as well.
And Vote Solar.
Good morning, David Bender for Vote Solar, and Will Kenworthy is also online.
Okay. Walmart.
Good morning, Your Honor. Stephen Lee from the law firm of Stillman, Thomas & Battle on behalf of Walmart.
And Weeg.
Good morning, Steve Heinzen here on behalf of Weeg.
Okay, we got all alphabetically applicant last, Wisconsin Public Service Corporation.
Good morning, Your Honor. Attorney Patrick Proctor Brown on the Zoom right now, and attorneys Phillips, O'Connell, Zank, Jackson, and Wilson are also in the room with me.
Okay, great. Okay, we got the whole team there. That's great. Okay, so that's our introductions. Let's move on for our normal course of business here. And we can probably go off the record. Let me just say we're going to be discussing the offered evidence list, the list itself, any corrections, errors or omissions to the list first, and then comments and questions on the comments and notes that I sent out with this list on an email yesterday afternoon. So probably best to go off the record. So I know we don't, it doesn't look like we have a lot of cross, so I don't want to take up a lot of time. I know we have a lot of other cases in the mix here, but I did want to just let people know I appreciate all the work everyone's done with the crunch of this case and the other cases, putting this all together. I tried to give you guys some advance comments to try to, facilitate the corrections and keep them to a minimum. So I do appreciate the folks who did review the comments and adjusted their practice with the filings going forward. I'm not sure. I guess I just kind of wonder that there were still a number of parties that made the same mistakes again. And I don't know if I'm just not getting through to people or if there's maybe a better way of doing this. I guess if you have ideas, just shoot me an email because like as you can imagine, it is a significant amount of time and effort to go through the filings to find these corrections. And I was assuming that when the direct ones went out, that we wouldn't really see much on rebuttal or surrebuttal. So still, we ended up seeing some coming back. So I appreciate if everyone just if they have something to say, just put it to me in an email, and I'll review it, and maybe we can revisit how we do this. So, having said that, I guess just basic question first is any errors or omissions to the list? Did I identify the documents correctly, or did I miss something? So let's just start with the applicant.
Your Honor, we did file, I believe, 6 or 7 pieces of rebuttal this morning. Again, they attempt to be conscious of everybody's time, right? So these are pre-filed so that we don't have to read them into the record. I believe they were served not that long ago by Colleen Saporsky. So hopefully everybody has those, certainly open to discussing the content of those documents. And, if necessary, those witnesses are available to read that testimony into the record. But hopefully we don't get objections to those pieces of testimony and they're able to save the time for everybody.
Okay, I guess I did not receive those, not that I know of. When were they sent?
About 9 a.m. this morning, Your Honor.
You need to email that to me.
Your Honor, I think they went to the service list. I'm not sure if you were included on that particular email.
Okay. Yes, I'll need that. If the applicant can do that, that'd be great. So,
yes.
Yeah, so I suppose what we're doing is we're mimicking the process of taking this testimony live, the additional testimony on the stand. So it would be useful to be able to review that to see if it's appropriate, mostly in terms of volume. When it comes, if we want to mimic the process of speaking sir on the stand, then I'm expecting that there's nothing like exhibits or things of that nature where that would not be simply a statement on the stand. So we need to review that. I appreciate you bringing that up. So I obviously not on the list because I didn't have that before. So besides
they were filed on ERF, so they should be up there if that's more expedient. But we also just forwarded them to you, Your Honor. Would have been from Attorney Zank. There are no exhibits, so I'll confirm that. It's just fairly limited. Sir rebuttal to what I think is fair to say was significant Sir rebuttal.
Okay. Yeah, I haven't gotten that yet. So, okay. So any other issues with the list itself, the documents listed from the applicant?
None that we've identified, Your Honor. We'll just say, appreciate you pointing out where we could add citations to the record. We looked back, and for particularly Zagant's, when he's talking about revenue requirement issues and past order points, we haven't cited those before, but happy to do so now. I think that was the only thing that we had on the comments on the main documents, and so far as I know, nobody's identified anything that's missing from the list.
Okay, good. Yeah, so it is whenever you're citing to a commission order or referencing a commission order, I need to see a citation. So it should say final decision and the PSC reference number if that's available, or if it's not available, if the order is not available on IRF, it should be the document, the order should be filed as an exhibit. So I know you did go back, the applicant did go back to in the past to show some of the history, which is always useful, but if it's not on IRF, we'll need to see those documents presented as an exhibit for the record.
That makes sense, Your Honor. And just one point of clarification. You're just, when you're pointing out in comments that you want a citation to a final decision, you're not questioning other places where we're using the citation form. In other words, where we do cite a commission decision, we've done it correctly. Is that your understanding?
Yes, I think so. I don't know if I can say that accurately because it was cited different ways for different witnesses and different parties. But the important thing is to say what the name of the order was. So final decision, if it's a final decision, and then the PSC number, if there is one that's live on the public facing IRF system. So if you say the commission approved, in the last rate case, the commission approved X, that it should at least point us to it's a final decision in which they approved it, and here's the IRF number. So that could be just done in a footnote. I think staff has been has done that very consistently, but they'll just throw that in a footnote. But that's the kind of the two elements, is the name of the order and the IRF number.
Okay, thank you very much, Your Honor. I appreciate it.
Yeah. Okay, good. Okay, so we'll move on to Cub. Did I miss something or do we need to talk about something?
Your Honor, I see that a couple KIME exhibits 3 and 4, which were filed along with his Sir rebuttal, and Singletary exhibits 11, 12, and 13 are not on the list. And then Mr. Singletary also filed some minor errata to his Sir rebuttal yesterday.
Okay, yeah, I think I picked up the Sir rebuttal. Let's I probably just didn't paste it in. I don't know if I still have that file. So there's, yeah, so Singletary 11, 12, and 13 I have here. And kind of exhibit 4. I got 3. I got 3, but not 4. Makes you wonder what happened there. Okay. Anything else?
In addition, Dr. KIME has a very minor correction to his exhibit 1 that we caught yesterday afternoon that he would like to deliver on the stand if he may.
Okay, and it'll most likely require a refile, but that's fine.
He will then refile.
Okay.
The revised exhibit.
Okay. So then let's move on to IUOE. I think we got all the filings from the union. Is that right?
No, Your Honor, I did enter in Sir rebuttal the other day.
Yeah. Yeah.
Maybe I messed up when I did it.
No, I think something happened with my cut and paste here, so I don't know why.
And as far as the corrections, I will get those to you early next week.
Right. Well, they're due in 3 days, after 3 working days after the hearing. So that's
Okay.
Yeah.
Thank you.
And so just showing you, I'm correcting the way you typed in the earth name. So I know you've been participating long enough. So if you could please use the convention here, the surrebuttal, so the name of the testimony, the party identifier, and your last name. And then when you get to the pages, you know, that's a pretty simple, you just keep that consistent. I'm trying to make it simple, but you know, but put some value into this. So it is good that you have that the page number, we do get a page number and it's got your name and that convention on there. So, you know, just so you know, so now if I'm gonna try to read it here, and I got four different versions or 4 different files up, I'll know while I'm reading this what I'm reading. So I could have Hub Services witness and Cubs witness, and I'm trying to read them all together because you're referencing each other, but I'll know which document I'm reading because I got your name on the bottom. And then another issue that I've seen pretty frequently is just that starting that line number with 1.
Okay.
So yeah.
Fair enough, sir.
Great. Thanks.
Thank you.
All right. So let's move on to renew.
Your Honor, it looks like you've identified everything correctly, and I don't have any questions at this time.
Okay. Well, I got 1 down. All right. And so just so you know, you might see this. I don't know why this isn't working here when I hit the space, but I got this WPSC. I have the party who claim that they may have cross listed here now, just for my use here, so don't get confused by that. But Sierra Club, any questions about the list?
Yes, Your Honor, it appears that you have 2 SC Met 12, and I believe, and I am just double checking this now, that 17 was not confidential. So that there's just 2 12s listed. I'm not sure why.
Yeah, that's probably because let's find out. So this is 12 for sure. This one's labeled 12 by you.
Did the judge get kicked off?
I don't see him anymore.
I thought maybe he disappeared from my screen. I'm like, he stopped talking and he's not there. All right, hearing over. We can begin.
I was going to say, is there a 15-minute rule in facilitating matters?
I'll sneak one in there. 15 minutes or 15 seconds?
I want to be fair. Sure, I've been kicked off one of these before.
Okay, I'm back. Oh boy.
I wondered why you all of a sudden made somebody else host.
Oh, who ended up being host?
Ms. Metz? That's what appeared on my screen anyway.
That's interesting. Okay, well, take it away. We'll just yeah, well, this is what happens when you don't plug your computer in. Now we know. Let's make sure the live stream's still going. I think it's pretty robust. Okay. All right. Well, where were we? Looking at the Mets.
Duplicate exhibit 12.
Looked like the second one listed was designated by you as exhibit 12. Let's check.
It looks like there are two 12s in the docket. There may have just been duplicate 12s filed, in which case we will, I don't know how to correct that, but.
Well, I think what I would do is just pick one for you, unless there's a reason.
Okay.
So there's one filed.
No, I'm just
yeah.
Oh, sorry. Go ahead, Your Honor.
Oh, okay. So one was filed on 128 and another was filed on 134. So I guess I would normally pick the earlier one unless you've made some change that you'd let people know about beforehand.
I don't believe so. I think this was just an error of uploading this number of files and duplicating one, but I am confirming that right now, Your Honor. I apologize.
All right, well, that's fine. Just let us know. As far as I can see here,
Yeah, they're just duplicates. It was just a duplicate filing. So
take the earlier one then. There we go. Okay, good.
I did, Your Honor, I did have a question about the comments. In
Can we
one
wait
of the
for that
sorry.
and just want to see if the list is accurate first, and then we'll go back to comments. Okay. So vote solar, anything to note on the
Just one thing, Your Honor. The first exhibit 5, Kenworthy 5, I think it's supposed to be 5C to correspond to the 5.
Yes, you're right.
That's the only item.
Okay. I'm going to show that right now, but all right. And Walmart.
Thank you, Your Honor. The list is accurate for Walmart.
All right, great. And Weeg.
Yes, Your Honor. Everything's accurate for Week as well.
Okay. Commission staff.
Thank you, Your Honor. Just two minor corrections. First, for witness field, staff's preference is to switch the one that you struck. There was a duplicate filing, so the preference would be to use the earlier one or the lower IRF number.
Yeah, okay, that's what I usually do. So I don't know what I was doing there. Okay, good. And same thing with 202 was, I guess the same thing with 2.
It's both the exhibits and the direct testimony. For some reason, they got uploaded twice. So
yeah. But you want me to accept the earlier version for all?
Correct. Yep.
Okay. It's going to do this now because otherwise I'm never going to remember. So all right. Okay. So let's move on to comments and notes.
One
yeah,
other
go ahead. Another one. Okay.
Sorry, I wanted to let you finish that.
No, that's okay.
Witness Craft had one exhibit that was filed with her SIR rebuttal. So that's exhibit PSC Craft 1.
Okay. My mouse had misbehaved when I was working on the SIR rebuttal. Where is it here? No, there it is. Yeah. There, we got it this time. Okay, perfect. That's it?
That's it. Thank you.
Okay. All right, so let's move up again with the applicant. Any questions on the comments or
Your Honor,
notes?
before we move to that,
Oh, sorry.
sorry, I just noticed that there is an exhibit, I believe, missing. Mr. Kenworthy had an exhibit 18, a confidential and a public.
Okay, do you know what round that might have been in?
The SIR rebuttal.
Oh, yeah, okay. Did I catch pub services last?
You also, sorry,
Oh.
you're also missing that for Sierra Club, the SIR rebuttal exhibits 35 through 37.
Sure. Oh, look at that. What happened here? Okay, and then Singletary Adams. Did I get Adams' second exhibit? No. That whole thing did not transfer. Huh. I think I got them all now. But did I indicate all the SIR rebuttal? Yeah, I think so. Field. Yep. Okay. All right. Thanks. Yeah, there's a bunch of them missing. Okay. Something happened. All right. So can we move on to comments? Any questions from the applicant? And we'll just do the, well, let's see. Maybe we should just take the main comments first, then I'll group swing back for individual parties. So I did have several notes here. And they do implicate some of the comments, but not all the comments, but it may be helpful to clarify that by doing this first. So let's get on the record for these notes. So first of all, good to go here. All right. So first of all, we have our comment regarding testimony citations that are not offered for the record. If they're, and the example I have here is Sierra Club Mets 33 and 34. Those are documents that to me seem like the commission's going to want to see, or a commissioner may say, well, you cited this, but it's something that, you know, I want to look at it, I want to verify it, or I want to rely on it in some way. And then 33 being the application sort of letter that was filed by the applicant, and then 34, Mets 34 is the reference to certain pages of the Federal Register. And for Federal Register, to me, it just seems so hard to find sometimes, and it's such a big document. So it's just as a courtesy more so to the commission, if they do want to look at that document, we want to provide it to them. So this is kind of a fluid standard, because it's kind of hard to know when you're citing something and you just want to make sure people know your source, and you put the not record evidence disclaimer on it. That's all correct. But then there just maybe some documents that just kind of rise to the top as being ones that we may need to see, or will be convenient for the commission to have. So that's something, you know, just kind of an ad hoc basis. I'm going to just throw that in and add an exhibit for you. If you don't realize it in the first go around. So I just wanted to mention that for everyone. And then the examples are Sierra Club, but I think it's useful for everyone to know. I think this is also, I think there's a few other documents like that I've added in exhibits for. So any questions about that? No? Okay. Next order of business is quoting commissioners' public statements. So I think I'm going to read this into the record and then have people respond. So that just might be the quickest way to handle this. And I know time's of the essence here. So let me begin. A rebuttal Cub Singletary, page 3, lines 16 through 24 through page 4, line 8. That's currently filed in this docket. Has witness Singletary submitted an extensive quote purported to be a comment from former Commissioner Vach at the open meeting discussion of the record in docket 5UR110. In the past, I've rejected quotes from commissioners for 4 reasons I consider such quotes to lack probative value. So first of all, the commission speaks through its final decision, not the open record discussion. So such statement having no authority and being made in the context of another proceeding should have no bearing on a current proceeding. Second, the commissioner's open meeting statements are untestable hearsay opinions of a layperson and highly prejudicial. A commissioner does not participate in a proceeding, either 1, in the capacity of a witness with expertise in any one area of utility regulation, 2, under oath, or 3, subject to due process scrutiny. So this just renders the statement subject to all kinds of procedural problems. So third, in the past, such statements, before we were live streaming and had YouTube recordings, were impossible to verify. 4, presenting such a quote, even if it could be verified, takes the statement out of context from the entire discussion and therefore renders it subject to potential manipulation. And that just leads us back to reason 1, which is commission speaks to its final decision. We don't quote commissioners as having authoritative, as an authoritative source. So with all due respect to them. So we do now archive our meetings, our open meetings, and the quote is on our YouTube channel. So there could be a mechanism to verify a quote, and I could impose a method of doing so that accords with the rest of the hearing process. So for example, we could require the offering party to file a verified transcript of the open meeting discussion. However, that process does not address other substantive deficiencies of receiving such evidence as we just discussed, like verifying or that the statement wouldn't be under oath and it's not subject to cross-examination, etc. So my inclination is to have to strike those comments and to have Cub refile with those portions just blacked out. But I'm willing to listen to any comments from the parties, commission staff about that before I make a final decision. So I guess we should have Cub probably chime in first if they wish.
Thank you, Your Honor. So Cub does believe that, you know, as you've noted, this is verifiable through the easily accessible YouTube meetings. And, you know, we would note that the Wisconsin Supreme Court has quoted commissioners when they are, you know, elaborating on in the open meeting on their written decisions. And, you know, we think that the quote that witness Singletary provided is very, very clear and provides, you know, good context for the discussion of that he presents there.
Okay. Anyone else wish to comment on this?
Your Honor, applicants would comment briefly.
Okay, yeah, go ahead.
Thank you, Your Honor. I do agree with Attorney Coburn-Ferris that there are occasions when commission comments provide proper context for testimony and for the status of the case. There are instances where the commission provides context for information they would like to see in a future rate case in open meetings in the past. So that may not be reflected fully in an order point. I agree with Your Honor that there could be a process for verifying them. Our issue with this particular quote is that it appears to us that Cub is offering it for the truth of the matter asserted, and that there are problems with payroll at applicants and their sister utilities, and believe that your proposed course of action to striking that quote is the appropriate one.
Okay, anybody else?
Your Honor, this is Ori from Renew Wisconsin. I have no opinion on this particular quote, but I do agree that there are instances where quotes from commissioners at open meetings would be useful, and would appreciate a process to include those in the record in the future. Thank you.
Mm-hmm.
Your Honor, David Bender on behalf of Volt Solar, I'd join that. I mean, I think it may be case by case, but there are times where the commissioner's statements may be more enlightening than the order, depending on how the order is approved or not by the commissioners. I also agree with Cobb that in the past, the courts have cited commissioner statements, so the courts have at least relied on it as well. And I would note that treatment of anyone else's statements, kind of hearsay statements, are quoted often in testimony. And I don't know why we would treat commissioner statements differently.
Mm-hmm. Mm-hmm. Yeah, I think because of the weight that they would be given, but and we won't have to get into the discussion about that. But
and Your Honor,
who's
Steve,
that? I'm sorry.
I'm sorry, Steve Heinzen on behalf of WEG. Yes, I agree with the statements that have been made by these others. Certainly don't think that there should be just a broad rule that would not allow the testimony or the statements of the commissioners in all circumstances.
Mm-hmm. Okay. Anyone else? Commission staff, any opinion?
Your Honor, I guess the only thing I would say is I agree that the commission speaks through its final decisions. Those are the ultimate authoritative source of the decision that was made by the commission. And really the only thing that I would add, and I think this goes to your fourth point about context. In discussions at open meetings, oftentimes that's the only opportunity that the commissioners have to talk to each other and sort of vet their thinking. So as everyone knows, there's kind of a back and forth oftentimes where a commissioner may start from a certain position and then through the course of discussion arrive at a different decision through that deliberative process. So my only concern is that context piece of where does the quote come from? Is it an initial statement and then later in the course of the discussion, the commissioner changes their opinion? I think it's kind of a slippery slope as to how we memorialize or capture that. So that would be the only thing I would add.
Okay.
Your Honor, this is, if I may respond to that briefly, if the entire meeting is recorded and available, there's no reason why that kind of misrepresentation can't be challenged on cross-examination or rebuttal testimony the same way any quotation from a case or selective citation from any other record would be challenged through evidentiary proceedings.
And I would note that CUB is, willing to provide such a transcript.
Okay. Okay. Well, let me think about that. I think we can hold that over. But yeah, I'm going to review the statement again and hold it over for now. I think, ultimately the commission will give it the weight it feels like it deserves. So that's always the final check if it got into the record. I guess I would rather not have debating commissioner quotes be the substance that is relied upon or argued about in our proceedings. I think we really would want to be looking at substantial evidence in terms of expert witness testimony on these subjects. So that is partially, that's really another element of my concern here, is that we simply have these statements existing maybe not in a vacuum, but kind of in its own plane, and then we have expert testimony arguing something different. Just that ends up confusing issues rather than enlightening us on it. So let me review those particular quotes, and I'll by the end of the day I should have a ruling on that. Okay. So another aspect of the filing here is saw I know it happened in these two instances here. I guess there's also, it's in Pub Service and Webco's case, but the Zgonk exhibit related to force majeure or some delays in on certain projects. There was a letter that was filed in another docket. It was brought into this proceeding through this exhibit, but only the redacted version was provided. So, it's been my practice that if you're going to file a document, especially one that we have unearthed, something that the commission possesses, we need to get both versions of that. So the confidential version and the public version should be filed as the exhibit in this case, and also just to preview next week in the Webco case. I'm not sure if there's any other examples of that in this case at this point, but yeah, I think we just want to make sure everyone realizes that's something that I'm going to expect. So we don't want to have you file public versions, redacted versions only especially if we have it on file, we have the confidential version on file, or if you possess the confidential version, then give that to us as well. Any questions about that?
No questions, Your Honor, but thank you for bringing it to our attention. I think it was just missed in the large filing that happened that day.
Okay. Yeah, and it's actually, I think what's redacted may be of substantial value in this case, so that didn't go unnoticed. Next one is we have similar situation here, a redacted public document. It's without our unredacted counterpart, and it's a Singletary 12 is the exhibit. I guess the exhibit states on the cover page, and I'm just going to quote this here, data for census tracts with fewer than 50 reported customers redacted to protect customer information. So I just want to hear from Cub exactly what's meant by this and why we're redacting this information. So yeah, just can you elaborate a little bit about that? Explain it.
So maybe witness Singletary can better explain it, but in terms of his analysis, those were such small data points. There were only there were census tracts that have one or fewer customers, one or few customers. So maybe I'm not sure what his cutoff was, but it was very, very low, and didn't want to reveal any customer, identifiable customer information. And so it wasn't, redaction was probably not the best way to put it. It should have been excluded.
So you would
excluded those from the analysis.
I'm sorry, the end of that again? What about the roundies?
He excluded those lines, those data points from the analysis.
Thank you.
Okay, so it's not in the analysis as well. Okay. Well, that does create a different angle of that. But so if you're not going to rely on that information, I think that would be, I don't know. I mean, maybe if we talk to him about it, it may be useful.
I think so. They were, because let's let Mr. Singletary explain if that's all right.
Okay, we'll hold it over for then. Yeah.
Okay.
I mean, ultimately, one solution is just to file a confidential and public version. But I understand the point, maybe a little more nuanced than that, so we can move on.
Yeah.
Your Honor, just really briefly, as the applicant, we certainly understand the protection of customer information and don't want that in the record. But it does look like there are redactions to the exhibit. And so if there's a change in methodology that hasn't been disclosed, I think that would be appropriate to put in errata. Like we're actually excluded from the analysis, not just redacted. But as you identify and Attorney Coburn-Ferris said, Mr. Singletary could certainly address it in his testimony.
Right. Yeah. Let's remember to do that.
And just to clarify, I misspoke. They were redacted. They were not excluded. So those data points, even though they represent, very low number of customers.
Okay. So they were used in the analysis. Okay. Well, that brings us back then. So, I mean, the option could be to either file a confidential version with a public version, but I'm not quite sure what the basis of the redaction is, because I'm not sure what is being revealed in that document in terms of customer identifying information.
And so you could use the geographical ID to individually identify the customer. And so we didn't want that information available.
So the whole census tract would give.
Well, because there's only one or a few number of.
Okay, it says fewer than 50. So that could be a lot more than one, first of all. But then, I mean, what would it be doing? It would be saying there's someone in this area is of low income. Is that of low income status? Is that personal information? It's in a census file. I guess as if it's in a public database of census tracts crossed with income information. It's a public record. I don't see how we have the ability to then withhold it from the public. So that's from my perspective. I have to think about, well, how does the state agency withhold information from the public when it's available somewhere else? So if Witness Singletary can address that now, when we get to him, that would be useful.
He will do.
All right, great. Okay, so then there was a statement in, I did read the Surabel from Ken Worthy. Statement that it looked like Vote Solar and the applicant agreed that some information is available to the public, could be available to the public, and it's now appearing unredacted in Kenworthy 18. And I guess I'm just curious, do we need to refile something to reflect that agreement that there's something that was, if something was filed confidentially, that can be now released to the public?
That is the agreement. I'll let Dr. Brown correct me if I'm wrong, but we have reached out and it, because everyone's busy, it took a while for everyone to get on the same page and agree that certain things can be publicly filed. And so 18, what's now Exhibit 18 includes everything that was in the Exhibit 5 plus some more, and no longer redacts. So we could refile Exhibit 5 without as many redactions, but it would be duplicative of what's already provided in 18.
Okay, so 18 replaces 5.
It replaces and supplements. It's got more in it, but it also has everything within 5.
I don't have a particular comment on the offered evidence list and how to do that kind of stuff, but I would confirm that Attorney Bender accurately stated our discussions, and we agreed to unredact the portion that he included in 18. I don't think we need to file anything more on that, but I'm happy to take your direction on that, Your Honor.
Okay, yeah, and then in terms of the testimony, does anything need to be unredacted that's been filed before confidentially?
No, there's nothing redacted in any of our testimony. We just put everything confidential in the exhibit.
Okay, and then Vote Solar is the only party that's presented that information that you know.
To my knowledge.
Okay, all right. So yeah, I think it's useful if we could refile 5 because we'll be holding that. And so especially if we're holding information confidential in one document and public in another, that's going to confuse matters. I mean, especially if you think of down the road a few years, if we get an open records request, we'll need to be denying one and releasing the other. That's going to make us look bad. So,
and just a very brief suggestion, if you wanted to renumber the citation and the testimony, that might be easier too, Dave. I'm not sure which way you want to go, but we're open to either for sure.
Yeah. If 18 can be useful as a substitute for 5, you can do that in your prior testimony. That's fine. And just in terms of keeping the record straight, though, we'll still need a refile of 5.
We'll refile 5. I think that's probably most expedient.
Okay. All right. That it didn't. Okay. So just quickly here, surrebuttal. So there was actually some more to that it's not there anymore. So that document, so we had the Bulkley surrebuttal 6 through 7. Didn't look like there was actually responding to something stated in rebuttal, and my question there was a little bit broader because I did see Sierra Club also added the beginning of surrebuttal for Mets, added some testimony about background, and I think that was in response to rebuttal, but it didn't state so. And so I guess the more overarching comment here was, if you are going to respond to something in rebuttal or surrebuttal, just cite what you're responding to. Doesn't have to be a big explanation. In fact, the more concise you can be, the better. I think in some cases parties tend to explain and take a long space explaining what the prior testimony was from another side, but it's not necessary. At least the citation saying I'm citing to when they said I didn't have enough experience. Here's more experience in response. So that would be useful. I think in Bulkley, I'm not sure, it talks about capital structure, but it doesn't say what rebuttal Bulkley is responding to. So I don't know if the applicant can just elucidate on that, or if we have the witness explain that. But if it's testimony taken out of order, we'll need to take it out of the surrebuttal. If it's not rebutting, if it's not surrebutting anything and just adding new evidence, we'll have to take it out. So,
Your Honor, I can address that.
okay.
I would direct you to page 6 of Ms. Bulkley's surrebuttal.
Yeah.
Lines 10 through 12. She's identifying position taken by Dr. Keim in his rebuttal, suggesting that the commission should investigate the possibility of lowering the company's equity ratio, which is part of the company's capital structure. And she footnotes that to a site to his rebuttal testimony at page 9.
Right.
And
that's, yeah.
The following Q&A follows up on that. If you want to go back to Mr. Keim's rebuttal, you'll see a recommendation on page 9, lines 14 and 15, after he has a discussion about financial strength and as it relates to capital structure. He says, I agree with Mr. Adams that the commission should not increase the company's common equity ratio, again, which is part of the capital structure. I suggest the commission investigate the possibility of lowering it. And that's what Ms. Bulkley has responded to.
Okay. Okay, yeah, so just a citation to that in the context of that question would have been useful, just so we could avoid my scrutiny, to say the least. Okay.
Yeah, I guess, yeah, hindsight, I guess it could have been crystal clear, yes.
Okay. Yeah.
But it is responsive.
Okay. Anyone have a comment on that? Anyone else? All right.
I just say from applicant's perspective, Your Honor, I agree with you that it seemed that Ms. Metz's testimony about her background was responsive to some of our testimony.
Yes. Okay. Thanks. Okay. So we did have a few background questions for, is it Megna, witness Megna? I'm just expecting if the utility doesn't want to handle that, or maybe they did on rebuttal, I'll just be investigating that a bit just to get some background on forestry management practices. Then I did want to mention, so I did have an
Your
issue.
Honor, before you move on from that,
Go ahead.
I'm happy to address that a little bit. So I don't think we addressed your specific questions in directly in the SIR rebuttal.
Okay.
From our perspective, we could handle it one of two ways. We prepared some written responses that we could file as an additional piece of testimony, either a supplemental SIR rebuttal or wherever you think we should put it, to be honest with you. Or he could address it on the stand. I think it's a matter of timing, as he'll just essentially be reading pre-prepared comments.
Okay.
Answers.
Yeah, I would probably just be on the stand. Just something brief, just because it just seems like we don't have background about this, and maybe it's everyone else understands this, but it should just be in the record too. So that's whether you all know what you're talking about or not, it should be something like this should be in the record. So I'd appreciate that. Yeah.
Sounds good, Your Honor. And hopefully if we're expeditious on the other witnesses, and that would be time saving, because I don't think anybody else had cross for him.
Okay.
So,
all right.
Thank you.
And so now this is a little addition here to what I've presented in this document before. And I have to admit, it's something I picked out around midnight last night. So I'm not quite happy about it, to be honest with you. But it's a note that I included in the list that I provided for rebuttal, which was that there are block quotes in the Ardent testimony that provided no citation. So I did a little digging that disturbed me, and my original note was put the citations in to correct this, thinking that there was one that you could present. But looking at the document filed, so I don't know, can everyone see this, or is it too small? You're good? Everyone's good?
We can see it, Your Honor.
So the rebuttal that was filed is on the left here. the color versions, if I'm getting this right, and correct me if I'm wrong, if I'm getting this right, the green is cited from this page of this NERC LTRA 2022 document, which is what I believe is the statement that's coming out from it's the 2020 long-term resource assessment from NERC, which is the only citation we have provided by the filer here in the testimony. So I looked up that document and I'm showing on one page, this is page 5, in the executive summary, there's the first sentence in green, showing that on the screen share. And then to get to the blue sentences, that the next sentence quoted in the testimony is, I've highlighted in blue. That is on page 9 of the document. And in that same paragraph, several lines down, there's the last sentence that the witness quoted, which is I've highlighted in yellow. So this is not a proper quote. Okay, so, and it's
Well,
not.
I guess, Your Honor, I think we would probably disagree with that. We've quoted all the information in that document, and it was readily accessible to you to find that document. It's been on the internet for 4 years. It's been cited in multiple pieces of testimony before the commission. I don't think we misrepresented it at all. But if there's something that you would like us to do to be more accurate with our quotation of a publicly available document from a well-established source, we certainly can.
Okay, let me move on to the next one. So you also cited NERC 2023 statement to FERC. That was on the same page of testimony. So we'll move on to that one. So again, all we have is NERC CEO stated. And there's I put in a green box the first part of the quote and blue highlight for the second part of the quote. And then looking at the statement copy that I found on the internet, we have the green portion is in the middle of the page. Then several lines down, 3 bullet points down, there's embedded in that last bullet point is the last sentence in blue. And then finally, we have the third citation, MISO CEO sounded the alarm louder in a February 2024 report. Well, there's no citation to that at all. So just Googling February 2024 MISO report, I picked this up, 2024 Reliability Imperative Report, February 21st final. And it has a message from John Baer, CEO of MISO. Quote again, so I didn't highlight this, I guess. First sentence at the top of the applicant's quote is the second paragraph of the page provided on the original. And then this last sentence provided in the quote from the applicant is the final sentence at the bottom of the page. Now, or maybe that might not be the bottom of the page, but the bottom that I copied. So at least in this situation, there's 3 dots indicating that there's a break, at least in this quote. But see, I mean, this just makes me very frustrated because how do we know where this is coming from? When I read a quote that's filed before the commission, I'm expecting that I'm going to be able to get to that citation and see exactly what is being presented. So, I mean, this has 3 dots, but there could have been a much better way of indicating that there's a huge break between that statement and this as well. I mean, it just looks like you're just quoting what is actually in reality another document. This one is totally unreasonable. I mean, it's on another page. You don't cite any pages. So I do dispute, and I'm frankly surprised you're digging in on this, Attorney Proctor Brown. I would be embarrassed to file this, but I don't know. I mean, this is just unreliable. So it just does not inspire confidence in this proceeding to see something like this. I had to pick it out on my own. And so, okay, we need to have citations. as a bare minimum. You need to cite these documents so someone can find it. And they need to be accurate. I mean, that's just, we're all attorneys here. I'm just really, really shocked to see this.
Well, Your Honor,
Your
I
Honor-
think we cited the words are exactly in the testimony, and the pieces in between just provide additional support for those comments. I think you're questioning the missing 3 ellipses in 2 different quotes, and Sierra Club had the opportunity to look for these things just as you did, and filed an additional 23 pages of responsive testimony to these things, and hasn't done anything about it either. This is not something that's even relevant to this rate case. We're talking about future reliability concerns. We had very little time over a holiday weekend to do. So there's nothing intentional here in any way. We're not hiding the ball. The documents fully support the statements that are there that you have found with, I think, relatively minimal searching, Your Honor. So I don't think we've had done anything at all to misrepresent the documents or the concerns that we have with Sierra Club's testimony. And frankly, I take a little bit of offense to you questioning our integrity and saying we should be embarrassed about the way that we've represented documents to the commission. But
Really,
You're-
do you
Are
see
we on
what's
the
on the
record, Your Honor?
screen? Hang on, Attorney Proctor Brown. Do you see what's on the screen?
I do, Your Honor. I see
think
the
it's- no,
exact quotation in those documents, and there's no question that we represented them accurately.
I dispute that. I very much dispute that. And I'm close to just having you strike the whole thing if you want to pursue this further. I mean, I would expect an apology, if anything. You can't file documents with the commission with this sort of sloppy quotations. I'm relying on you to quote things accurately. At least tell me where they are. Give me the page number. Tell me that you skipped some lines. This is, a court would skewer you for this.
I disagree, Your Honor, but we're happy to file a revised version with the
I haven't
ellipses
said
and
you
the
can
pad
yet. I want to hear from other
specifications.
parties. Who wants to comment on this?
Your Honor, if Sierra Club may speak to this just briefly.
Yeah.
We don't consider these comments particularly, as Attorney Proctor Brown just conceded, we don't consider these comments particularly relevant to the issue here, which is specific reliability concerns with Weston. We agree that cherry picking a number of statements about generalized reliability concerns from the ample volume of documents put out by MISO is not speaking to the specific issue here, which is whether the costs associated with the Weston units are justified given the lack of planning that went into WPSC's current portfolio. However, we just want to note there's a little bit of irony here in that WPSC took the position that there was cherry picking going on with the commissioner's own comments, when of course the commissioners were the ones who made the comments, who will be evaluating them for what they're worth, only for them to do the same thing when it comes to MISO and other RTO officials, where there's the same concern that they may be given outdue influence because of their official position. So we, think that these quotations, however selectively picked, don't go to the issues in this case, which is the reliability of the Weston unit specifically. But we concur with your assessment of the misleading nature of the quotations.
Anyone else wish to comment?
I mean, Your Honor, I would just note that I'm not aware of any convention, legal, academic, journalistic, that would allow for a block quote to pull from different sources, let alone a convention that allows for stringing together sentences that are not next to each other with no ellipses. Ellipses are critical to the semantics of what's in a block quote.
Okay. Anyone else?
Yeah, if I can just briefly respond, we didn't take the position that the commission's comments were taken out of context. We were taking the position that they were introduced in this matter for the matter asserted, the truth of the matter asserted. So I would just say that Ms. Walk-Press is misrepresenting our position in the earlier statement. If we've made an error of not having ellipses, then we can add the ellipses, but that's the only error that I see here. Thank you, Your Honor.
Okay. Well, I disagree that I can leave these statements in the record. I think the way they were quoted should have been done in standard format so that parties would have been tuned to the exact nature of the quote, and citations should have been included. I know we are on tight deadlines, but this is prejudicial, and I'm going to have you strike these quotes from the Arndt testimony. If you disagree with me, you can appeal that decision. So striking these quotes and refile without them, please.
Thank you, Your Honor. I would just say, I think that definitely goes to your decision on whether Cub should include the quotes of the commissioners, but appreciate your quick decision.
Don't know if that's true, but I'll take it into advisement. Okay. So, do we have any other matters here that we have not discussed before we take our first witness?
Judge Newmark?
Mm-hmm. Yes.
This is Kurt Bain with Roundy's. As I was listening to the discussion, there was a couple references to emails that went out that sounded unfamiliar to me. So I checked with my co-counsel to see if she had received those emails, and after some digging, I realized that I'm not on sort of the main email list for a lot of the communications going back and forth between the attorneys.
Okay.
For example, there was several emails yesterday on the 19th that I didn't receive.
Okay.
So I apologize if I missed anything that I was supposed to respond to. But I would also ask the parties if they could add me back onto that email chain.
So let me ask, did you get the offered evidence list?
Don't believe so. There was a lot of I'm still kind of going through what I missed.
So this
and my co-counsel did receive them, but she hasn't really been working on this case very much.
Mm-hmm.
So I did notice that it was a little quiet, but hadn't really put
telltale sign.
Yeah.
Okay. Oh, let's go off the record for this. So I'm displaying your entry in the on the service list. That comes directly from my database, which is where how I create the emails that I send you guys. Is that incorrect? Did I type something wrong? Maybe I didn't get a bounce back from you.
Well, yeah, I'm just not on there at all. It's not an incorrect.
Oh wait, I'm sorry. Who's speaking?
This is Kurt Bain with Roundy's. Yeah, so when I look at the recipient list, no, that's correct right there.
Okay.
But you have my co-counsel Jody Cohn, and you have my witness Justin Bieber on there, but not me. Not you. I think I have received emails from you, but it was just sort of the general traffic of the last few days, and maybe I'm still kind of digging in to see what I missed, but
okay. So
yeah, and I don't have a witness in this case. I don't have any cross. I'll be more active next week.
Yeah,
but,
right.
Yeah. So no harm, no foul. But
well, I mean, you are a party, so if you did have cross, you have a right to do that. So, so when I send emails out, I start from scratch every time, and but I have a certain program that I can create these email addresses from the database. So if the database is correct, I'm going to get all the emails correctly. Now, there is a way that people can access that. It's a little complicated, but I would say that, yeah, that's why we go through this practice to make sure this list is accurate. And I guess I'm just disturbed that, yeah, you weren't getting those things, because we need to, and when people use email chains, that's of course going to be a risk that people are taking it. Someone's off the list. You keep repeating that problem.
Your Honor, this is Stephen Lee on behalf of Walmart.
Yes. Yeah,
to provide
we're off the record. We're off the record.
Okay. To provide some clarification, at least, the most recent mailing service list on ERF does not include Mr. Bain. And that may be why he was not included on certain service lists.
The last what? I didn't hear you.
The most recent mailing service list on the docket that is accessible does not include Mr. Bain.
Okay, okay, so I think it may be useful to review. So, so if you go into the case management system and put in the docket number, if you go to documents, I think it's documents, yes, okay. You can pick up the service list from my database. And this is just so convoluted, and apologize for that. It's not my fault, but this is the way we chose to present this. So on this document, if you export this active service list, you'll get an Excel spreadsheet with the current list emails. So I haven't had this problem happen before, so hopefully it hasn't happened before. It hasn't been brought to my attention. So unfortunately, that's unfortunate, but here so if you go through that process, you can get the updated list. There really is no update that gets pushed to you when changes are made to the list. So we just don't have the staff capacity, resources to do that every time. When I get a request, I'll update it. It goes into my database. It goes in, you could then pick that up from here. But so yeah, I apologize if there's been problems with that, but there is a way to get the most current list from our website if you are aware of that. So I would encourage, I would encourage people to do that, before rounds of testimony, you want to look and see if there's been a change filed to intervention, to a notice of appearance that's changing something. Then if to make sure that was adopted, you can go to this site and export the new list. But yeah, the mailing service list, that just gets, whenever we send something out using a list, it'll also issue that list onto IRF. But it doesn't just get updated by a matter of course. Just because an update's created, we don't put out a new list. So, although I think you should probably have been on that list for a long time. So, okay. All right. So I think we did have some requests. Are we done with comments, questions? Well, we still have a pending ruling on the commissioner quotation, and we're going to be talking to witness Singletary about the redacted exhibit.
Are you still off the record?
Yeah, we're off the record. And I just want to recap, and we'll have some testimony from witness Megna. That's all my comments. All right, so yeah, continue off the record. We had one witness request to go before noon, which was Alex Lindquist. So we could take, if there's no problems with that, we can take that commission staff witness first, and then continue in our standard order. Why don't we just take a 15-minute break right for now, and before we take witnesses, and we'll be back to pick up witness Lindquist. So
Your Honor.
Your Honor? No.
Yeah, go ahead. Who's first here?
Before we take a break, are we able to excuse witnesses for which there are no cross?
Oh yeah, let's do that. You're right. Let's do that first. So the list does indicate who had questions for certain witnesses. So has anything changed since the email round of those emails have gone out? Anyone have any additional questions for anybody?
Your Honor, CUP does not have cross for Ms. Bulkley.
Okay. No one has questions for Bulkley? That's a lot of testimony. Okay. All right. So
given I will note that it appears that we received 9 pieces of Sir, which has not been dealt with yet. We have not had an opportunity to even open those pieces of testimony,
Okay.
let alone read them.
Okay, so why don't we hold off with the applicant witnesses? That's a good point. They're probably not leaving anyway. So so it appears that there's no questions for Keim. Is that correct?
No. I'm sorry, Your Honor, if we could hold that one until after the break. There's some question here, whether we have some questions for Dr. Keim.
All right. Tetzloff, any questions? Belke or Beck? Yeah. Belke? Kell? Kenworthy? And Perry? Any questions? Bauer? Pollock? Adams? Field? You're making people very happy today. Ori? Jurek? Oh, they're probably going to appear anyway. Okay, McFerrin, Probst, any questions? Yeah, the staff will appear. Is that correct, Attorney White?
Yes, Your Honor. And I just confirmed with witness Lindquist, and it's fine to call him after the break. I just wanted to verify whether he wanted to verify by affidavit or quickly get that out of the way once we pick back up.
Okay. Well, why don't we just get him over with now if he's there?
All right. Anything else before I call witness Andrew Lindquist?
Well, we're off the record. Let me just check.
While we're doing the witnesses, it would be helpful to talk about applicants' witnesses too. I think we maybe started later in the list.
No, actually, because we haven't gotten the Sir rebuttal reviewed yet, I'm not going to excuse any of the of service witnesses yet.
Okay, there are witnesses on our list that did not file Sir, but that's fine.
Okay, so I don't have those documents in front of me. So who did not file Sir rebuttal?
Mr. Gerlikowski did not.
Okay, any questions for Gerlikowski?
Mr. O'Brien didn't.
Okay, let's just go through each one. Questions for Gerlikowski? So far, there's none. Yeah, nobody? Okay, who's next?
I believe Mr. Kurdecki did. Mr. Hawley did.
Oh, Hawley's got questions. Any questions for, you said Kurdecki?
He filed Sir.
Oh, he did. Okay.
Mr. Lambert filed Sir.
Who did not? Okay, who did not file Sir?
Right. Mr. O'Brien did not file Sir.
So any questions for O'Brien? No? All right. Who's next?
Mr. Pecorelli didn't file Sir.
Any questions for Pecorelli? No. Okay.
And I believe that is it, Your Honor.
Okay, so, all right.
And our witnesses, we would ask to be able to file by affidavit for those 3 that hopefully are excused.
Yeah, that's up to you. Right. So, right. As long as, right. I'll excuse them from being required to appear. And then you can choose whether you want to have them come up to verify or file an affidavit. So is that all the witnesses we think are not, that don't need cross? Tetzloff didn't read cross. All right, so let's get on the record. So we discussed witnesses that may be excused. They have the option of either taking the stand to verify their testimony or filing an affidavit, but we expect no cross-examination for these people. So first is applicant witnesses, Gerlikowski, O'Brien, Pecorelli. IUOE witness Tetzloff. Renew Wisconsin witnesses Becky and Kell. That'll look right on the transcript. Vote Solar's witness Kenworthy, Walmart's Perry, and Weeks, Bauer, and Pollock. All will have no questions for. So commission staff will take the stand to verify their testimony, whether or not there's questions. So let's move on quickly then to witness Lindquist. We're all set to go.
Thank you, Your Honor, and I appreciate accommodating this request. Commission staff would call witness Andrew Lindquist to the stand.
All right, I see you there. Raise your right hand. Do you swear or affirm to the truth, the whole truth, and nothing but the truth?
I do swear.
Okay, go ahead.
Thank you. Mr. Lindquist, in this proceeding, did you file or cause to be filed direct and serve rebuttal testimony?
Yes, I did.
And did you also file one exhibit in this matter?
Yes, I did.
Are the statements and representations in your direct, serve rebuttal, and exhibit true and correct to the best of your knowledge?
Yes, they are.
And do you have any additions or modifications to make to either your testimony or exhibit today?
No, not today. I will be refiling a correction to an exhibit, but nothing of substance today, no.
And that correction is the one noted in the offered evidence list?
Correct.
Thank you. With that, I don't have anything further. The witness is available for cross.
All right. Any questions for the witness? No? All right. Thanks very much. You're excused.
Thank you, Your Honor.
All right. So let's break until 11:45 and we'll start with applicant witnesses.
Hi. You know, hey, it was 1 second here.
Okay, so let's get back together here. I don't see our, oh, there you are. Gotta put a pin on you, Debbie. There we go. There you are. You're the person I need to make sure is there, if anybody. All right, so I think we're ready to begin with taking applicant witnesses. I do want to mention that we did receive, let's see, the 9 instances of certiorari rebuttal in writing. I think I got that email with those documents within the last hour or so. I have not had an opportunity to read it all. And I just wanted to ask if parties are prepared to for the presentation of these witnesses with that testimony offered in writing, or do they need more time to review?
Your Honor, if I may, this is Megan Walkspress for Sierra Club. We would move to strike the certiorari rebuttal testimony as procedurally improper. There's nothing in the facilitating matters order that contemplates such a filing. It was sent to parties less than an hour before the beginning of the hearing. There's no plausible way that either myself or my witness can meaningfully respond to what in our case amounts to 10 new pages of testimony. And it's simply improper for WPSC to try and get the last word in this way. It has elements of surprise and prejudice.
Okay, before we hear a response, any other parties wish to comment on this? No. Commission staff, anything? Okay, let's go ahead, Attorney Proctor Brown. Oh, wait, Evan, did you have something?
I was saying no. Motion
okay.
doesn't have a position.
Okay.
Honor.
Go ahead. I'm
Thank
sorry.
you, Your Honor.
Your Honor, we share CUP shares Sierra Club's position on this matter. We have had an opportunity to look at one of the 9 pieces of testimony, and we have not had an opportunity to even analyze that one piece sufficiently, let alone read and digest and analyze 8 additional pieces of testimony.
Okay, anyone else? Okay, let's hear a response if there's one.
Your Honor, this is a regular part of practice before the commission, and it's a time-saving effort for all of the parties to put in pre-filed served testimony. I think I've been involved in something on the order of 30 commission proceedings at this point in the last 10 years, and most of those do have elements of certiorari or live direct testimony. So in lieu of the live direct testimony that every witness is allowed to do during this hearing, we pre-filed that testimony and provided to the parties, just as we have in multiple other cases, and there's really no surprise or prejudice. All of this is responsive to the voluminous rebuttal that was put in by the other parties.
Okay, so I don't disagree with either side. So there is a bulk in terms of volume, just in terms of the number of witnesses were being presented, certiorari in writing. Does seem slightly overwhelming to read and digest. However, I think we mentioned before that the practice represents basically the witness's opportunity to respond to the last filed round or anything that they may have heard at the hearing, which is part of our practice. That opportunity exists. And I guess what's contemplated in that is that testimony on the stand is done hopefully succinctly, and it's done in a timely manner. Given the complexity of these cases and the number of issues, it does facilitate the record to have these documents come in writing, so that we're so that the evidence is presented accurately and hopefully concisely. But I think the basic cure here will be to provide some more time for review. So let's and I think there's an advantage to interveners in that sense, in that they're not trying to hear and digest the testimony live, which may be even more difficult to do than to review the written filing. So it is a matter of convenience that we're doing it in writing, and it would mean that we should take a longer break and have parties review this so that we know that there's been no prejudice involved with this process here. So,
Your Honor, if I may ask a clarifying question,
Sure.
typically witnesses are not permitted to have communication with counsel or rely on documents on the stand. One of the differences about these kinds of pre-filed testimonies versus live testimony is that they're essentially being given an additional opportunity to vet everything they say with counsel and phrase it. Will you be allowing other witnesses to have documents prepared in consultation with counsel while being subjected to cross-examination on the stand? Or I'm just raising a concern that these are materially different than something like live testimony.
Okay. So,
Your Honor, if I can just briefly respond to that, I
sure, go ahead.
appreciate it. So I think, Your Honor, you correctly recognize that this is actually beneficial to the other parties because they've had the testimony for now about 3 hours. It's fairly regular. I've seen it in many proceedings where parties will read in their testimony just as these witnesses are prepared to do. The difference between relying on some sort of extraneous note and the prepared testimony is significant, right? So I think it's very common for a witness in these proceedings to have their own testimony in front of them, including pieces of sur or prepared remarks at the hearing. That is different than some sort of notes or attorney-client privilege material that Ms. Walks presses is, I think, attempting to refer to.
Yeah, I guess this is also slightly different than cross. So this is presenting the statement of more of like a supplemental direct, or sort of like we have phrased it, sur rebuttal. I think providing an opportunity to review the documents more fully is going to provide that parties the chance to respond correctly. Not sure if I can maybe get a clarification from you, Attorney Watchpress, about exactly what your concern is on. Is it that your witnesses' statements will be subject to some other sort of standard than the written sur?
No, Your Honor. I'm just pointing out that there is a difference between offering live direct testimony on the stand and being able to compose a document in advance with the opportunity to consult with others, with the ability to pull in additional resources. I think, skimming it quickly, there's some kind of visual diagram in one of the sur rebuttal filed for our two relevant witnesses today. I'm just pointing to the fact that this is not just speeding along answering questions on the stand. This is a different type of response. And if the cure is to give us more time, I understand that. I just wanted to point out those distinctions.
Mm-hmm. Okay. Well, there really shouldn't be diagrams or other. Can you point to that exactly? That's something that I've in the past kind of made as a.
Yes. So on page 5 of the sur rebuttal testimony of WPSC Arendt, there are more MISO documents from the, I'm just reading now, as shown in this slide from MISO's market committee, these wind droughts lasted 11 hours and 8 hours. There's no citation here. There's no place where we can go and cross-check it. And as you say, although we've had 3 hours, 2 of those have been in this hearing. So just this ability to introduce visual evidence from external sources in a pre-filed document is not the sort of thing one would typically expect in supplemental direct testimony. And so I guess I want to push back at the suggestion that this is just facilitating what would otherwise be a laborious process of answering questions on the record.
Your Honor, can I just briefly respond to that? Because I
Sure,
think it's
yeah.
a statement of procedure. Expert witnesses rely on exhibits in direct testimony all the time, right? Like I'm not sure what Ms. Walk's press is kind of getting at there. The pre-filed testimony as a whole is replacing direct testimony that's live, which could have PowerPoints, which could have diagrams, which could have models, right? Like there's no distinction between having a slide that is referenced, and we can provide an additional citation if it's necessary, in a pre-filed piece of testimony and bringing it up on the screen live at the hearing.
Well, an additional exhibit would need to be shared with parties 24 hours in advance because we're on Zoom. That's part of our standard. So that was procedural distinction, but I think at this point I'm going to let parties review, and we can give you an hour to review the testimony, and we'll get back at 1 and see if everyone is on board. I think that should be plenty of time to review the testimony and respond when the witnesses take the stand. So let's go into recess until then.
Thank you, Your Honor.
You're on mute.
Because I asked all the questions that I thought would get a lot of negative response. So I did that on mute so I could just move on. Well, I was going to say, buckle up, everyone, because now we're here for the rest of the day. First thing I think is
On or off?
we're off. Yeah.
Okay.
Yeah, I'll tell you. Yeah.
Okay.
First of all, I think we cured objections to the SRSA rebuttal by providing this hour to review. Any other? Do we need to readdress that, or are we good to proceed?
I just had one question, Your Honor.
Yes, go ahead. We're off the record.
Okay, I don't know, maybe this should be on the record.
Okay, yeah, let's get back up.
Sorry.
So, okay, we're reviewing the SRSA rebuttal after an hour break, and I'm just polling the parties if they have any additional comments to make. Go ahead, Attorney Coben-Ferris.
So, I was just trying to square SRSA, pre-filed SRSA written testimony with the facilitating matters order, which, says that the written testimony should be produced according to the schedule established by the order. And then, there's direct rebuttal and SIR rebuttal in the order, but there is no SIR.
Yeah, I thought we kind of addressed at the beginning, but
I think.
So there, yeah, go ahead. Anything else?
I think that Attorney Proctor Brown's argument was that this is always how it's done, but I thought perhaps this was addressed in recent updates to your facilitating matters order, as intending not to.
Well, the way it's been phrased in terms of the hearing practice, the process during the hearing is witnesses have the opportunity to present live testimony, responding to the last filed statements and statements made by witnesses appearing at the hearing before that witness at issue takes the stand. So you have the opportunity to add to your testimony in response to what's happened between SIR rebuttal and the time you get on the stand. And that's in the way it's written is it's live testimony at the hearing. We have made in the past many times the accommodation that it be filed in writing so that we can proceed quickly and efficiently with the process. And if the testimony is really mimicking what would be said on the record, I mean, basically what we'd end up doing is if I say you can't file it, then then the witness ends up reading what's in writing and reads the statement that's written into the record, and that takes way more time than even this process today. So, it is a practical adjustment to that practice that we have. It's just saying instead of presenting your SIR rebuttal on the stand, you file it, and if people have a chance to review it and can accept it in writing, we'll just put it in the record as if read. If there's a problem with any particular, I reviewed those documents. I think many of them meet sort of that expectation where they're quickly addressing a particular item of SIR rebuttal and providing a response. And do you have a particular, are you talking theoretically, or do you have a particular problem with any one filing that you want to address?
So, Attorney Waxpress mentioned the figures on page 5 of Arendt's SIR, and I have, we have not had an opportunity to determine, I don't see a site there. And I would like to, understand where that text came from and, better understand, where that, just verify that.
Mm-hmm.
And I think there are a few other places where there are citations that, given the discussion earlier today, we do feel a need to go and double check, but we don't have time to cite check the applicant's testimony,
Mm-hmm.
at the moment.
Okay.
Your Honor, if you don't mind, just a brief response.
Let me get any other comments, others on this.
Sounds good, Your Honor.
But so aren't the page 5, the at least Cub takes issue with, is that correct?
Your Honor, Sierra Club also takes issue with it, but we'd actually like to be able to cross the witness on it before we state a final position on its admissibility.
Well, okay. If we're going to be crossing on it, then I think we're going to put it in the record. So let's.
Well, Your Honor, we think we were actually able to find it, and we think there's a similar issue to the one you raised earlier with misrepresentation of sources. And so while we object to its submission altogether, now that it's been presented, we think it goes to the witness's credibility.
Well, that's okay. Well, anyway. So in terms of Cub, is there any particular other places that you have a complaint about? We just need to do this in an orderly fashion. So I just want to know what we're dealing with. Are there some filings that people are comfortable with that we can admit, or are there some filings that people have objections with?
So another, just a typographical concern that Mr. Stasik's SRSA rebuttal does not have a footer and page numbers.
Yeah, we'll get to that. I'll deal with to the extent I found it, I'll mention the filing problems, but in terms of the substance and objections to the substance of it, anything else on from Cub?
Not that we're aware of.
Okay, so it's basically the art. Page 5, I believe. Okay. Let's do this.
Did you want a response now, Your Honor? I'm sorry.
No, let me collect them all. Collect them all, and then we'll respond. So I don't think we have the IUOE connected to us. How about Renew? Any issues with this SRSA rebuttal?
None that I'm going to raise at this hearing, Your Honor.
Okay, Sierra Club, I think you have a few.
Yeah, we continue to feel that it's improper to admit, but we would, given the opportunity, like to cross-examine the full document from which the diagram is drawn.
Okay, so talking about the aren't page 5, any other?
We have other cross-examination questions too, if they're admitted provisionally, but we continue to maintain that admission in contravention of the facilitating matters order is improper.
Okay, and what about any other filing, any other SRSA rebuttal?
This would go for Mr. Hawley's as well. Those are the only two that are relevant to our testimony. Mr. Hawley's does not appear, again, given the shortness of time to review it, appear to have the same issue with bringing in external matters. But the timing, again, we believe is improper.
Okay, so just generally speaking. Okay, let's go to Vote Solar. Any issues with this?
None, no objection. I think we'll have some, so now that we've reviewed it, some cross of Mr. Nelson and maybe Lambert. But no objection.
Okay, and we'll go through if there's anyone we can excuse after we get through this part, but yeah, thanks for mentioning that. Walmart, any objections?
No objections, Your Honor, but we do share the concern with a lack of citation, particularly in Aaron's testimony that has been discussed and highlighted by other parties.
Okay. Weig?
Good afternoon, Your Honor. On the substance, no objections as to the procedure. I guess abstain without being as familiar with how it was served. Don't take a position at the moment.
Okay, I mean just timing of service? Is that?
I'm sorry. No, I'm just saying that the material is on issues that are not, relevant to the issues that we are addressing, and so we have no concerns at all as far as the substance of the material coming in, but as far as whether or not it was done properly, or we would object if it was on issues that we were involved in. I just have to say I don't have an opinion on that at this time.
All right. And commission staff, anything to add?
No position.
Okay, so yeah, let's hear from pub service. I guess really what's at issue is I think we've covered generally speaking the practice, but if you want to add to that, you can, and then look at the aren't page 5. I think that's a particular crux of contention here. So go ahead, Attorney Proctor Brown.
Yeah, I think if you put that reference into Google, it's the second document that comes up. We'd be happy to provide the full presentation to the parties, but there's no prejudice here. Mr. Arndt could have read this part in and brought up a slide during the hearing, just like any other witness. Happens very regularly in these proceedings. And I personally have handed out copies of SIR right before a witness goes on the stand when these hearings were live. So what has happened now is we've given all the parties 4 hours when they might have had 3 minutes to review the testimony in advance. So there should be no question that there was no prejudice here. We're happy to add an errata to have a pin site to this document, but that's not what he would do on the stand either, right? He would reference what it is. He would pull up the slide, and this is intended to mimic the live testimony, not legal briefing. So that's what I would say. If there's some question about cross, it should be admitted. This isn't a voir dire process on witnesses. If it were, I don't think Ms. Metz would qualify as an expert in any court in the country. So that's what I would say.
Okay, we can hold that opinion to yourself. What I would do then is I think you need to be able to provide that link to the full document to everyone. If you could email that to everyone. And I guess there may be issue as to whether it's being presented correctly. That's something that has to be dealt with on cross at this point. And I think I don't know if we're going to take Arndt first as alphabetically, but let's get that document. And I suppose okay, that's probably good enough. So let's just go off the record, and I'll check for that email.
Your Honor, while you're off the record, we would ask, I think most of the parties overlap today and next Tuesday. We didn't think we did anything exotic here. Kind of surprised by interveners that have been in these proceedings for decades, objecting to something that we've done regularly, and those parties I think have done as well. So if there's some need for these witnesses to testify live during the hearing on Tuesday, happy to do it. But I think the time-saving nature of it and the increased ability for parties to review and respond to testimony are both benefits of pre-filing this kind of testimony.
Yeah, well, this has been something we've done in the past. I guess my touchstone for this is that if I would be at the hearing and I would have a witness sit down and provide this testimony, it should be short and concise statement of here's what prior witness said, and here's my response. I think that's been done in many of these filings. I think when the problem comes up when there's much more information being provided, and I think I think there may be issues with putting in tables and documents. It's yes, we could accept that on the stand, I suppose, but it does create. Then we just pay more scrutiny to it, and it takes longer. So I don't think we're really changing things here. It's just a matter of maybe just getting everyone on board and on the same page here. But and I've had your witnesses read your testimony in the record instead of accepting the written testimony. That's another, I mean, I've done that before when it seemed like it was too much to accept in bulk at once in writing. I don't really see that as being very effective because then we're trying to follow, we don't have the benefit of the written document. So the issue really tends to be a matter of proportion. Is the source rebuttal proportionate to the surrebuttal? I don't, no one's claimed that you're adding things in that shouldn't be rebuttal, but to the extent that it can be concise and presented in a short and sweet statement, it may just be conducive to removing this delay and problem that we're facing. So, I mean, just.
Your Honor, and I don't want to hide the ball, right? Like, I think it's pretty clear to people that have read both cases that there are pieces of testimony that we're discussing right now, Arndt and Holly, that will not appear on Tuesday, but almost certainly the other pieces will, right? Like, that's just the nature of how these cases have come together.
Yes.
We can withhold them and read them into the record on Tuesday, or we can file them on, Tuesday or Monday morning. It's really kind of a binary choice to us.
Right.
I think the testimony is going to come in the same way, right?
Yeah, I think file what you can, and we will take it from there. I think you're not going to be dealing with the Weston issue, so in the next case, so most of this will drop away.
Thank you, Honor.
Yeah. So I don't know if I'm looking at the right place. I still haven't found the link to that document.
It would have come from Attorney Zank, I believe, including the attachment, and then the link should have been in the email.
Anyone else?
I don't know.
Yeah.
Every once in a while, our firewall slows things down. So sorry for that.
Okay. Well, can we take another witness and then wait and see if that appears?
Yeah, we weren't intending to take Arndt next in any event. I think the question we had is whether Mr. Kurducky had cross. I didn't hear any objection to his sir, which I think is the only reason he's still here.
We can pull this list here now, see if there's anyone left. So we still have questions for these witnesses. So is it just Kurducky that or Lambert had?
Kurducky, Nelson, Lambert all had sir, and then didn't have any questions.
Right. Okay.
In the pre-hearing notice. All
right. So let's get on the record, and we'll note that we've provided some time here for interveners and staff to review the sir rebuttal from the applicants. So we have 3 witnesses that filed sir, which originally parties indicated they had no cross for. So I'm wondering if that state of affairs is the same now, and if these witnesses could be excused from the hearing pending verification of their testimony. So first one was Kurducky. Are there any questions now for Kurducky? No, okay, how about Lambert?
Your Honor, I may. And to be clear, that Lambert responds to Mr. Kenworthy by pointing back to and quoting testimony from Mr. Nelson. So I'm not sure who to direct these questions to. So I think it's Mr. Nelson, but I don't want to have him, I don't want to waive and then have him point to Mr. Lambert after my.
Okay, well, let's go off the record. Can you provide any direction there, Attorney?
So, yeah, Mr. Lambert, sir, on page 2 at the top.
Your Honor, do you mind could you pull it up, or I can go and search for it?
If I can find where I am here.
I'll search for it too.
Oh, here I got it. So we want Lambert.
Lambert, sir.
Look at that. And we're talking about what page?
Page 2 at the top.
Oh, yeah.
So you want to ask about the quoted statement, Dave?
Well, yeah, I want to ask about the basis for Mr. Nelson's statement, but I'm not sure why Mr. Lambert, instead of Mr. Nelson, responded here by pointing back to it. So I don't know if that's maybe because Mr. Lambert did the analysis in the first place, the scaling here that we're talking about.
Yeah, why don't we kind of move on, and we'll ask that question, and then you can cross-examine one or both of them after we're able to. Okay. They're sitting here. I just don't think we.
So we'll keep them both. We'll keep them both in. Okay. So Lambert and Nelson will stay, just so Korducky can be excused. And we already had these two. Lukowski was excused too, right?
Yeah, Mr. Gerlikowski was excused, Your Honor, and so I believe O'Brien, Pecorelli, Korducky are the excused witnesses right now.
Okay. Yeah, I don't know what happened to my notes here. Okay. All right. So I think we're ready to go. So let's get on the record and just say that in addition to the prior witnesses that were excused, witness Korducky is also excused. There's no cross-examination for that witness. It'll be up to applicant to decide how they want to verify that testimony. Okay, are we ready to proceed with our first witness?
We would call Ms. Ann Bulkley because we'd have some corrections, but I'm just wondering, we have an individual who would want to watch if Ms. Bulkley is going to be cross-examined, so we'll just ask if the parties have cross-examination for Ms. Bulkley.
Wait up, I'm sorry. What's being asked?
We're just wondering if anybody had cross for her, because there was an individual within the company I wanted to watch, but if that's too burdensome, it's not a big deal.
I just don't understand wanted to watch. I'm not sure what you mean by that.
Never. It's okay, Your Honor. I think a mistranslation on a note I was handed, but thank you.
Okay. All right. Be careful with those notes. Okay. So look, and there's questions from Cub, right? Still, yeah.
In fact, we have no question.
Oh, okay. Yeah, that's right. Because you were going to look at that. Okay. Okay. So let's.
The only reason we would call Ms. Bulkley is to make a couple of corrections.
I'm sorry, who's speaking?
Brad Jackson.
I don't see a box. Okay. I see you now.
Okay, there we go. All right, so go ahead. I don't see her yet. There we go. All right, there we are. Old familiar face. Let's swear you in. Raise your right hand. Do you swear or affirm? Tell the truth, the whole truth, nothing but the truth?
I do.
All right. You may just want to get closer to the mic a little bit. It's a little low on my end.
Okay, is that better?
Yeah, that's better for me. Okay, hopefully that helps everyone. All right, go ahead with this witness.
Ms. Bulkley, would you please state your name for the record?
It's Ann Bulkley, spelled Bulkley.
And by whom are you employed?
The Brattle Group.
Ms. Bulkley, in connection with this proceeding, did you prepare or have prepared at your direction pre-filed written direct rebuttal, surrebuttal, and surrebuttal testimony?
Yes, I did.
And in connection with that testimony, did you also prepare or have prepared at your direction 28 exhibits.
Yes, I believe that's the correct number.
I think there's 29.
29, I'm sorry.
Yeah, that's okay,
There was
but my
one-
list is not accurate right now.
Okay, 29.
Yes, that's correct.
Thank you. Ms. Bulkley, did you have any corrections to any of your pre-filed materials?
I do have two corrections. The first correction is in my rebuttal testimony on page 16, footnote 14. The page number is incorrect in that footnote. Instead of page 13, it should be page 17.
All right.
The second correction that I have is in the footer of my Sir rebuttal testimony. I have inadvertently referred to it as Sir rebuttal testimony. And so that correction should be made to reflect on all pages Sir rebuttal.
Thank you. Any other corrections?
No.
All right. I understand there's no cross, so I'd ask that Ms. Bulkley be excused.
All right, so yeah, let me make sure. I don't think we asked that one before. So any questions for witness Bulkley? No? Okay, I did have one more filing note here. This page 12, we just need to put the non-record evidence disclaimers on those footnotes, please.
All right.
So we'll admit these documents on the record, including 29, which I don't have on my list. I do now. Any objections to that? All right, thanks. Now those documents are in the record and this witness is excused.
Thank you. Thank you, Anna.
Thank you, Your Honor.
All right. Move on to our next witness. Next witness.
Thank you, Your Honor. Applicant would call Mr. Joseph Zagantz.
I'm sorry, what was the last name?
Zagantz, Z-G-O-N-C.
Gotcha. Thank you.
Where's my screen? There we go. All right, I see you there. Raise your right hand. You swear or affirm, tell the truth, the whole truth, nothing but the truth.
I do.
All right, go ahead.
Mr. Zagantz, did you prepare and file direct rebuttal, surrebuttal, and surrebuttal testimony in this proceeding?
Yes.
And did you also prepare and file 6 exhibits?
Yes.
And if I asked you the questions contained in your pre-filed testimony today, would your answers be the same?
Yes.
And to the best of your knowledge, are the 6 exhibits that you filed subject to the corrections that we've discussed off the record and in the authored evidence list, true and correct to the best of your knowledge?
Yes.
Thank you, Mr. Zagantz. Mr. Zagantz is available for cross-examination.
Okay, just wanted to note, since you did mention 6 exhibits, those last 2 are going to be withheld from the record. They're just citations to current commission orders that can be cited using the PSC reference number. If that's wrong, let me know.
Your Honor, I think, and I think that's actually maybe if we want to go off the record, we can handle it, but I don't think that's quite right.
Oh, okay, yeah, no, sure. Why don't we go off the record if it's technical? Okay. Oh, remove. Oh, that's weird. I think I'm thinking of the other case. Well, I might be thinking of the Webco case. There was a couple of exhibits. So it's no 5 and 6.
Yeah, we can
Cite
pull
to
them up,
orders.
but I believe that they're the force majeure notices.
Oh,
And then 6 is actually a prepared exhibit with an analysis of the long-term debt issuances.
oh.
So
Okay. Huh.
I actually didn't see that comment in the offered evidence list this morning, so apologies for not bringing it up. But yeah, the earlier list, we were a little bit confused because none of his exhibits are decisions. They're the notices and then a prepared schedule.
Okay, I don't know where I picked that up from.
And actually, I think maybe it's 4. One of those two is one that we talked about this morning that needed the confidential version filed on.
Yes, yeah, that's the force majeure. Yeah, that one I sure. Oh, that's 5. Force majeure. Or is another force majeure notice. Okay, so those are the 2. Okay.
And then 6 is is a schedule.
Yeah. Something happened with my computer. Save something, right? Okay. Thanks for catching that. Okay, so where are we at? So we have documents. So let's get on the record so we can receive the documents as indicated on the offered evidence list with the corrections we've discussed and are on the offered evidence list as well. The witness is available for cross. I think there might be a question or 2.
This is Evan White's from the commission. I'll defer if anyone else wanted to go first, but we do have some limited cross for Mr. Zagans.
Yeah, I think you're up. Yep, go ahead.
All right. And it might be helpful to pull up Mr. Zagans, his sir rebuttal testimony, page 10.
Okay.
And just for the record, Mr. Zagans does have copies of his testimony in front of him.
I was just going to ask that because I can't see the witness, so.
So the witness should be under the attorney. I'm going to change that to witness. Is that usually what we'll use for the witness here?
There we go. I didn't promise to be perfect about that, Your Honor, because
no, that's fine. I don't worry about it. We'll just call that box witness, and then at least we'll know that much. So it was a page 10.
Page 10.
Right.
Oh, no, just leave it alone now. Oh.
Okay. Everyone good?
I think so.
All right.
Sorry, we're operating at cross purposes on renaming the box for a second there, Your Honor.
Okay, no worries.
Okay.
I'm looking at page 10 of my sir rebuttal now.
Thank you, Mr. Zagans. So my question is starting at line 12, you mentioned that in response to the force majeure costs, the applicant had 2 choices. And then on line 13, you list a second choice that you state is litigating the force majeure notices. I was just wondering if you could expound upon that a little bit more for the record as to what that means or what that choice or option is.
So that would be to litigate with the contractor providing the service against the increased cost or the change.
And when you say litigation, does that imply that there's some sort of clause in the contract that you would be litigating? Or I'm just trying to understand what that litigation would entail or how that is an option for responding to these force majeure notices.
I'm not familiar enough with the contract to know the specifics on that.
Is there a witness that would know that information?
Well, Evan, we can have a discussion off the record if we'd like, but I would say that is a legal question that would ordinarily go to the in-house legal department here. I believe we've been using the term litigate, and you can ask Mr. Zagans about this in a colloquial sense of additional legal proceedings between the developer and WPSC.
Okay, well, it's in the testimony, so I'm just trying to flesh out for the record exactly what that option was. So let me ask a different question. As it relates to that second option that you present in your sir rebuttal, were there considerations by the applicant about that choice as to whether or not to pursue it?
I think I do have to state an objection that calls for attorney-client privileged materials.
Okay. Mr. Zagans, do you know whether that option was pursued?
I do not know whether the option was pursued.
So I guess that begs the question, what is the basis for in your cert rebuttal stating that it was an option for the applicant to consider?
So I would have stated that they accept it, move on in some fashion, or go through some legal proceeding to come to a resolution.
And you don't know any more details about that second option that you can provide for the record?
I do not.
Okay. I don't have any further questions.
All right, thanks. Anyone else with questions? Cross questions? No, how about any redirect?
No redirect, Your Honor.
All right, great. Thanks very much. You're excused.
Thank you.
Just for the party's purposes, we're going to go to Mr. Lambert next, and I believe that will permit Mr. Bender's questions to be asked to both individuals. We just need a moment to switch out the chairs.
Okay. And off the record, I did get the
Are you off or you're talking?
Off the record, yeah. I got the market committee email from Attorney Zenk. I hope everyone else has received it. A MISO operations report.
And my apologies, I'm not reading the notes right today, I guess. We're planning to do Mr. Megna next, as he's closest, but just for Dave, Attorney Bender, we do have both witnesses. We'll put them both up, and then you can just ask the questions directly.
Was it? So who's up next? I guess I'm confused now. Is it Lambert or Megna?
Our apologies, Your Honor. Dave Megna is up next.
Okay, that's all right.
Sorry about that.
No, I'm glad we're getting people on the stand either way. Get someone in here. All right, so we have a witness, Megna. I see you there. Let me swear you in. Raise your right hand. You swear or affirm, tell the truth, the whole truth, and nothing but the truth.
Thank you.
All right, great.
Okay, good afternoon, Mr. Megna. For purposes of this proceeding, did you prepare or cause to be prepared rebuttal, surrebuttal, and surrebuttal testimony?
Yes, I did.
And Your Honor, I know we handled some errata that we filed, I believe, yesterday, as well as your errata in your offered evidence list. Subject to those corrections, would your answers be the same today as they are in your testimony?
Yes.
You also submitted one exhibit, correct?
Correct.
Is that exhibit true and correct to the best of your knowledge?
Yes.
And then I think that's it, Your Honor, for Mr. Megna. I know you had some questions for him, so maybe before we go to cross-examination, I mean, it's up to you, but if you want to address your questions that you had.
Okay, if the witness is prepared to speak to that, I can just accept that statement unless you want to go through my particular questions. Either way, just those questions were to give kind of an idea of where I was headed, but we could just pursue those if necessary.
Yeah, I think the way we did this, Your Honor, is we just Mr. Megna is just going to respond to each question individually. We used your questions as kind of just a Q&A sort of format. So if that's okay with you, we can just do it that way. If you want me to ask the questions, or if you want to ask him your questions.
No, I can ask. No worries there. Okay, witness Megna. Good afternoon. This is Michael Newmark, the administrative law judge for the PSC. Probably heard me talk way too much already today. So I just had a couple of questions, and really the purpose of this is, well, I think all of you know these issues very well when it comes to forestry management. I don't think the record reflects some of this background, and I think it might be useful in order to process some of the more specific evidence that's been presented for the commission to decide the issues surrounding forestry management in this case. So let me go ahead with these questions. I provided these earlier on the offered evidence list. And I begin with the first one. So under what conditions is Pub Service responsible for trimming trees?
All right. Anytime that a tree becomes a hazard to our distribution facilities or potential hazard, which is typically when tree growth becomes close to or within 10 feet of our primary lines, we're required to trim.
Okay. And how about removing trees? Under what conditions is Pub Service responsible for removing trees?
And like other utilities, WPSC has the obligation to remove hazard or potential hazards to our distribution system. For example, if we had a diseased, weak, or leaning tree that poses a threat to the electric distribution system, we would remove that. Or if it causes safety issues or power outages, we would remove it.
Okay. How is Pub Service's responsibility for tree trimming directed by the property lines or roadway near which the tree resides?
Typically, when we're looking at private property lines, road right of way, we're dealing with the customer and municipalities to gain permission to talk with them about removal of trees or trimming those trees.
Okay. So removal or trimming. Okay. So let's maybe blend some of these questions now. So who is, when it comes to the cost of trimming a tree, and based on a property line, the tree is owned by another entity like a landowner or a municipality. How is that cost shared at all?
No.
It's completely Wisconsin Public Services cost. Is that?
That is correct.
Okay. And how does that relate to the right of way at all? Does it have to be, the tree doesn't need to be in the right of way, or is there any relationship to the right of way and Wisconsin Public Services financial responsibility for handling the tree?
No, it'd be when it's in close proximity or when it's in proximity to the electric distribution system, we're responsible to trim it. And mainly because under a OSHA regulation, only qualified personnel, either qualified contractors that trim trees or qualified personnel for WPSC are allowed to work within 10 feet of those energized electric lines. So we will safety zone a tree to make it safe for others to take down or trim, but we are the only ones that can work near or around those lines.
Okay, so just to be clear, if a Pub Service is going to make a tree safe for further trimming or removal by somebody else, if necessary?
That's correct. And that, again, that is a cost that we bear.
Okay, so making the tree safe is the cost of Pub Services, and that's Pub Services responsibility.
Correct. We will take it to a point where a private contractor can safely remove the tree or trim it.
And then who would pay that private contractor?
The homeowner or the municipality.
Okay, and so just to be clear, the costs that have been estimated by the company in this case is limited to making the trees safe clearing that safety zone. Is that correct?
For those circumstances, yes.
Okay, and then in addition, there's other situations where the company needs to remove the tree completely.
Yes.
Yes, and that cost is reflected in the estimates you provided.
Correct.
Okay. Is there any way to tell how that's broken down in the cost estimates that you've provided?
All of for what we've asked, our program is what we're looking at covering the costs of.
Okay. But have you predicted in those estimates the number of trees that need to be safety zoned versus the number of trees that need to be removed or trimmed to a greater extent?
Yes, and that in my testimony, you'll see that was also a cost that's rising because of the emerald ash borer. So that, yes, that's in there.
Okay, so all right. So then in terms of emerald ash borer, are those trees that the company needs to remove completely, or can they still safety zone? Can you just safety zone those trees? Well, which one?
Yes, we typically are safety zoning those trees for private contractors, or municipalities. And depending on the proximity to our distribution lines, we may remove them completely.
Okay. Would you say what do you say the proportion would be between complete removal versus safety zoning and emerald ash borer that's failing, I guess you use the term?
That's hard to say because I mean every tree is a little bit different. We know what we've spent on safety zoning so far at this point. We expect that to increase over the years with the emerald ash borer going further into our territory.
Okay, but you expect that also to increase in terms of removal?
Or safety zoning, yeah.
All right, well, that's great. I'm glad you could provide that background. It helps me understand this a little bit more. I don't know if I know there were certain terms that were used in the data request response and it's now in testimony. I'm just curious, just in terms of that safety zoning versus removal, is there just something we should be looking at in order to just pinpoint the forecasted costs in terms of one versus the other? You mentioned that there was a distinction that's included in the estimates. Is there any way we could just give us a direction as to how to find that in the record?
I'm not sure I understand the question.
Okay, well, so I know the cost would be different between safety zoning a tree and removing it. Is that an accurate assumption?
That's correct.
Okay, so and then you said that the estimates for doing either are in the forecasts that you've provided. So I guess I'm just making sure that the record does distinguish between those two costs and what your estimates are for either one.
Yes, on page 7 of my rebuttal, it talks about where we have seen the cost to safety zone double from 320,000 to 630,000 in 2023 and 2024.
Okay, and then in terms of the removal?
You know, from a standpoint of removals, we are more than likely going to make it safe, make sure that it does not impact our electric line. And so we may top that tree. We may not completely take it all the way down to the ground. we'll make it so that it doesn't impact our distribution system.
Okay,
And
but
as
there's
part
no,
of our normal cycle trimming.
okay,
Sorry, I didn't hear what you said, sir, but there's no,
that was me. You can ignore that part. You said it was part of your normal cycle trimming? So,
Right,
okay.
correct.
Yeah, I interrupted, so I'm sorry. So, yeah, I guess, but there's, okay, so it doesn't seem like we can delineate the estimates between removal and safety zoning in terms of the forecast that you presented. That's all I'm trying to make sure that if the commissioner asks me, well, how much is removal going to be versus safety zoning? I can't say, well, if you look on page, line E7, it says in 2025, there's going to be so much safety zoning. And on E8, it's so much is going to be removal. Doesn't get that detailed in terms of the estimates, does it?
No, and again,
that's fine.
Removal would be the last option.
Okay.
If it's going to pose a danger to our electric distribution system, then we would remove it. Otherwise, we're trimming and making it so it doesn't impact our electric line.
That's fine. I just wanted to check, make sure we have everything. All right, great. I think that's excellent. I appreciate your help with that, assisting me to understand. Any other questions, cross questions to follow up with that? No, any redirect?
No, Your Honor.
All right, great. Thanks very much. You're excused. All right. Who's next? Do we have a new witness?
I'm sorry, who's the attorney that just sat down?
Hi there, this is Lauren Zank, last name is Z-E-N-K.
Thank you.
Yes, and applicant is calling Brian Lambert. We are just getting him.
Okay, great, thanks. Is it in some person that's in the room, or do we need to admit them to they're in the room?
Oh, Cameron, yes.
All right, there you are. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
I do.
All right, go ahead.
Thank you, Your Honor. Mr. Lambert, can you please state your name for the record?
Brian Lambert.
Mr. Lambert, did you submit written rebuttal, and sir rebuttal testimony in this case?
Yes.
Is everything in your testimony truthful and accurate to the best of your knowledge?
Yes.
If I asked you the same questions in your written testimony, would your answers be the same today?
Yes.
Okay. This witness is available for cross-examination.
Okay, yep, so we can accept all those documents for the record. I don't think there's any corrections, so appreciate that. Okay, do we have cross for this witness?
I'll have one, but I don't want to step in front of anybody else.
No, I'm not seeing anyone clamoring for questions, so go ahead.
Good afternoon, Mr. Lambert. David Bender for Vote Solar. Do you have your sir rebuttal in front of you? Your sir rebuttal.
Yes, I do.
I'm sorry, which rebuttal was it?
Two sirs, sir rebuttal.
Okay.
I do.
On the top of page 2, you are responding to Mr. Kenworthy.
Yep.
His testimony about the lack of explanation for choosing 3,000 as a subscription limit for the BYOD. Do you see that?
I do.
And then your response points to and quotes from Mr. Nelson's direct testimony.
Yes.
Okay. Do you know who did the scaling from the MGE program to reach the 3,000 subscription limit proposal?
I don't for sure, but I can discuss it a little bit to the best of my recollection.
Do you know why you're responding, pointing to Mr. Nelson's testimony instead of having Mr. Nelson respond on this point?
I was advising, as this is would be a new offering for our company, I was advising the preparation of a lot of these documents coming through, in working through this as a process. I think I ended up probably in the best position to talk about where the number came from.
Okay. Where did the number come from?
Like I said, I don't have exact calculations to show, but I believe it's based on the original approvals for MGE's Bring Your Own Device Demand Response Program, which to my understanding started with a 500 device Google Nest smart thermostat pilot, and then was expanded to use an aggregator with a maximum of 1,000 devices. And so using that range, it was scaled up for this initial 3,000 number for Wisconsin Public Service.
Okay. Where were the 500 Google Nest and the 1,000 devices approved? What's your reference for those two numbers?
I don't have that with me. I'd have to take a look to find.
Do you know?
I don't have these.
Do you know the date of those approvals?
It's going back a number of years, but I don't.
And how did you go from 500 Google Nest and 1,000 total devices to 3,000? What's the math?
Like I said, I don't have the exact calculations, but I believe it was based on the relative number of sort of that population of customers for Wisconsin Public Service compared to Madison Gas and Electric. So somewhere in that 3 to 5 times range, starting from the range of 500 to 1,000 customers.
Total customers, residential customers, sales, what's the?
Like I said, I don't have the exact calculation that was done. It was just using a customer count and starting from the MGE place. That was my understanding where their pilot started, a similar type of program, and looking at what we are.
And who else worked with you in deriving that scaling from MG&E to your 3,000 proposal?
I worked with Mr. Nelson and Mr. Stasek and advising them on putting together the program.
Okay. Thank you. That's all I have for this witness.
Okay. All right. Any other cross? No? Redirect?
No redirect, Your Honor.
All right. Thanks. All right. Great. You're excused. And yeah, those witnesses are still available, right? We have Stasek and
Yes, Your Honor.
Nelson. So that's opportunity to question on that point. Okay. So. Okay.
Your Honor, are we able to call our next witness?
Yes, please.
We call Mr. Aaron Nelson.
All right. All right, witness Nelson, I see you there. Raise your right hand. Do you swear or affirm? Tell the truth, the whole truth, and nothing but the truth. All right. Having trouble hearing you. Maybe there's something covering the mic now, a piece of paper or something.
We'll speak up.
Yeah, I'll speak up. Sorry
Okay, that's better. Yeah, go ahead.
Good afternoon, Mr. Nelson. Can you state your name for the record?
Aaron Nelson.
Mr. Nelson, did you submit written, direct, rebuttal, surrebuttal, and surrebuttal testimony in this case?
Yes, I did.
Did you also sponsor and submit 13 exhibits?
Yes.
Is everything in your testimony and exhibits truthful and accurate to the best of your knowledge?
It is.
If I asked you the same questions in your written testimony, would your answers be the same?
They would.
Thank you. This witness is available for cross.
All right. So we have everything settled here. Any questions for witness Nelson?
I do, Your Honor.
Go ahead.
Good afternoon, Mr. Nelson. David Bender for Vote Solar. were you present or could you hear my questions from Mr. Lambert?
Yes, I was able to listen to that.
Okay, so I have basically the same questions for you. So from his testimony, I understand that the scaling to reach 3,000 device pilot proposal came from MG&E's initial offering of 500 Nest and 1,000 total devices. Is that correct?
Yeah, that's correct to the best of my knowledge.
And do you know when the commission approved, what year the commission approved that size program for MG&E?
I don't know the exact year, but I know it's been several years.
How many? Like 3, several, or more than 3?
More than 3.
And who did the research into MG&E's program to find those numbers?
I don't recall exactly who did that research.
It was not you?
I don't believe it was, no.
And do you know what other data point was used to multiply by the 500 and 1,000 to reach a 3,000 device or 3,000 customer proposal in this case?
Yeah, my understanding is that the population of customers applicable to the pilot was used. So that would be residential customers at both Madison Gas and Electric and Wisconsin Public Service Corporation.
So the multiplier is basically the ratio of residential customers at MG&E and residential customers at WPSC?
Correct, yes.
All right. Thank you, that's all I had.
Excuse me. Yeah, so I did want to mention sorry. For Nelson's SRSA rebuttal, we just have a page 5 correction or a comment here on the docket 6690 TE 114 final decision. We can just get a PSC number inserted into that citation on a refiling.
We can do that, Your Honor. Thank you.
And I think with that, any other cross? Redirect?
No redirect, thank you.
All right. Thanks very much. You're excused.
Thank you.
Next witness.
Your Honor, we will be calling Mr. Hawley next.
You're sure?
To the best of my knowledge. Someone actually stole my note with the note.
Yeah. So let's swear you in. So raise your right hand. Do you swear or affirm? Tell the truth, the whole truth, and nothing but the truth.
Yes, I swear.
All right, great. Thanks. Go ahead.
Thank you, Your Honor. Mr. Hawley, did you prepare and cause to be filed rebuttal and SRSA rebuttal testimony in this case?
Yes, I did.
And if I asked you the questions contained in your rebuttal and SRSA rebuttal testimony, would your answers be the same today?
Yes, they would.
And subject to corrections that we've discussed on the record and off the record and the offered evidence list, we would submit Mr. Hawley's rebuttal and SRSA rebuttal testimony for the record.
Okay, that's great. And no objections to that, so they're in. Anything
So
else?
Mr. Hawley's available for cross.
Okay. Any questions?
Yes, Your Honor. Sierra Club would like to cross-examine.
All right, go ahead.
Examine. Hi, Mr. Hawley. My name is Megan Waxpress. I'm representing Sierra Club in this matter. I'd like to direct your attention to your Sir rebuttal testimony. At page 4, line 1, you state there is, oh, I'll wait till the get there. Page 4, line 1. There is currently little capacity to provide the natural gas supply necessary in WPSC's service territory. Have I quoted that correctly?
That was specifically in reference to the Weston site.
Okay. WPSC and WEPCO share a parent company, WEC. Is that correct?
That is correct.
And WEPCO is currently in the process of seeking commission approval for the construction of more than 1,200 megawatts of new gas-fired generation. Is that correct?
Your Honor, objection. Another utilities construction dockets are not relevant to this rate case proceeding.
Your Honor, if you'll forgive me, I have. Oh, thank you. So WEPCO is in the process of seeking commission approval for the construction of more than 1,200 megawatts of new gas-fired generation. Is that correct?
That is my understanding.
And WEPCO is also in the process of converting operations at Elm Road to from coal to gas-fired generation. Is that correct?
Your Honor, objection to this too. I believe it misstates what's happening at Elm Road and is another utility in a forward-looking construction docket.
Okay, can you clarify that question?
Sure. There is an additional project for which WEPCO expects to increase the need for gas within its service territory. Is that correct? Beyond the new construction?
That is correct.
Okay. And WPSC has stated its intention to convert Weston 4 to gas-fired generation. Is that correct?
That is correct.
So is it WPSC's position that it is not possible to provide the natural gas supply necessary for all of the generation resources that we've just discussed?
No.
So it's your position that if the company chooses to build gas generation, there is the possibility of bringing that supply online?
Objection vague.
I'll reframe.
Okay.
Is it your position that had WPSC chosen to replace Weston 3 in whole or in part with gas-fired generation, it would have been possible to bring on sufficient supply to meet that need?
Objection vague and calls for speculation.
Your Honor, he's testifying to the availability of gas supplies, and I've established, I don't know.
It's okay, overall.
Well, Your Honor, it's vague as to time, and she's calling for speculation about something that didn't happen in the past. I don't think it's a proper question, but I understand the ruling.
Okay, go ahead.
I will point out my response was related to the hypothetical example of adding facilities at the Weston site, which currently just would not have the capability to provide natural gas or dispatchable natural gas generation beyond what's currently there at this time. Again, I was thinking of the 2025, 2026 test year.
Was there sufficient natural gas capacity to bring on the current 128 megawatts of gas at Weston before the company announced its plans to construct it?
I'm not sure. I'm not in gas planning or generation planning.
But you're testifying to the availability of gas supply to meet a hypothetical alternative source of generation.
It's my understanding that the gas supply at the Weston site is limited.
Currently, is your testimony?
Currently, yes.
Okay. Does WPSC compare the variable cost of production at Weston 3 or 4 to that unit's revenue from the MISO energy market on an annual basis?
I don't know. That would not be in my area of responsibility.
You testified to the Weston Power Plant's participation in the MISO market. Is that correct?
That is correct.
But you're not familiar with any, you are not personally familiar with any processes within WPSC to track the cost of operating Weston 3 or 4 as compared to MISO energy market revenues. Is that correct?
Objection, I think that mischaracterizes the testimony.
He's free to say I've mischaracterized it.
And I'm free to make an objection.
Yeah. What testimony would you like to have the witness refer to? Is it something that we can point to?
So he states, for example, on page 5 of his rebuttal testimony, that his team, line 3, or going up even further, page 4, speaking of Ms. Metz's analysis, he says her flawed analysis of what is economic depends entirely on whether an individual generating unit will have positive energy margins in the MISO market in a given year, which does not
slow down a little bit. If
sorry, MISO market in a given year, which does not accurately assess benefits to customers. My team has to make operational decisions on a daily basis to respond to market conditions and ensure customers have a reliable source of energy and capacity. And so I'm asking, given that he is talking about the usefulness of a measure, which is the annual break-even margin, whether he in fact is aware whether or not WPSC tracks that.
Okay.
I don't think that was the question. There's not currently a question pending, I don't believe, but that's what
based on what you read, can we ask, let's ask a question based on that testimony then. Go ahead, attorney.
Okay. Does WPSC track whether an individual generating unit has positive energy margins in the MISO market in a given year?
And again, I would respond, I do not know that occurs. That is not my area of responsibility. My role is more focused on daily operations and ensuring that we are managing our resources in a way that minimizes the cost to serve WPSC load in a reliable manner.
Who in WPSC would have that responsibility?
Objection Foundation.
Overruled. Go ahead. You can answer that, please.
I believe that might lie in our generation planning group or in our fuel cost planning group in YF.
Would Mr. Arendt know the answer to that question?
Objection calls for speculation.
Okay. Overruled. I'm gonna have to overrule you every time you do that.
She's asking about the knowledge of another witness, Your Honor. That's classic speculation.
Okay, move on. You need to answer that, please. Do you know?
I do not know if Mr. Arndt knows the answer to that question.
So there was another question about daily values, wasn't there, Attorney Watch Press? I think you. First of all, let's just go off the record for a second. I had trouble finding the quote that you read on the rebuttal. Can you just give me the site for that?
Yes, it's beginning at page 4, line 22, and continuing on to page 5, line 3.
So which did I'm in rebuttal by accident, I think. Where are we?
I think you're in Mr. Nelson's testimony, Your Honor, or you were.
Okay, where am I supposed to be?
Mr. Hawley's testimony.
Right. Okay. So yeah, so off the record, so I did see that on page 5, he does speak to making daily operational decisions on a daily basis. And you had a question that related to information collected daily, I think, and that was objected to. And I didn't know if you want to restate that question and get an answer, or at least attempt to state that question.
No, Your Honor, I think I've gotten the information I need from this witness. and I just want to ask one more kind of question
Go ahead
along
and
these
get on the record.
lines.
All right, so
Yeah.
back on the record.
So you personally, Mr. Hawley, wouldn't know if between 2018 and 2020, WPSC ever performed a calculation to compare the variable fuel and O&M costs associated with operating Weston units 3 or 4 to those units' revenue in the MISO energy market.
That is correct.
Okay. So if I could then turn your attention to exhibit SC METS 35. Let me see if I can find it. And if you scroll down to the response to Sierra Club 6 SC05,
$605, is that?
6 SC05, yes. And this refers to Mr. Hawley's knowledge that any combination of wind and solar resources of virtually any size cannot serve as a reliable replacement for dispatchable resources such as Weston 3 and 4 for test year 2025. Have I read that correctly?
I believe so.
What is that
Yes.
knowledge what is that knowledge based on?
From time to educate my staff of power traders and managers, I will at a staff meeting, as we talk about kind of what's coming down the road in the future of the utility industry and the future for our generation portfolio, pull up the MISO interconnection queue and sort of review with my staff what projects are out there that are being proposed. And that with the idea being that there actually are projects that exist out there that are being proposed. But the projects in the interconnection queue are not all projects that will be constructed. They're just projects that have gotten into the MISO interconnection queue for a transmission interconnection. So knowing that and seeing the size of the projects in the queue, in my view, there was nothing there that looked like we'll be able to provide the thousands of megawatts of wind and solar generation that would be required to replace the energy from Weston 3 and Weston 4, much less provide the reliability that Weston 3 and Weston 4 provide our customers.
Were you in the habit of checking the MISO queue for potential projects in 2018?
I believe I have been observing the queue for quite some time. I've been in this role for over 20 years. The MISO queue did not exist 20 years ago, but I have looked at it from time to time. I'm not sure if can't recall if I looked at it in 2018 or not.
Would there have been any other basis of your knowledge to conclude in 2018 that there were insufficient wind and solar resources to replace the energy provided by Weston 3?
Objection. I believe that mischaracterizes the testimony.
Okay, any response?
I mean, I can read what he said about his knowledge in the record, or I can just read what he said in this testimony. In his response, he clarified that he meant energy as well as capacity. So I was following up on that. But I don't know what I've mischaracterized.
The
I
time
don't believe
frame.
he's right, exactly. I don't think he's testified about 2018 at all. This is a forward-looking test year for 2025 and 2026. And that's what Mr. Holly's testimony has been targeted on.
I understand that. What I would like to understand is what he was looking at in 2018 through 2020. And I can ask whether he had knowledge, whether he would make the same statement about a comment. I'll ask it this way.
Okay.
Would you make the same statement about the availability of wind and solar resources of virtually any size that cannot serve as a reliable replacement for dispatchable resources, such as Weston 3 and 4, as of the year 2018?
Objection, relevance, Your Honor.
Overruled.
If we're talking about replacing dispatchable resources, that means resources that can be brought on demand to not only supply energy, but also supply capacity, basically keep the lights on in Wisconsin and preserve reliability in the MISO footprint and in Wisconsin. And it's my belief that wind and solar resources of any size cannot provide that level of reliability. I've seen on a day-to-day basis in the MISO footprint where there are days where wind resources can go from 15,000 megawatts of generation in one period of the day down to less than 500 in another part of the day, particularly in the summer, but it happens around the year.
In 2018, were you similarly certain that no combination of wind, solar, battery energy storage, or gas resources could serve as a reliable replacement for dispatchable resources such as Weston 3 and Weston 4?
Objection, Your Honor. Are we really going to ask him about his knowledge from 6 years ago and the certainty of his 6-year-old beliefs in this case?
Yeah, overruled. He can answer.
Well, 6 years ago, there was very little solar generation in operation in MISO or even in the interconnection queue that's been a more recent surge in applications for transmission interconnection service. I'm not sure how much solar was in the queue in 2018, but I imagine it would have amounted in Wisconsin to less than a couple hundred megawatts. But that is speculation on my part. It's significantly more now than what was available back then. Battery energy storage is even further behind in terms of what would have been in the interconnection queue back in 2018. And for dispatchable gas generation, typically we have awareness of gas generation resources that are in the interconnection queue in the state of Wisconsin. And my knowledge, there's a combined cycle project in Superior, Wisconsin. I'm not sure when that entered the interconnection queue or where that stands in the process, but I'm not aware of any other significant dispatchable gas generation that would have been in the interconnection queue back in 2018.
You've answered with respect to the interconnection queue, but has WPSC contracted for any projects that were already in the interconnection queue at the time WPSC came to contract for them for any new generation that has come online in the past 10 years?
Objection, Your Honor. I believe this is actually beyond the scope of the statutory discovery rules now. We're back 10 years and vague as what exactly that we're talking about here.
Yeah,
Limited to 5 years, Your Honor, in the last 5 years.
Is there a clearer way you can ask that? I'm not following.
Okay. Your knowledge of the lack of availability of resources for both 2018 and the present is based on the MISO interconnection queue. Is that correct?
That is correct.
Is there any other basis for that knowledge?
Perhaps conversations with colleagues from time to time, but nothing that I can recall specifically. But reading the trade press, I guess, would be another example.
And I'm saying, is it the case and in the past 5 years, WPSC has never proposed new generation that was procured by a contract from a project that was already in the interconnection queue? Is that correct?
Your Honor, I checked it vague. I think there's actually a double negative in there that I can't quite parse myself.
Okay, can you rephrase?
Has the interconnection queue been the source of new generation for WPSC in the last 5 years?
I don't know the answer to that question. That's more of a generation planning question, and that's outside of my area of responsibility.
Okay, I think I'm done. Thank you, Your Honor.
Thanks very much. Any other cross? A redirect?
No, Your Honor, thank you.
All right, thanks. Thank you, witness Holly. So I did want to just, and you're excused. I think we have everything set in order for you. I did want to mention that I guess my lack of response to whether the questions on cross need to adhere to some timeframes that apply to discovery is not an admission that that's true. I would have to get a lot more analysis and legal presentation to be able to parse that out. I don't think I've seen that objection before, but I would be careful on making it again without some sort of legal analysis to back that up. So you don't need to deal with it now. I think that the question's moot in this case, but let's go to our next witness.
Your Honor, we'll call Jody Arndt.
Okay. Let's get this up here. Okay. And no, still an empty chair. Okay, we can wait. There you are. All right, raise your right hand. Swear or affirm, tell the truth, the whole truth, and nothing but the truth.
I do.
All right, go ahead.
Thank you, Your Honor. Mr. Arndt, did you prepare and cause to be filed rebuttal and sir rebuttal testimony in this docket? And subject to some corrections that we've discussed off the record and on the record today about the offered evidence list, if I asked you the questions contained in your rebuttal testimony and your sir rebuttal testimony, would your answers be the same?
Yes.
I would offer Mr. Arndt for cross-examination.
All right, so I just wanted to check no exhibits, right? I didn't miss anything.
I don't believe so. It depends, Your Honor, on the ruling about the committee presentation. But
On sir, is that?
Yes.
Yeah, okay. All right. So witness available for cross?
Yes.
Okay, all right. Okay, let's have questions for that. So I didn't know if there was, so let me just back up. Is there a current objection to that? Let's see, it's a slide, I think, that was included on page 5. And we do have the complete document now that was emailed to us by the applicant. So I'm not sure if did parties get a chance to review that? Do they have anything to raise at this point, or are we going to have questions for the witness?
Sierra Club anticipates moving for admission of the full document.
Okay, that's one way to cure this. So I don't have a, well, I haven't, well, let me let me take a pic. Let's go off the record for a second. I don't know if I've actually put my eyes on it.
Well, subject to your review, Your Honor, I think probably the easiest procedural way for it would be for us to revise that page and include it as an exhibit, and we're happy to do that.
Okay, yeah, I just wanted to see what's in there exactly. I'm doing that right now. You notice my eyes are set on the screen. Okay, so yeah, that's fine. Okay, yeah, if parties are going to resolve their disputes, whatever may be happening there, hello there. Then we can resolve it that way. So okay, so just to double check, does anyone take issue with the way it's presented, the way that the report is presented in the testimony? Did you say you would delete that and add an exhibit? I don't know if I paid attention to what you said enough.
Your Honor, what I said is we can revise this page. And then
Okay.
reference the exhibit, so it'd be exhibit WPSC ARNT 1.
Reference.
And
okay.
I think in the meantime, just to resolve some of the other issues we've talked about today, we would update the site at the same time.
Okay.
That we revise the testimony.
Yes. All right. That sounds like the reasonable solutions. Everyone agree? Okay. Let's get that here. So just go off the record for a second. Better write it so I can understand it later. Okay. Okay. So that's good. I think we're good. So let's get on the record. So we can accept ARNT rebuttal, surrebuttal, and I'm sorry, the ARNT rebuttal, the ARNT surrebuttal with the modifications we've discussed, which would be adding citation to the table on page 5 and adding the MISO operations report as exhibit ARNT 1. So we'll expect that as a refiled according to the the refiling schedule.
Thank you, Your Honor. I think you stated our discussion correctly, just for the record.
All right, good. Thanks for confirming. Okay, so is this witness available? Do we have questions at this point?
He is
Yes.
available. That question was to me.
Thanks. Go ahead, Attorney Watchpress.
As I believe it, in my mild defense, I believe it was a compound question if there were any questions. So.
No objections to my question.
Okay, I'd like to direct your attention to page 4 of your Sir rebuttal testimony and the diagrams we have been discussing.
And we're starting with 4, page 4?
Page 5?
Page 4. Is it page 5? Then page 5 it is.
Okay.
And I'd like to direct your attention to the document that you've now introduced that you say these diagrams are from, which is the MISO operations report. And I'd like to direct your attention to page 6 of that report. And at the top, do you see where it says, MISO effectively managed the July wind droughts thanks to normal demand levels and mild weather. Is that correct?
That's what it says, correct.
And you did not reproduce that section of the slide in your Sir rebuttal testimony. Is that correct?
It's obviously not there, so correct.
Okay. And you do not provide a citation in your Sir rebuttal testimony to this PowerPoint presentation. Is that correct?
That is correct. There's not a citation there.
Okay. So elsewhere in your testimony, you state that wind droughts are, quote, highly unpredictable. Is that correct?
That's correct.
Okay. And in your Sir rebuttal testimony, you don't cite any source for that conclusion about unpredictability. Is that correct?
Just experiential knowledge.
Okay. I'd like to direct your attention to page 24 of this same document, the MISO operations report. Slide 24.
Is that the right one?
It says 24 on the bottom, Markets Committee, September 17th, 2024. And am I reading the heading correctly that it says monthly day ahead wind forecast performance, mean absolute error and mean absolute percent error? Have I read that correctly?
Yes, at an average absolute error, correct.
And if you look at the right hand of the diagram, it says mean absolute percent error,
Correct.
and that corresponds to the orange squares.
Correct.
And those values range between, would you agree that they range between approximately 3 and 5%? Is that correct?
Yep.
Okay. If we could go up to page 20 of the presentation. And this page says as its heading, short-term load forecast. Is that correct?
That is correct.
And it also shows forecast errors here as, oh, I am so sorry. Please, page 19, I apologize. This is the midterm load forecast, the day ahead midterm load and forecast. Do you see that?
Mm-hmm.
And there are red dots that refer to the forecast error on this diagram as well.
Yep.
Okay. Can you answer with a yes, please?
Correct. Yes.
Yeah. Okay, thanks.
And those percent forecast errors range mostly between 0 and 5, but in at least 3 cases rise above 5%. Is that correct?
Correct.
Okay. Is WPSC not able to predict wind output on a day ahead basis?
We attempt to do that to the accuracy we can.
How accurate are you?
That's in Tom Hawley's area. I'm not on the day ahead real-time desk.
But you testified to the unpredictability of wind as part of your Sir rebuttal.
Objection, Your Honor, that mischaracterizes the testimony.
Is that the response there or no?
The response is that he let me find it.
Yeah, okay.
He says, although highly unpredictable, MISO has experienced 11 wind droughts since 2020.
Yeah, wind droughts are an extreme case, and that's what it says in the testimony.
So WPSC is not able to predict wind droughts.
We can't predict all of them with 100% certainty. Absolutely.
Do you know approximately what percentage you're able to predict?
Again, I'm in long-term planning, not the day ahead real-time area.
Okay. How many forced outages that lasted longer than 5 hours has Weston 3 had since 2020?
I do not have that data in front of me.
So you have not reviewed the number of outages that Weston 3 has had in the last 4 years?
Sure, I've seen it. I just have no idea off the top of my head what it is.
So you state on page 6 of your Sir rebuttal testimony that, quote, keeping Weston 3 operational now may similarly permit WPSC to take advantage of market conditions between now and its scheduled retirement before 2031.
I don't know if it's on my end or somebody else's, but we're breaking up.
I haven't noticed anything.
Off the record. Well, I'm noticing the video on Pub Services end looks a little like it's lagging a bit, but
yeah, I don't think we got any of that question. It sounds like it was on my end, so apologies for that. I think I would just ask to restate it, and then hopefully our internet doesn't bungle it again.
All right, let's have it read back.
Question. So you stated on page 6 of your Sir rebuttal testimony that, quote, keeping Weston 3 operational now may similarly, may similarly permit the load WPSC to take advantage of market conditions between now and its scheduled retirement for?
That's what it says, correct.
To keep Weston 3 in operation, WPSC will need to pay certain fixed costs regardless of how much the unit operates. Is that correct?
Correct.
And those costs are in the order of magnitude of tens of millions of dollars per year. Is that correct?
Sounds about right.
And WPSC has never performed a forward-going economic analysis to assess whether the option value of maintaining Weston 3 is worth these tens of millions of dollars in capital expenditures and operating and maintenance costs required to keep it available. Is that correct?
There's no such formal report.
No such formal. Has any written document ever been presented?
We do long-term planning continuously. It depends on the situation where we look at particular units that something is threatening their viability, whether that's age, whether that's rules that may come in from certain areas. But other than that, no, we have not looked at that specifically from an economic standpoint.
Would you agree that multiple years of negative energy margins in the MISO market would threaten a unit's viability?
No.
What is an example of something that would threaten a unit's viability other than environmental regulations?
Backward-looking data does not represent what the future potentially could be. So it's very difficult to look at backward-looking data and say that that's a reason that you should be looking at to investigate retirement of a facility, unless there's something very specific or dramatic. But from the standpoint of what we would look at is something that would literally threaten the viability of that unit on a forward-looking basis.
So WPSC does not consider the economics of a unit in deciding whether or not to look at alternative sources for generation.
We considered the forward view of what is potentially available for the units in the market against whatever would be there to replace that unit to make that determination.
But WPSC has never performed that kind of forward-going comparison for Weston Unit 3, correct?
Objection. I believe that mischaracterizes the testimony. You can answer.
Yes, he can answer. Go ahead.
Like I said, we look at resource planning continually. Have we looked specifically at Weston 3? We recently have, but we until recently did not have the reason there that threatened the unit's viability.
I guess you still haven't answered my question, which is there any economic information about a unit that you would consider as threatening a unit's viability?
Don't think that was the question. But
Well, I'm going to ask that. Is there any economic information that you would consider as threatening a unit's viability?
Like I said, it would have to be something extreme, right? It would have to be unsustainable prices, fuel issues where you could not get deliverability of fuel, lack of fuel, something along those lines, which would impact the economics. Or it would have to be a rule that's promulgated that would require a substantial investment in a particular unit.
So a unit's performance in the MISO energy market could never be a basis in WPSC's view for evaluating its future viability.
Backward-looking data is not a representation of what the future is from a planning standpoint.
Does WPSC project performance in the MISO energy market in future years?
When we do our analysis, we certainly look at, that's part of what we do when we run the models, is look at that forward view across multiple scenarios and sensitivities.
I'm sorry, what models are you referring to?
Our long-range capacity expansion models.
So that's for additional resources, is that correct?
Well, it's either additional or replacement or projects that we need to do that are of a certain size where we need to form justification for that.
Has WPSC ever run such a model that allowed it to endogenously select a retirement date for Weston Unit 3?
I would not allow a model to predict a retirement date.
Has WPSC ever run a model with any retirement date for Weston Unit 3 other than 2031?
Again, we have not, because we haven't seen a need regarding the unit's liability until recently.
Did you say liability or viability?
Viability.
Thank you.
You bet.
You said until recently. What
Right.
triggered the consideration of Weston 3 recently?
The EPA rule that was recently promulgated.
So not any economic information about the unit.
Correct.
Has WPSC at any point in the last 5 years evaluated whether lower cost resources are available to meet its customers' needs than those which it is currently utilizing?
We have a full listing of every project within Zone 2, their interconnect agreement. We have relationships with all of the developers. We understand where they are in their process, and we continually talk to them. So yes, we've been doing that since at least I didn't get into this area until 2021, but for sure starting in 2019, 2020, from my knowledge. I can't speak before that.
The Weston Rice units were a self-build project though, correct?
That is correct.
Let's talk about those Weston Rice units. You, along with WEPCO, jointly filed an engineering plan in support of the application for a CPCN to construct those Rice units in February 2021. Is that correct?
Your Honor, what is the relevance of referring to a construction docket that's been approved years ago and a unit that was approved into the revenue requirement years ago to this forward-looking rate case?
Your Honor, the witness has testified as to the timeline for replacement generation and did not include, did not talk about the Weston Rice units. So I want to establish in the record the timeline for the construction of the Weston Rice units.
These are documents her own expert could have brought into the record and testified about, and I don't see what the point of having cross outside of Mr. Aaron's own direct and rebuttal and Sir rebuttal testimony would be at this stage of the game when there's nothing in the record about Weston Rice being relevant to 2025 and 2026 rates in the way that Ms. Waxpress is discussing.
May I respond just once more, Your Honor?
Sure.
We've had repeated testimony from both witnesses now that the basis for their conclusion that there was no alternative to the Weston units was their review of the interconnection queue and the availability of projects in that queue. My point with the Weston Rice units is that the company has demonstrated its ability to build a project on an expedited timeline on the Weston site in recent years without any engagement with the MISO interconnection queue whatsoever. And so I think it's relevant to rebut the assumption that is implicit in their testimony that the lack of availability of projects in the queue speaks to alternatives.
Your Honor, she's conflating two different time periods, and if there is a lot of testimony about that, it would have been in rebuttal, and it should have been included in her expert witness's 23-page rebuttal testimony. It's not news to anybody that the Weston Rice unit has been approved, has actually survived court appeals, and has been operational for, I think, 18 months or 24 months, going back years before the relevant time period for this rate case.
Any response to that?
No, Your Honor, I just think that it's relevant to show the availability of replacement and to rebut the witness's assertion that the lack of projects in the interconnection queue speaks to that availability.
Okay, but in this case, I think we should have had that filed by your witness and an analysis presented prior to the hearing. And this isn't anything new that's been offered on Sir rebuttal, so I don't think we need to be bringing it up at this point. This should have been offered by the witness on regular rounds of testimony.
Mr. Hawley testified to the availability of alternative resources in his Sir rebuttal, but I will let it go. Okay. When does WPSC currently intend to complete the gas conversion at Weston Unit 4?
The plan would be so that we could be compliant with the EPA rule.
And that date is January 1st.
Before 2030.
Is it your understanding that WPSC is under any legally binding obligation to meet this January 1st, 2030 deadline?
Plus for a legal conclusion, Your Honor.
He can answer to the extent he knows the application of the rule to his field.
As far as my knowledge is, yes, we are aiming for that date to be in compliance with that rule.
If WPSC chose a different means of meeting that rule, would that be at WPSC's discretion, or is there any other legally binding obligation for it to convert by that date?
Your Honor, I think that calls both for a legal conclusion and for speculation about events that will occur up to 6 years from now.
Okay. Any response?
I mean, we're testifying to the reasonableness of the test year costs in Weston Unit 3 and Weston Unit 4. I think the plans for the plant are relevant for assessing the reasonableness of those costs.
It doesn't cure the deficiencies in the question, Your Honor.
Guess he can answer to the extent he has any available information, or tell us he doesn't know.
So can you repeat the question?
Let's have it read back.
Question, if WPSC chose a different means of meeting that rule, would that be at WPSC's discretion, or is there any other legally binding obligation for it to convert by that date?
The conversion by that date is being driven by the EPA rule.
Does WPSC currently have any plans to cease all generation at Weston Unit 4?
We have not made that determination to date, so what we put out there publicly is what we have.
Has WPSC run any models or conducted any analyses to compare the costs to ratepayers of retiring and replacing Weston 4 versus converting it to gas?
Objection vague, Your Honor.
You rephrase?
Has WPSC conducted any economic analyses to assess the relative cost to ratepayers of either retiring Weston 4 by January 1st, 2030, or converting it to gas by that date?
So I believe now we have a time period, Your Honor, and that shows the irrelevance of asking about things that will happen 6 years from the test year.
I'm sorry, Your Honor, they're objecting when I ask about decisions made in the past, and they're objecting about decisions now made in the future. And so if it's their position that anything outside the test years of 25 and 26 are relevant, that can be their position. But I think that's a legal argument befitting briefing and not consistent with the statute or utility practice.
I disagree with both of those things. It has to have some impact on rates and whether rates are just and reasonable within the test year. And I do not see how an economic analysis about events that will occur in 28, 29, and that will be subject to other statutory provisions in utility practice in Wisconsin has to do with that test year. But Ms. Waxfors is correct. Our position, as it has been in numerous cases, is that it has to have some effect on the reasonableness of rates in the test years to be relevant to a rate case.
Okay. So I'll allow the question. Witness can answer to the extent that he knows, but we need to start wrapping this up, please.
Sure. Given there are no costs that would be in the 25 or 26 timeframe, like any other project, we would bring this forward for approval to the PSCW on whatever we decide is the right plan for that site.
And I think I may have asked this a slightly different way, but does WPSC has not performed any forward-looking analysis of Weston Units 3 projected energy market margins or energy and capacity market margins at any point in the past 5 years? Is that correct?
When we would bring a project forward to determine the long-term future of Weston 3 and 4, we would provide that economic analysis.
Oh, you're muted, Attorney Watch Press. Don't know how that happened.
In your testimony, no, actually, apologies for that. One last question. For the test years, is WPSC willing to commit not to seek to recover fuel and variable costs associated with the Weston units that exceed those units' revenue in the MISO energy market?
I don't think that's an appropriate question for this witness, as it's asking for the company's position. We filed a revenue requirement, but I think he can answer to the extent he knows.
All right, go ahead.
Not to my knowledge.
So the company is seeking to recover fuel and variable costs in excess of the revenue earned in the MISO energy market for Weston's unit 3 and 4.
That mischaracterizes the testimony, and this is again not an appropriate witness to discuss the revenue requirement and the fuel cost plan, I think is what Ms. Walks-Press is really after. There are other witnesses that have testified about that.
Okay. I agree with that. Is there another question?
No, Your Honor, I'm done.
Okay. All right. Any other cross? Nothing. Redirect?
No, Your Honor. Thank you.
Okay. Need the decks here. So we do have is it Stasek left?
Yes, Your Honor, but that would be our last witness.
All right. Let's take Stasek, please.
Your Honor, Mr. Statesek is available to be.
I see you there. Raise your right hand. Do you swear or affirm? Tell the truth, the whole truth, nothing but the truth?
I do.
All right. Go ahead.
Thank you, Your Honor. Mr. Stasek, did you prepare and cause to be filed direct rebuttal, and sir rebuttal testimony in this case?
That is correct. I did.
And subject to some of the clarifications and revisions that we've discussed previously, both on and off the record, if I asked you the questions in your direct rebuttal, sir rebuttal, and sir rebuttal today, would your answers be the same?
They would, yes.
And Mr. Stasek, did you prepare and cause to be filed one exhibit WPSC Stasek 1?
Yes.
And to the best of your knowledge, and subject to corrections that we've discussed previously, is that exhibit true and correct?
It is.
Your Honor, Mr. Stasek is available for cross.
All right. Just want to mention we need page numbers at the bottom of the sir.
Yes, Your Honor.
Yeah, that's all.
Understood.
Okay, great. Thanks. And I think that's it. So do we have questions for this witness?
I have a question, Your Honor, for the witness.
Yes, go ahead.
Good afternoon, David Bender for Volt Solar. Were you present or did you hear the cross of Mr. Lambert and Mr. Nelson?
I did, yes.
Okay. I think that Mr. Lambert identified you as one of the people who worked on developing the BYOD proposal. Is that correct?
Mr. Lambert and Mr. Nelson worked on it at my direction as we were working with CUB and renew as per the commission's order in the prior rate case.
Okay. Do you
I'm sorry, in the prior, did you say in the prior rate case?
That is correct.
Thank you.
Do you have any insight in addition to what Mr. Lambert and Nelson testified about as to the process of scaling the MG&E BYOD program for your proposed program size in this case?
So beyond what either or both of those two gentlemen collectively testified to, I don't have any further context.
Do you know what year the commission approved a program size of 500 or 1,000 devices for MG&E?
Off the top of my head, as I sit here today, I do not.
Okay. Thank you. I have nothing further.
Okay. Other cross and redirect?
No, Your Honor. Thank you.
All right. Thanks. You're excused. Okay, just had a couple more notes for the Sur rebuttal. I forgot to mention before for Ducky, we have a non-record evidence disclaimer and two tariff citations that are made in testimony. If we could add those. And for Mensa or Megna, sorry.
Sorry, Your Honor, I guess I didn't understand the tariff.
Yeah, there's
maybe other people did, but
okay, sorry. Let me see. Korducky. Just trying to do this quickly. With that,
no, I hear you. I don't want to commit to doing it if I don't understand what it is.
So there's citations to the X280 tariff, and I don't know if there's another tariff cited, but there's a couple, and the X290. So either we can offer those as exhibits or just disclaim them as.
Okay, I understand now. Thank you, Your Honor.
And then Megna has commission decision citations. You can just add the just correct those to the site format that we talked about.
Yes, Your Honor. Thank you.
So we have the applicant done. Let's grab 10-minute break and we'll start with our next witnesses. So we can stretch for a minute. We'll be right back.
Thank you, Your Honor. Much appreciated.
All right, it's about time to start. We have the principal people we need here. Let's see if we can get the rest of us. I believe it's Cub's turn. Going through the list alphabetically here.
Are you on?
I think I'm on. Can you hear me?
Yeah. No, I didn't know
Oh.
if you're on the record.
Oh, on the record. No, not yet.
That's why, you know.
That's all you care about, I know.
I was going to say that, but I didn't think that would sound very nice.
That's okay. So we'll need to see if we have Cub witnesses available. We're gonna have Content and Singletary with questions. Okay. Well, let's get on the record. Let's take our first witness for Citizens Utility Board.
Thank you, Your Honor. Cub calls Tom Content.
Okay. I see you there. Raise your right hand. Do you swear or affirm? Tell the truth, the whole truth, nothing but the truth?
I do.
All right. Your volume's a little bit low for me, but maybe that's just me. Check that out.
Is this any better?
It is. Yeah, I think so. Okay.
Okay.
All right. Go ahead with this witness.
Please state your name for the record.
Tom Content.
Mr. Content, in this proceeding, did you prepare and cause to be filed direct testimony and 3 exhibits?
Yes, I did.
And is that testimony and the information in those exhibits true and correct to the best of your knowledge?
It is.
Do you have anything to add at this time?
No, I don't.
The witness is available.
All right. Any questions? We can start with the applicant. We're not hearing you.
Thank you.
Oh,
yes,
maybe...
we have a few questions, Your Honor. This is Joe Wilson on behalf of the applicants.
Okay, Debbie, did you get that? Okay, all right. Go ahead.
Good afternoon, Mr. Content.
Good afternoon.
One of the things that the commission will have to do in this case is set an authorized return on equity for the utility, right?
Correct.
Could you please direct your attention to page 4 of your direct testimony, lines 17 and 18? You have that in front of you?
Yes, I do.
And there you talk about the quote, billions of investments upon which utilities will earn their regulated returns. Do you see that?
Yes.
You said that's page 4. Oh, I got the wrong witness. That's
Oh, wait.
So there you talk about the billions that utilities will, billions upon which the utilities will earn their regulated returns, right?
Correct.
Utilities are not guaranteed to earn their regulated returns, though, are they?
No.
Utilities are supposed to be given the opportunity to earn their authorized returns by prudently managing their businesses, right?
There's some they are off they are yes, they can achieve those returns depending on how they operate their business.
Objection to this line of questioning. We do have a witness who is an expert in return on equity, and these might be better directed to Dr. Keim.
He's already answered the question.
okay, we'll just move on. I think
utilities don't
line
always...
of questionings, though, just in terms of the line of questioning, I think the witness does address rate of return on equity, right?
Yep.
Yeah. Okay.
Yeah. In fact, it's one of the principal focuses of his testimony.
Okay.
Utilities don't always earn their regulated returns, do they?
I think I don't know definitively, but I know Dr. Keim would be able to offer insights on that.
Could you look at page 7 of your direct testimony? Specifically lines 7 through 11, where you discuss some of the elements of WEC's incentive compensation plan. Are you there?
Yes.
Okay. And you say that the metrics under the incentive compensation plan measure total shareholder return, including earnings per share, cash flow, authorized and earned return on equity, right?
Correct.
In your testimony, you don't note that under the company's short-term performance plan, there are also targets for customer satisfaction, do you?
No, I do not.
Why not?
My point was to address the issue of affordability and the ability of customers to pay their bills. I think I was calling attention to the lack of a metric in that area.
You also don't mention that the fact that there's a metric for workforce diversity, do you?
The testimony speaks for itself. It's not there.
You also don't mention a metric for supplier diversity, do you?
Correct.
And you also don't measure a metric for, or mention a metric for safety measures, do you?
That's correct.
Is your understanding that WEC's short-term incentive compensation plan in fact contains metrics for all of those things?
I believe it does.
Could you turn to page 8 of your direct testimony? And at lines 12 through 16, you discuss increased investment in Wisconsin because of a regulatory decision in Illinois, right?
Following a regulatory decision in Illinois, correct?
And you reference your exhibit 3. Let's take a look at that. That's some excerpted pages from one of WEC Energy Group's investor decks, right?
Correct.
Back at page 8 of your direct testimony, you discuss the fact that or your contention that there's $300 million of increased spending in Wisconsin, right?
Yes.
Could you show me where in exhibit 3 it says that there's $300 million more of investment in Wisconsin? Because that's the citation you provide for that fact.
It's the combination of regulated renewables as well as electric delivery.
Okay, what page are you looking at?
Actually, let me look.
I believe it's page 18.
Hold on 1 second. We're going back.
So we've got 17 up on the screen now. Attorney Coburn Ferris, you think it's page 18 we should be looking at?
I believe so.
Let's take a look at that page and see if that provides the answer.
So it's the 300 million in additional generation electric delivery. I would note that that does include Michigan. If to the best of my recollection, it may have been discussed on the conference call that the focus was going to be for Wisconsin for that $300 million.
Okay, but nothing in Exhibit 3 tells us the breakdown as between Wisconsin and Michigan, does it?
Correct.
And as you sit here today, are you able to tell us the breakdown of that 300 million as between Michigan and Wisconsin?
No, I would note the relative size of the utilities in the Upper Peninsula as opposed to the applicant.
Well, would you agree that despite the relative size of the utilities, electric generation additions can be quite substantial, and a single power plant could account for hundreds of millions of dollars if it were being built in one state versus the other?
Objection. This goes beyond the scope of Mr. Content's testimony.
You want me to respond?
Sure, you can respond.
Well, he testified that there was $300 million going into Wisconsin. It appears that the exhibit he's signing for that does not support that fact. And I'm trying to, and then he said, well, you have to consider the relative size of the utilities, and I'm exploring whether that really tells us anything, and I don't think it does, but I'd like to hear his answer on that.
All right, go ahead, you can answer that.
It's not the only dispute. Can you repeat the question?
Let's read it back.
Question. Well, would you agree that despite the relative size of the utilities, electric generation additions can be quite substantial, and a single power plant could account for hundreds of millions of dollars if it were being built in one state versus the other?
Yes.
Okay. As you sit here today, are you prepared to say that any of the additional investment being made in Wisconsin as a result of the regulatory decision in Illinois, whatever the amount, should not be made?
No, I didn't. I did not say that in my testimony.
Okay, and are you saying that today?
No.
Staying on page 8 of your direct, and if we could go back there, Judge, please. Lines 9, excuse me, page 8, line 20 through page 9, line 8. There you talk about the early retirement of the Columbia power plant, right?
Yes.
All right. I understand CUB's position on the recovery of the cost of that plant, but my question for you is whether CUB takes the position that Columbia should be kept in service to avoid the stranded cost issue that you raise in your testimony.
Objection. Mr. Content did not testify to that issue, and this is a question better asked of Mr. Singletary, who specifically spoke to Columbia retirement scenarios.
Well, he's talking about this issue in the testimony we're looking at right now.
Overruled.
I would my purpose in bringing this issue up was my purpose of my testimony was to highlight issues that were raised by Dr. Keim and Mr. Singletary in their testimony. So I would defer to I think this question would be better directed toward Mr. Singletary.
Okay, you're Cub's executive director, right?
That's correct.
So on behalf of Cub,
I am not, I'm not the technical witness on this issue.
does Cub take any issue with Columbia's retirement in 2026?
Objection vague.
Okay, sustained.
No further questions.
Okay. All right, any other cross? All right, redirect.
No redirect.
Okay, I was just curious though, I thought I heard witness content said this investor deck that's content 3, but something I'm not really familiar with, so I won't ask about what it all means, except that you did mention that you were on a call. Were you, and can you just describe what call you were on? If I heard that correct?
I was not on the call. I was listening to the call, and I reviewed a transcript of that call. It was the earnings call of the WEC Energy Group from earlier this year that reflected their Q4 results for 2023.
Okay, and so I was just curious, just in terms of the statement you made about $300 million. Remember the page there. The $300 million investment in Wisconsin, was that the number you heard on the call?
Yeah, they talked. My recollection at this is that they talked about it in as an investment in my recollection is that they had talked about it as an investment in Wisconsin from the call, even if it wasn't accounted for that way on the slides.
Okay. Okay, thanks. That's all I had.
Yep.
Any other redirect from that?
No.
Your Honor, can I just note a little bit of a double standard?
I'm sorry, who's speaking?
This is Joe Wilson.
Oh, sorry, your box doesn't light up. I'm sorry.
Yeah.
Go ahead.
I apologize.
It's okay.
We're talking about a transcript of a earnings call here that is not in the record. And earlier there was a lot of discussion about what a former commissioner said in comments that are preserved on YouTube. It seems that there's a bit of a double standard here.
You heard the call.
Okay, Mr. Singletary heard the commissioner's comments, and they're preserved on YouTube. But okay,
They're not. No, that's different. Okay. Do you want me to? Well, what double standard don't you like exactly? I don't see that. So okay. He said he heard the call. That's where so that to me prompted a question as to where that $3 million figure might have come from, rather than the slide deck. And that's to clarify the record. I asked him that question. I don't see that as a double standard, sir.
Okay.
Okay. Let's move on. Done with content. Let's call the next witness, please.
Cub calls Corey Singletary.
Okay. Let's swear you in. Raise your right hand. You swear or affirm, tell the truth, the whole truth, and nothing but the truth.
I do.
Okay, go ahead.
Please state your name for the record.
Corey Singletary.
And in this proceeding, did you prepare and cause to be filed direct testimony, errata for your direct rebuttal, sir rebuttal testimony with errata, and 13 exhibits?
Yes.
And is the testimony and the information, is that testimony and the information contained in those exhibits true and correct to the best of your knowledge?
It is.
And with respect to Exhibit 12, which we discussed earlier today, could you tell us what this exhibit is, where it came from, and why you're including it on the record?
Yes. So what the exhibit shows is the data table I had received from commission staff, separate from this proceeding on work I was doing on energy burden generally. And that includes by census tract information such as customer counts, average annual bill for electric and gas service total, and a variety of energy burden figures calculated by the utility and provided to staff in the table. In my direct, I had noted that in the process of going through preparing an energy burden analysis for WPSC for this case, I had noted that there were a number of census tracts where the data was a little odd to me in that there was a value for an average total annual energy bill for gas. And I should clarify that this table is specifically for WPSC gas, at least as based off of my understanding of the source data. And so there was average annual gas bill figures for census tracts where there were no gas accounts. With what's up on the screen right now, you can see kind of down towards the bottom third of the page where there's a few of those. And it was more of a note in my direct, kind of in the interest of furthering, work on this by not only parties, but by the company, to just kind of point this out as a data point that I had noted. In his rebuttal, Mr. Stasek had commented that he, I don't remember the exact wording, but he stated that he found my, observation essentially kind of without merit. And so again, just in the interest of clarifying things, I offered this exhibit to just kind of show what was included in the source data that I used, just to kind of clarify things there. And then in the process of preparing that exhibit, I did note that there were census tracts where the count of residential customers within that census tract area was one or very small, say like a double-digit number. And in particular, with respect to the ones where the customer count was one, meaning it is directly customer identifiable information, but even in ones where the customer count was very small, and so could still be attributable to, somewhat directly to folks if you just, put the census tract information in and look it up on a map. In the interest of protecting individual customer identifiable and personal information, I had perhaps used the wrong term and redacted it to sort of anonymize the data somewhat.
All right. Do you have anything else to add to your testimony at this time?
I do not.
All right, the witness is available.
Okay, well, and just a few follow-ups for witness Singletary on that. So in terms of the redacted lines or rows that we see on the tables, just have the first page presented here. I just as a threshold question, in the data in that redacted row, did you use that data in your analysis?
I did.
Okay, all right. So, and then as another follow-up, this data, is it available to the public?
No, it is not. I mean, certainly the input data to the calculations that the results are shown kind of in the yellow columns or columns with yellow shaded headers. Those are obviously produced by the input data, which is all the billing information in the blue header shaded columns on the left. And that all comes from the utility billing system. So that is not publicly available information. To calculate energy burden, you can kind of see at the top of this exhibit. Staff's instructions directed the use of specific data tables from the United States Census Bureau American Community Survey. And so that in combination with that bill data produces the information on the right, but the information on the left is not publicly available information.
Okay, I see. But no one's claiming that the data that's being presented here needs to be redacted or qualifies under our standards for confidential handling.
Based on my recollection of the specific criteria for confidential handling, whereas I sit here today, I can't think of one that it neatly fits under. The steps I took, like I said, were more in the interest of anonymizing the data to protect the customer information.
Well, I mean, the data that's being presented here, by filing it here, you're obviously saying that's data that doesn't qualify for confidential handling.
Don't know if I fully understand your question.
So you filed this document publicly.
Correct.
Except for that redacted row. So all the numbers I'm seeing here are public, and no one's claiming that they should be redacted.
To my knowledge, no one is claiming they should be redacted. And the reason that I did not redact the rest was that the number of customers was such that the information, at least from my perspective and based off of information that's been filed by utilities in annual reports, not by the applicants, but by other utilities on this issue in annual reports where they do provide census tract level data, like kind of at this level of detail, that if it's kind of anonymized like this with large customer accounts, that there has historically not been a problem with that being filed publicly.
Okay, and have you seen the redacted versions when there's one or very few accounts on a row?
I cannot recall.
Okay. But no names are being released or addresses, like mailing addresses of customers.
You couldn't. Sorry, I didn't mean to interrupt you.
Go ahead.
No, you could not use this information as it is to, for example, pull up to someone's house. You would have to use the census tract number, and then that is relatively easily searchable online as to what specific geographical area that is. And in areas where there is a small number of customers, or just one customer, it would be pretty easy to identify that within that area, that's the customer. But there's no addresses.
Mm-hmm. So what do you consider customer, what did you call this? Customer information. You're protecting customer information. What are we protecting by?
The amount paid by the amount of the customer's utility bill.
But it doesn't give the name or the account number or the location of that customer. Okay.
Your Honor, if we change that to personally identifying customer information, would that be helpful?
Well, that's what I'm trying to get at. I don't really see any personal identifying customer information. So
because it's such a low number.
I'm sorry, I know there's a law that prevents municipalities from releasing customer information. 196.375, I believe. Now, I think people have argued that applies to the commission. I don't read it that way. It says the municipalities need to keep that information confidential, except when they're putting account numbers and bills on postcards and mailing them. But having said that, that's municipal utilities anyway. So I'm just trying to get at what is the customer information that's being released by releasing that information. I don't really see any. So anyone else want to comment on this? No, I think we fleshed out the issues.
Your Honor, if it would be your preference that this be refiled without the bars, the redactions, from my perspective, if that's your direction, that's fine. I was operating from my general experience of how this type of data, this type of census tract level data is handled in other states like California, where they do a lot more of this kind of granular information, analysis, and they have standard practices for how they anonymize data. We don't have that here in Wisconsin. And so this was my best attempt to, I'll say, play it safe.
Okay, I appreciate that. And I'm going to have you file the full version publicly because I don't think it fits our standard for keeping a document under wraps. We want to be, apply those standards consistently and with integrity. and with integrity. So unless I'm told that the rules prevent us from releasing that information, I'm going to have you file it publicly. So let's refile with that.
Understood.
I may be a little bit late, but just one other thought for your consideration. If the concern is
I'm sorry, who's speaking?
I'm sorry, this is Evan Whites from the commission.
Oh, sorry, I couldn't see you moving. Go ahead.
I was just thinking it through. If the concern is that with these certain census tracts, the number of customers makes the broader information more identifiable, could just the number of accounts be redacted rather than the entire bar? That way you would still have all the additional information, which I think is the purpose of this exhibit, but you don't necessarily identify how many customers there are such that you could narrow it down to a particular person.
Okay, well, I'm just going to stay with my ruling. Thanks for adding that, though.
Just a thought.
Yep, okay. Okay, so let's move on to our next issue, which is quoting the commissioner in rebuttal. So we did discuss this at the beginning of the hearing. I don't want to review all of it again, but I can give a little more direction with this before we receive these documents into the record. First of all, like I mentioned at the beginning, it's always been my practice to strike these when I see them. And for the reasons that I gave at the beginning, I don't know necessarily if that's a set and fast rule. I'm willing to be persuaded by that in terms of when quoting a commissioner. Now that we have YouTube and can be and the statement can be accurately transcribed and filed as a verified transcript, that may be useful in certain circumstances. I haven't seen that yet, and I don't see it here. I think not to get ahead of ourselves, but I think that I could perceive a situation where what the commission's order says is in dispute or is ambiguous. We could use commissioner statements as extraneous evidence to interpret what the commission's saying, but we would need to get the full context in a verified format to be able to make it useful. So I think the applicant did identify a situation, for instance, if the order point is not clear, or we're not sure how to apply it to a particular situation, extraneous evidence may be useful to interpret what's being said. But I'm saying that that's not something you can hold me to in this case. It's just kind of a legal theory there. So obviously a hypothetical that may be applied someday in the future. And of course, you'll quote me back on it. But I did want to say in this situation, we're not seeing that kind of issue being presented. And I understand the thrust of this testimony, but I don't believe it's appropriate now that we've have this before us for evaluation, playing Monday morning quarterback here, like I always do. This quote is not appropriate. And one of the reasons I can give you is that looking at the order from the basis of the open meeting discussion for docket 5UR110, looking at the order that comes after that discussion, we do see the issue addressed by the commission on page 29 of the final decision, and it doesn't raise the issues that were discussed. There seems to be a lot of controversy here reading this section, and I think if the if the commission was giving direction for future cases, that staff has been advised as to what the commission's order is and is applying that in its analysis and its audit, like I think which is its normal practice. So this discussion kind of, details a controversial topic, but it states a clear result, and there's really no controversy as to what the commission decided in that case. So using the commissioner's statement really doesn't clarify that. It doesn't help us understand the final decision. But I will note that also that one commissioner dissented. So there may be a lot more in the context of the open meeting discussion that's not being presented. We would need to see sort of the full discussion. And at this point, I don't think, because it doesn't really impact the an item that's in play is not interpreting what the commission actually ordered. So in that case, I'm not going to allow it in. So we'll need to see that redacted from the Singletary rebuttal. I think if we'd start at line 16, starting from page 3 with this challenge and up until page 4, line 9, ending with levels, we could take that out of the rebuttal, and I think that would satisfy the standards that we're developing here. So yeah, that's my ruling on that. Okay, so with that, any cross for the witness?
Yes,
And
Your
so
Honor.
I'm going to interrupt. Let's go off the record. So I need you, Attorney Wilson, to switch seats with because your microphone's on. So I just noticed in terms of the live stream, we're not catching Attorney Wilson's questions on camera.
Oh, yeah. Thank you, Your Honor. We forgot about the live stream and the way that works.
It's okay. It's always the devil's in the details.
That's right.
Your Honor, before we go back on the record, just a point of clarification regarding your decision as it related to the quote from the commissioner. I know staff addressed that in, I believe, Sir rebuttal testimony. Yeah. Did you want any modification to that discussion?
I don't think it was necessary. They didn't use the quote. I don't really feel strongly about it. So I guess I'll leave it up to you if it's, let me see. I can't remember where that was.
I believe it was the Sir rebuttal testimony of witness Probst.
Yeah. Yeah, my understanding was that the way it was worded, we could get away with not having to refile that. Oh, let's see. Yeah. So they quote the decision.
I guess it would be the lines 4 through 7.
I mean, I don't think it really says anything. But if just to be consistent, if you want to take it out, yeah, go ahead and do that.
I guess I don't have a strong preference, so whatever Your Honor.
All right, take it out. You make me decide. Take it out.
So just the lines.
Just what I have there. So starting on page 3, line 4 with the witness, and ending on just go up until up and including line 7, that page.
Okay. Yeah. Thank you.
I mean, I guess it doesn't. I guess you don't really need the quote either from the order, but it's fine. Just take out the reference to the discussion or record.
Will do.
Yeah. Okay. All right. So are we ready for cross?
Yes, Your Honor.
Okay, perfect. All right, let's go ahead.
Your Honor, would you mind pulling up Singletary?
Yourself.
Yes, This is Joe Wilson on behalf of the applicant. Would you mind pulling up Exhibit 12 again, Your Honor? We were looking at it for so long that I came up with a question.
Oh boy, that's the danger of that, huh?
Right.
Let me get oriented here, because it's pancaked among many other screens.
Yes, Singletary 12.
Yes. All right, we have you there. Go ahead.
Thank you. Mr. Singletary, could you explain how some census tracts appear to have no residential gas accounts and yet have average total annual energy bills?
No, I can't, which is why I raised it in my testimony. I did not prepare this document.
Okay. All right, that's an issue you raised in your testimony, and as was a discrepancy?
Yes.
Okay, thank you. Mr. Singletary, you've said that you support staff's audit adjustments except where otherwise noted, correct?
Yes, I believe that's what my testimony says.
Okay. If staff abandons disallowances it originally proposed, are you likewise walking away from your support for those disallowances?
Not necessarily, no.
Ms. Probst has removed staff's adjustment 13 related to O&M account 921 for office supplies and expenses. This is discussed at Surrebuttal PSC Probst page 2. Are you withdrawing your support for that adjustment?
I did not testify specifically with respect to that adjustment in detail. I believe the portion of my testimony you're referring to where I stated my support for staff's audit adjustments sort of generally was based off of the information that Ms. Probst put in her direct testimony. I have not since subsequently sort of opined on those adjustments. If staff has provided additional information in its testimony supporting why it has changed its position on specific revenue requirement adjustments, I believe the commission can then take that into consideration in arriving at a final revenue requirement, just in the same way that it would consider my testimony with whatever weight it decides.
Okay, have you reviewed Ms. Probst's surrebuttal testimony?
I have.
Okay, and do you have any opinion about whether she's correct or not in abandoning adjustment 13?
Not without reviewing that specific portion of her testimony. Feel free to forgive me. There's a lot going on in here that I've been testifying on.
Yeah, sure. So we've got it up on the screen in front of us.
Okay. And are you specifically referring to, I believe you said, the office supplies and expenses, which she discusses between lines 10 and 20. Is that correct?
That's right.
Okay. So reading Ms. Probst's testimony in this instance regarding this issue at this spot, and actually going back and looking at Mr. Zagance's rebuttal, because she bases her change off of his rebuttal. And I'm recalling now that my understanding is this is related to an accounting practice. And so I would not have any reason to disagree with Ms. Probst's conclusion here, but I am also not an accountant, so.
Thank you. Could you please turn your attention to page 5 of your rebuttal testimony, specifically starting on line 17?
I'm there.
Okay. And here you're talking about the company's headcount generally, right?
Correct, yes.
Okay. And one of your proposals is that if the commission approves funding for headcount above the staff's audit adjusted number, it could be subject to escrow accounting in the test years, right?
Yes, but I do want to clarify, just in case I used the wrong accounting terminology. My intention was that if the commission approved an increase in the revenue requirements to reflect an increase in the headcounts above staff's audit adjusted levels, that those funds be subject to refund if they were not, if the company did not fill those positions.
Okay, understood. If the utilities headcount is subject to escrow accounting treatment, why should the revenue requirement be limited to only 25% of the company's requested amount as you propose?
The 25% number I suggested was my attempt at what I'll call gradualism in this area is, staff's testimony speaks for itself as to how it arrived at the number, and why it, adjusted the headcounts to the level it was to reflect basically a historic headcount, I believe, as of sometime this spring. And so I do not have a magic number, but somewhere between 100% of the companies ask above the audited number and nothing. My thought was that, 25% would be a reasonable number to essentially, put back to, build into the revenue requirement headroom for the company to, make those additional hires with less concern about its impact on earnings.
You've said generally that you support having the utility be fully staffed as necessary to provide safe and reliable service to its customers, right?
I think the wording I would use would be, I fully support the company having being prudently fully staffed, and under those headcounts that the revenue requirement reflect those costs.
If unspent amounts would be refunded to customers under an escrow accounting approach, what is the point of capping the funding at a 25% level?
If I understand your question, I think what you're getting at is if it were subject to escrow accounting, then from a dollars perspective, that the commission could approve, for example, the entire requested amount requested by the company. And if it were subject to escrow accounting, then the impact would be, I'll call it the same in principle. If that's what your question is driving at, then from an accounting perspective, based, again, I'm not an accountant, but from a revenue requirement impact perspective down the road, then it would be the same. The reason I put in a specific number was to reflect at least a general regulatory principle that, that we try not to write blank checks, to use that term. And so, I don't disagree. Again, this is all coming from the perspective of I don't have any reason to disagree with the reason that staff arrived at its head count. But essentially, if I wanted to give the company somewhat of a benefit of the doubt on the amount that it believes it needs in terms of staffing and the number of staff that it can actually hire and retain during the test years, that rather than just making it uncapped, that putting a specific number on that would again build into revenue requirement an amount for increased staffing and allow the company to demonstrate that it can actually hire and retain increased staffing levels over time.
You don't understand the company's proposed headcount funding level to be uncapped, do you? The company is proposing a specific funding level for headcount, right?
Objection, Your Honor. If Attorney Wilson could distinguish between FTEs and headcounts, I think that he's talking about FTEs.
Yeah, they mean the same thing.
I think in some contexts, headcount is considered actual numbers of employees.
Okay, if you could define your terms when you're asking a question. Let's just leave it at that.
Okay. Maybe it's easier to talk about the funding level for employees at WPSC. And if I refer to that, do you understand what I'm talking about, Mr. Singletary?
I do.
Okay. And WPSC's requested revenue requirement for employees at WPSC is not uncapped, right?
As built into any particular revenue requirement, no.
Would you agree that the revenue requirement you are proposing in your testimony is if the bookends are the company's revenue requirement and staff's audit adjusted revenue requirement, yours is 75% less than the company's, right?
With respect to this specific issue, yes.
Okay. So both are caps. Yours is just less than the company's, right?
I'll try not to parse that too much. Yes, essentially.
Okay, thank you. When you're do you differentiate between when you're considering employment revenue requirement, do you differentiate between filling positions and attrition from retirements or other voluntary departure by employees?
The way I approached this issue was by thinking in terms of total headcount, total FTEs, positions that the company has filled at any one point in time, which would reflect both hirings and, attrition through retirement or through whatever means, and whatever those staffing levels are at any given point in time. So it would reflect both. And the basis at least at a high level for staff's audit numbers were the sort of total staffing numbers that the company has had historically and up until the beginning part of this year.
In this context, do you understand headcount and FTE to be effectively interchangeable terms?
We can do that until such time that the distinction is important. Sure.
Thank you. Switching topics, you propose that the commission should disallow any return on the undepreciated book balance for Columbia 1 and 2, right?
Yes.
The Wisconsin Commission has never disallowed return on retired plant, to your knowledge, right?
I want to answer your question completely, but honestly and under oath here, nothing, no, in the sense that I can point to specific orders. I do have a recollection from when I worked on commission staff of a retired, I believe it might have been a wind facility that was moved into a reg asset and was amortized without the traditional return, but I cannot point to a specific citation for that.
So you didn't cite that in your testimony, right?
Correct. No, but you asked me, am I aware of any instance? So I am attempting to answer your question completely here.
As you were preparing your testimony, did you look for that example?
I did.
And you weren't able to find it?
No, because not everything is available on IRF and easily found, depending on how you're searching.
Did you talk to anybody and pick their brains about what decision that might have been?
I have done so in the past, and I have gotten similar. I seem to recall that, but I can't point to something specific. So,
okay, can you tell us everything you've done to try to locate that past instance, because this is kind of important.
Objection. I think this is a bit argumentative. To ask the witness to flesh out exactly what he did to answer the question in the way that Attorney Wilson has asked it.
Your response?
I'm asking him to tell us how he's researched a decision that he seems to vaguely remember on a very central point in this case, for which he's raised examples from other states, but not from Wisconsin. One of the central claims that my client has made in this case is that this has never been done in Wisconsin. Mr. Singletary started to tell us about the things he's tried to do to identify what this prior situation may have been, and I'm trying to exhaust the lengths he may have gone to identify what this may or may not have been.
Go ahead. Go ahead. No, go ahead, Attorney Farrell. You look like
Insofar as he already asked and as he already answered the question, I do believe it's asked and answered.
Yeah, I agree. Sustained. Let's move on.
Have you told us everything you've done to try to identify this prior decision by the commission?
Asked and answered.
He has not answered that question.
That's true. Go ahead.
All right.
Yeah.
No, and I don't know if I would recall every specific thing, because this is an issue that the issue of recovery of not necessarily large coal plants, but any kind of stranded asset is an issue that has come up in various contexts during my 14 years working in the utility industry in Wisconsin, going back to when I was on commission staff. which is where I was originally, where I'd originally heard of it. But at this point, like I said, I don't recall every specific instance of every occurrence of when I may have done research on this.
Have you told us all the actions you've took that you remember as you sit here today?
Thank you.
I have performed searches on obviously the Commission's electronic regulatory filing system. I have performed searches on the Commission's electronic regulatory filing system archive. Not now, obviously, because I no longer have access to that, but when I was a member of Commission staff. I have attempted to search using publicly available legal search tools. I believe it was LexisNexis in public libraries. And I have done general, searches online and whatnot.
And you haven't been able to locate this prior decision, correct?
No, old decisions tend to be hard to find. And again, I did not, to be clear, I did not initially offer this for this reason.
Yes.
And
I think that's he's not offering this, so let's drop it now. I think we have enough.
Nope.
Okay, any other questions?
Yep, I've got more questions.
Bye.
Would you agree that you're asking the Wisconsin Commission to break new ground in terms of its accounting treatment of retired plant with respect to Columbia 1 and 2, putting aside the decision that you recall?
if we were talking about Wisconsin specific decisions, yes.
I'd like to talk a little bit about the company's forestry efforts. Your rebuttal testimony, you discussed your evaluation of the company's request for increased funding for forestry activities at pages 11 through 13, right?
Sorry, I believe you're referring to my rebuttal.
Yeah, that's right. Just orienting us in the testimony.
Okay. Yeah, I did testify on that. Yes.
And ultimately, you adopt the staff's recommendation that the revenue requirement should be based on the 3-year average for forestry costs, right?
Yes.
Your discussion appears to be largely a recitation of the staff's analysis on the issue. Did you conduct any independent analysis on forestry or rely on staff's analysis?
I primarily relied on staff's analysis, as I indicated was my intent in direct.
Okay. Were any elements of your analysis independent?
No.
You agree that dead or dying trees outside of WPSC's distribution lines can cause power outages, right?
Yes.
Mr. Megna testified about more frequent and severe winter and summer storms in this case generally, right?
I seem to recall something along those lines, yes.
And do you agree as a general proposition that as a result of climate change, storms in Wisconsin are becoming more frequent and severe?
I believe so, yes.
Do you believe climate change is occurring?
Yes.
And do you believe that small changes in average temperatures can lead to large changes in the number of storms and weather events?
Yes.
And do you believe that climate change is having an impact in Wisconsin in terms of more severe storms?
Yes.
And do you believe that it's leading to more extreme temperatures?
That is what the evidence suggests, yes. Not the evidence in this proceeding, but general scientific evidence, yes.
Do you believe that climate change is impacting the ways in which electricity reaches homes and businesses here in Wisconsin, for example, that transmission and distribution lines are prone to damage.
I'm sorry, Mr. Wilson, you broke up for me there. Do you believe that climate, and then you broke up? I
Yeah,
apologize.
climate change is impacting the ways in which electricity reaches homes and businesses in Wisconsin. For example, that transmission and distribution lines are prone to damage more frequently during extreme weather.
I would agree that climate change is creating a situation where severe storms are likely to occur more often. I would say that the fact that transmission and distribution lines can be damaged by trees is not a new problem. It's just that the storm problem, the frequency and severity of storms is affected by climate change.
And do you believe that the frequency and severity of storms will pose significant challenges for utilities in Wisconsin in terms of storm restoration, duration, and cost?
Objection. This calls for speculation that really is beyond Mr. Singletary's technical expertise and his testimony.
I don't think it is beyond the scope of his testimony. He's testifying about forestry costs. This is one of the two sort of pillars of the company's request for increased funding for forestry, and I'm trying to establish the extent to which Mr. Singletary agrees with the basis for the company's request for increased funding.
Okay, I'll let it continue. I think we can hand the Cub can always ask some redirect questions about this. But I don't see witness Singletary as having qualifications in this field, but we'll see what I can accept his answers to the extent, and the commission can view them for what they're worth. So we have a pending question. Let's read it back.
My mouse is not working. Sorry. Do you believe that the frequency and severity of storms will pose? I'm sorry. Significant challenges for utilities in Wisconsin in terms of storm restoration, duration, and cost?
If we're talking about Wisconsin generally, yes, but the impact by utility will vary based off of the company's system, how it's designed, and things like the amount of overground and undergrounded lines and a lot of other factors.
All right. Mr. Singletary, I'd like to ask you a few questions just about the other pillar of the company's request for increased funding, which is the spread of emerald ash borer. Could we pull up WPSC Magna 1? Mr. Singletary, are you familiar with this exhibit?
Yes, I did review it.
Okay. On this exhibit, on the left-hand column there, it says EAB, that's emerald ash borer, is very effective at finding and killing ornamental and forest ash. The pest is expected to cause more than 99% mortality of susceptible Wisconsin species. Did I read that correctly?
You did read that correctly if we ignore the parenthetical, yes.
Thank you. Thanks for not making me read the Latin. And this is the DNR's fact sheet on Emerald Ash Borer. Do you have any reason to disagree with the DNR's assessment in this regard?
From an entomology and botany perspective, no.
The same section states that dead branches and trunks are structurally weakened by EAB infestation and can become a safety hazard, right?
That's what it says.
And you don't have any reason to disagree with that, do you?
No.
A timely tree trimming cycle can help maintain trees before they become too intrusive to nearby power lines, right?
Yes.
The longer a tree trimming cycle is, the longer those trees go without maintenance. Is that your understanding?
I'll agree to that generally, yes.
And Mr. Megna in this case has explained that WPSC's tree trimming cycle has grown too long effectively, right?
I seem to recall that, yes.
And he's explained specifically that mild winters and warm, wet conditions have contributed to more tree growth, right?
That sounds about right, yes.
Yep. And you don't have any reason to disagree with those statements, do you?
No, again, in terms of general botany, no.
You do have any basis to disagree with Mr. Megna's testimony that it's not feasible to maintain WPSCs or to achieve, excuse me, I'll start over. Do you have any basis to disagree with Mr. Megna's assertion that it's not possible to achieve WPSC's optimal tree trimming cycle without the increased funding being requested in this case?
Well, that's sort of the central issue around, I believe, both staff's testimony and mine, is that there is the question of whether or not there's enough evidence in the record to support the conclusion that the company's total forestry spending, which would include things like addressing EAB and some of the other forestry related issues we were talking about earlier on reliability, if the total spend, including the increase that the company is seeking, is reasonably reflective of evidence showing that the total forestry work the company needs to do supports that.
And do you have any basis to dispute Mr. Megna's assertion that, in fact, the company can't achieve its optimal tree trimming cycle without the increased funding being requested in this case?
From my perspective, I don't have enough evidence to come to that conclusion, other than I don't disagree that this specific aspect of the company's forestry activities is experiencing increased costs. The part that I am not, I don't have enough information to come to a conclusion on, which is why I basically raised the question of is there enough evidence to support the request, is whether or not that increase for these specific items we're talking about within the context of the broader forestry spend by the company warrants the requested increase.
Nothing further.
You're on mute, Judge.
Other cross. Nobody? Did you hear me that time? All right. Redirect?
No redirect.
Okay. Great. You're excused. Thanks very much.
Thank you.
Okay, Cub calls Dr. Steve Keim. You there?
There he is. Raise your right hand. Do you swear or affirm? Tell the truth, the whole truth, nothing but the truth?
I do.
All right, go ahead.
Please state your name for the record.
Stephen Keim.
Dr. Keim, in this proceeding, did you prepare and cause to be filed direct testimony, rebuttal, sir rebuttal, and 4 exhibits?
I did.
And do you have a correction to your exhibit 1?
Yes, I do. Your Honor, I don't know if you want to pull this up on the screen or if you just want me to tell people what it is.
Both.
Okay. All right. So exhibit 1 on schedule 8, which is a value line, a screenshot of a value. No, exhibit 1. That's exhibit 3, I believe.
How's that look?
It's Tom's. Excuse me, Your Honor.
Oh my goodness.
Okay.
Getting late.
Well, that's right. 3rd time's the charm, I'm sure.
We'll see.
Yeah. Keim exhibit 1. Yes, that's it. Okay. So if you scroll down, please, to Schedule 8, and if we look at Schedules 8 and 9, they're actually duplicates of each other. So Schedule 8 says Avista Corp, and Schedule 9 is exactly the same. That Schedule 8 should be Duke Energy, so it should be a value line sheet for Duke. I refer to Duke and Avista in my testimony, but I inadvertently put Avista in there too. So all I have to do is replace that screenshot with Duke Energy.
Okay. Is there any objections to that?
Your Honor, applicant does not object.
All right, thanks. All right, so go ahead and do that for the refiling deadline, please.
Thank you, Your Honor.
All right, so given that correction to exhibit 1, is your testimony and the information contained in your 4 exhibits true and correct to the best of your knowledge?
Yes.
And do you have anything you'd like to add to your testimony at this time?
No.
The witness is available.
All right, any questions? Start with the applicant.
No questions from applicant, Your Honor.
Oh, okay. Oh, see, I'm doing content again. That's why. All right, nothing from the applicant. Anyone else?
Your Honor, commission staff just has one quick question.
Sure, go ahead.
Dr. Keim, did you review the sir rebuttal of applicant witness Bulkley?
Just introduce yourself to the witness. Sorry.
I'm sorry. Attorney Evan White's on behalf of the commission.
Yeah. Mr. Whites, you know, we had this 1 hour to review things. So I did look at it. I read it. And so I have familiarity with it, but I would normally take, I understand the constraint we have. I would normally take more than an hour, but I did look at it.
I just had one specific question. If we could pull up the sir of witness Bulkley, page 9. And then lines 6 through 14, there's a specific question. If you've had a chance to take a look at that, see if you had any comment on that.
Let me just quickly review it again. Well, I submitted an exhibit in this proceeding, which would be exhibit 3, which shows that historical average of stock prices is a bad way to go. They're inaccurate, they're more volatile, the errors are more volatile. So to the extent that this testimony is trying to support averaging of stock prices, this is a very technical point, but I'm going to use just a little bit of technical language. Stock prices are known as a non-stationary series. That means there's no natural mean. Wherever the price is today, that's the best price going forward. So if you look backwards, you're just going to make your estimate worse. Now, there's more than that in that question. So I don't know if I addressed your question, because there's more than just the average of prices. Did I respond to your question?
My question was just if you had anything to add to that. So.
Yeah, for example, Ms. Buckley says, oh, he's average GDP. Well, GDP is a stationary series. And stationary doesn't mean what common people think. It means it's growing at a fairly fixed mean, where stock prices move randomly from point to point. So you should average stationary series, and you should not average non-stationary series. So my testimony is actually completely consistent with the financial evidence.
Thank you. I don't have anything else.
Okay. So any other cross? Redirect?
Yeah, I'll just ask, since Attorney White's brought up Ms. Buckley's sir. Dr. Keim, is there anything in Ms. Buckley's sir rebuttal testimony?
Your Honor, can I just object to this? Just because the staff attorney had one question about one piece of the sir does not open the door to some sort of open-ended critique of the sir.
Okay, I do agree. If this is related to the issue that Attorney White's the commission staff raised, then you can redirect from that point, but we can't go back to the opportunity to make your statement on what was filed previously to the witness's appearance. So,
does anything in that particular section of Ms. Buckley's sir rebuttal change your conclusions regarding the recommended ROE and capital structure?
No.
Yeah, and just so everyone knows, like, the way the rules work, you don't need to disclaim, or you only need to state where you do agree now, or you change your position. It's understood, it's implicit, and it's ordered that failure or silence does not indicate consent in terms of the rounds of testimony and as they develop. So that question is, hopefully we all agree on that. We all understand that. So it's not technically necessary, but I appreciate you asking that. But it's we're all supposed to operate under the assumption that unless you retract a position based on what you've heard from someone else, you maintain your original position or your most current position. That's how we operate. We've tried to do that as far as I can remember. So, so no more questions for the witness. You're excused. Thanks very much.
Thank you, Your Honor.
All right. Okay, so that's Cubs witnesses. And move forward. We have so let's go off the record for a second. So I just wanted to mention, so I did review another exhibit now that this exhibit got up long enough, I noticed that you guys, when you refile this, you just need to take off the exhibit designation on the original document. That's part of our standard procedure. I just have it on the
cover page.
Yeah.
Thank you, Your Honor. Yeah, we will take that off.
Mm-hmm. Okay, so I can't remember, we're off the record. Did we swear in Tetzloff and enter that? I know I talked to him at the beginning, but I don't remember if we actually.
My memory is we didn't, Your Honor, but that's certainly subject to correction at 4:30.
Yeah, that's okay. So I knew he did appear. I think he had no cross. I don't know if we excused him in terms of filing an affidavit, but so this is a little tricky situation. I think in the past, he had not appeared, and actually did not accept the testimony. But in this case, I know he did show up. So let's just, if we can communicate to him, if we can have Attorney White's, I don't think he's here right now. So Attorney White, if you just can communicate to him to have an affidavit filed to verify that testimony, that would be helpful.
Sure, I can send that email after the hearing.
Okay, yeah, thanks. All right, so yeah, that's my, yeah, not remembering here. So let's move on, get on the record for renew.
Your Honor, it's our intent to verify by affidavit.
Okay, yeah, I think my notes got erased again. I don't know what's going on here. Okay, and Sierra Club.
Yes, Your Honor. We'd like to call witness Lucy Metz to the stand.
Okay, I see you there. Swear you in, raise your right hand. Do you swear or affirm, tell the truth, the whole truth, nothing but the truth? And can't hear you.
Can you hear me now?
Yes, the volume's a little low, so maybe just putting that microphone closer, or
Okay, I'll make sure to speak up.
that's better. Okay, perfect. All right, go ahead. You can introduce your witness.
Oh, Your Honor, can we go off the record a second? I have a quick administrative question to ask.
Oh, we can try it. Yeah, go ahead.
Okay, so you suggested the addition of 2 additional exhibits. Ms. Metz has not yet filed them, so I'm not quite sure how to ask her to attest to the truthfulness of their contents, given that they're yet to be filed. Do you have any suggestions for how to handle that?
Just assume they are. So we have those exhibits are marked 34 and 35. And for some reason, I don't know what happened to all the changes I had made earlier. They're gone. Yeah, so so I have your 35 and 36 for surrebuttal, and 34 and 33 and 34 are the documents that I was asking to be filed. So
there's also a 37 on surrebuttal, just.
There is, you're right. So if we could include all 37 in the verification, the 33 and 34, if people weren't.
Are you still off the record?
Yeah, we can
okay.
33 and 34, what we're intending there is to file the application filing letter revised, and then the specific pages of the Federal Register. So what we can, if you could just verify that with the witness when you're doing the verifications, so that we're all on the same page on the record, that would be useful. But yeah, let's assume they are in. I don't think would be any controversy to the two new, well, they're not really new. The two documents I'm making you put in, but and the surrebuttal, I guess we'll see, but so far I haven't heard anything. So, okay, so does that make sense? Are you on?
Yeah, so just treat it as if they're all in already and ask about exhibits 1 through 37.
Right, and then we just need to have her describe 33 and 34 for the record.
Okay.
Very briefly.
Thank you.
Okay, all right, so let's get back on. So it's your witness, Attorney Watchpress.
Thank you. Ms. Metz, could you state your name for the record, please?
Lucy Metz.
And who is your employer, Ms. Metz?
Synapse Energy Economics.
In this proceeding, did you file or cause to be filed direct and surrebuttal testimony?
Yes, I did.
Did you file or cause to be filed 37 additional exhibits in this proceeding?
Yes, I did.
And I understand 2 of those exhibits, Exhibit 33 and 34, have yet to be formally submitted into the record. Can you provide a brief description of those exhibits?
Yes, I can. 33 is the filing letter that is linked there, and 34 is a section of the Federal Register.
Thank you. If I asked you the same questions that are set forth in your direct and sir rebuttal testimony today, would you provide the same responses?
Yes, I would.
Is your testimony true and correct to the best of your knowledge?
Yes, it is.
Are the exhibits you submitted true and correct to the best of your knowledge?
Yes, they are.
Is there anything you would like to update or correct in your testimony as filed?
No, there is not.
I present the witness for cross-examination. Thank you.
Okay, any questions?
Yes, Your Honor. Applicant has questions.
Okay, go ahead.
Good afternoon, Ms. Metz. I'm attorney Patrick Proctor Brown of Quarles and Brady representing the applicant. We haven't met before today, right?
No, we have not.
And Your Honor, if you could bring up exhibit SC Metz 1. So Ms. Metz, this is a copy of your resume, correct?
That's correct.
You graduated from undergrad in May 2022, is that correct?
Yes, I received a Bachelor of Science in Engineering Science in 2022.
You don't have a degree in economics?
That's correct.
You don't have a degree in public policy?
No, I have a degree in Engineering Science.
You joined Synapse as a research associate in July 2022, just 2 months after you graduated from undergrad, correct?
That's correct.
And you've been at Synapse for the past 2 years?
That's correct.
You've never worked for a utility with an obligation to serve load?
No, although I will say that often in the course of our work at Synapse, we're putting ourselves in the shoes of utilities who are making decisions about whether and when to retire and replace legacy units.
Have you ever put yourself in the shoes of a utility?
Yes, over the course of my work at Synapse, I've worked in nearly a dozen utility jurisdictions, analyzing issues related to integrated resource planning and power plant economics.
And always while being supervised by somebody at Synapse with more education and more experience than you, isn't that true?
Objection. Lacks foundation.
Sustained.
You just testified that you've been in 12 proceedings. You are not leading that testimony in those 12 proceedings, correct?
Last spring, I did submit panel testimony in Georgia critiquing Georgia Power Company's 2023 IRP update. But you're correct that we often work in teams at Synapse.
Right, and you've never been the senior person on that team until this docket, correct?
That's correct.
So in all of your other cases, you've been supervised by somebody with more experience and more education than you, correct?
Objection. Again, calls for speculation.
She was on the teams.
Oh, sorry.
She knows
I'm sorry.
that
I lacks foundation. Excuse me. It's late in the day. I apologize. Lacks foundation.
Sustained.
I think I just laid the foundation, but I'm happy to lay more. You're aware of everybody that worked on the teams and the 12 matters you've been a part of, correct?
I'm not sure I understand your question.
Right. So you've testified that you worked on teams at Synapse and have participated in testimony in 12 matters. Is that an accurate statement of your testimony?
I have worked on teams and I have worked on comments and testimony in nearly 12 jurisdictions. Not all of those were testimony projects.
Okay, so of those 12 projects total, you're aware of who you worked with on those teams at Synapse, correct?
Yes.
Okay, and the supervisor of those teams, you're aware of their experience and education, correct?
Correct.
Do they have more or less experience than you?
Does the senior person on the team have more or less experience than me?
Yes.
More.
Do they have more or less education than you, the senior person on the team?
More.
Thank you. You've never dispatched a power plant, correct?
That's correct.
You've never worked for an independent system operator like MISO?
That's correct.
You've never submitted generation resources to MISO?
That's correct.
You aren't a member of any MISO stakeholder committees?
That's correct.
What are FTRs?
I am not sure.
Objection. Vague.
Where do you see FTR? Is this on the exhibit 1 or somewhere else?
It's a component of MISO revenues, and I just wanted to understand if she knew what it was. And she
Okay.
doesn't, so that's fair.
Your Honor, that's mischaracterizing the testimony. FTR could mean anything. He has to at least specify some context for asking about an acronym.
It was in the context of other questions related to MISO. I think I got the answer that I need. If you want to redirect her on it, that's your prerogative.
Okay, continue.
Prior to your testimony in this docket, you have not testified in Wisconsin Public Service Commission proceeding, correct?
No, as I mentioned, I submitted testimony last spring in Georgia.
And that's the only testimony you've submitted to any public service commission, correct?
That's correct.
And have you ever supported testimony in connection with the Wisconsin Public Service Commission proceeding?
No.
And I think you just mentioned this. The only other testimony you submitted to a public utility commission was in conjunction with Debbie Glick, who is a senior principal at Synapse. Would you agree with that statement?
That's correct.
Did you provide any live testimony yourself?
Yes.
So you were cross-examined on the stand in the Georgia proceeding?
No, but I was on the stand.
Okay, so you testified to verify your pre-filed written testimony before the Georgia Public Service Commission. Is that an accurate statement?
Yes, that's correct.
You didn't provide any additional direct testimony on the stand before the Georgia Public Utility Commission. Is that true?
That's correct.
And so the only thing that you presented to the Georgia Public Service Commission is what you called panel testimony in conjunction with Ms. Glick, correct?
That's correct.
And that was jointly drafted between you and Ms. Glick?
Yes.
And it related to Georgia Power Company's 2023 IRP, correct?
Yes, their 2023 IRP update.
Georgia has a statutory requirement for its public utilities to submit IRPs, correct?
I believe so, yes.
How often are public utilities in Georgia required to submit IRPs?
I don't know that off the top of my head.
Georgia is not a part of MISO, correct?
No, it's not.
Have you ever developed an IRP for a utility?
No, I have not.
Have you ever developed an all-resource RFP for a utility?
No.
Have you ever submitted a proposal to an all-resource RFP?
No, I have not.
Have you ever used Plexos to analyze the least cost expansion plan for a utility?
I'm sorry, to analyze
To analyze the least cost expansion plan for a utility.
Thank you.
Synapse uses Encompass, so no, I don't have direct experience running Plexos.
And you haven't used Encompass to develop the least cost plan for utility either, correct?
No, but I have used Encompass in the Dominion 2023 IRP update as a comparison to the utilities IRP modeling results.
Yeah. Setting aside your testimony in this docket, have you done any work at all related to renewable generation in Wisconsin?
This is the first case that I've worked on in Wisconsin.
Right. You have no other project, no other experience with renewable generation in Wisconsin besides the testimony that you've submitted to the commission. True?
That's correct.
Have you reviewed the MISO interconnection queue for Zone 2 in MISO?
I have reviewed the interconnection queue, not specifically for Zone 2,
Which zones have you reviewed it for?
for MISO as a whole.
So you looked at all projects within the MISO interconnection queue?
Yes.
That's hundreds, if not thousands of projects, correct?
I reviewed summary data. I didn't read about the details of every project in the queue.
And you weren't looking for projects in Zone 2, correct?
No, this was actually for a different proceeding.
Okay, so you haven't reviewed the MISO interconnection queue with respect to your testimony in this case at all. Is that true?
No, I have not.
Have you helped submit an interconnection request to MISO?
No.
Do you know how long it takes for MISO to approve an interconnection request?
My understanding is that that varies based on the project,
It can take years, right?
depending on the project. Yes, I believe that's correct.
And you reviewed the testimony of Mr. Hawley and Mr. Arndt, correct?
That's correct.
That includes the biographical information in their testimony?
Yes.
You would agree Tom Hawley has much more experience than you in developing daily operating plans to economically and reliably dispatch power plants?
Objection. Relevance.
Goes to the credibility of the two witnesses, Your Honor.
Credibility of pub services witness?
The witnesses that she's criticized in her testimony? Yes.
She's
Yeah.
not offering testimony on the operational choices that WPSC made, which Mr. Hawley is responsible for. And Mr. Hawley disavowed any knowledge of planning processes.
I think she has offered testimony on how we operate Weston 3 and Weston 4, but I can withdraw the question. That's fine.
Okay, that's fine.
You would agree that Jody Arndt has much more experience than you conducting long-term resource planning, right?
Jody Arndt has been at WPS for many years, but what I bring is a breadth of experience looking at multiple utilities and their best practices across the country.
You think you have a breadth of experience in the 2 years that you've worked on 12 projects? Is that your testimony? Okay,
yes.
Thank you. I want to move on to some of your testimony related to Weston 3. You opine in your testimony that replacing Weston 3 and 4 with alternative generation would likely save ratepayers money. And the site for that is Direct SC Mets 10 if you want to go to it.
Thanks, let me get there. Okay.
So I believe it is. Yeah, it's the point number 6 at the top of the page. That's your opinion, right? Replacing Weston 3 and 4 with alternative generation would likely save ratepayers money, correct?
That is my finding based on an analysis of the company's data.
Okay, do you identify any alternative generation project in Wisconsin in your testimony that will be online in test year 2025?
In fact, one of the recommendations that I make is that WPSC needs to test the market and find out what resources are available, because despite the declining and negative net revenue of the unit, the company took no action to issue RFPs or to find out what alternatives could be available to it. And that failure is now costing ratepayers money.
So Your Honor, I'd actually move to strike as non-responsive.
Okay. I'm not going to do that, but go on.
Thank you. Could you answer my question, though? Do you identify any alternative generation in Wisconsin that would be online in test year 2025? And I don't need you to recite anything else. Just want to answer to my question.
Objection. Vague as to time period.
I said in 2025. I'm not sure what more specificity you need than that.
Well, when are we asking about the availability of resources?
That has nothing to do with my question. So we can have it read it back.
Yeah, let's read it back. Overrule the objection.
Question, could you answer my question though? Do you identify any alternative generation in Wisconsin that would be online in test year 2025? And I don't need you to recite anything else. I just want you to answer my question.
My recommendation is not to replace the units in 2025. And no, I do not identify specific alternatives that would be online in 2025.
Do you identify any alternative generation project in Wisconsin that would be online in test year 2026?
No, identifying specific resources that would be online during the test years is not part of my testimony.
Did you identify any alternative generation projects in Wisconsin at all?
Again, identifying specific projects is analysis that the company should be doing and is outside the scope of my testimony.
So the answer is no, you didn't identify any alternative generation projects in Wisconsin?
Correct.
Thank you. You testify that it is in ratepayers' best interest to retire Weston Unit 3 as soon as WPSC can procure replacement resources. The site for that is Direct SC Mets 26.
Thank you.
And I'll try and give you the site first next time, Your Honor. Sorry.
So I can catch up.
It is line 3. Do you see that, Ms. Metz?
Yes.
Is there any basis to that statement besides your analysis of Weston 3's net energy margin over the last 6 years?
The net energy margin, or the net revenue margin, which I should clarify also includes the capacity value of Weston 3, is the major source of that statement. But reliance on Weston 3 also poses other risks that I describe in my testimony. For example, future environmental regulation and current contraction in the coal market in the US.
And those are qualitative analyses that you have in your testimony, but you don't quantify those risks. Is that fair?
No, the major quantified risk is that ratepayers are paying more than they need to be for the capacity and energy services that Weston 3 is providing.
But you don't conduct any forward-looking analysis or projection in the test years or beyond the test years, what you call the net energy margin, net revenue margin, right?
No, my recommendation is that based on the historical performance of the units, that declining and negative performance should have triggered WPSC to perform a forward-going alternatives analysis, which it hasn't done at any point in the past 10 years.
You don't identify when WPSC can procure replacement resources, do you?
No, as I said before, WPSC failed to issue any RFPs for replacement resources, despite that period of sustained negative net revenue from 2018 to 2020 at Weston 3.
And we can read your testimony, Ms. Metz. A lot of these are yes or no questions, and it would speed this along if you didn't kind of tell us the testimony that's already in the record. Can you do that for me, please?
Your Honor, can we have a little, sorry, could we be a little bit more respectful of the witness, please? Thank you.
Yeah,
that was very respectful, but
I don't think what he's saying is inaccurate. I think the testimony speaks for itself, and the position of Sierra Club is clear by the testimony. So I think it's in the record, and no one's disputing that it exists for the commission to read. So and this is this is something we can say of all the witnesses. So don't mean to pick on one in particular, but since it's been raised here, I think it's useful for everyone to understand that if it's in the record, it's going to be available to the commission, and answering the cross questions as succinctly and efficiently as possible helps us. And then if clarification needs to be made on redirect by the party's attorney, the witness's party's attorney, then there's an opportunity to do that. So, but I think I know where the witness has been explaining. I think we understand her position in terms of her view of the case. And I think the questions that the applicant's raising are fair, but the answers could be a little more succinct. That's fine. It's a pretty fine point to make at this point, and especially listening to all the other cross-examination we've had, but it's a true point. So let's proceed with that in mind.
Thank you, Your Honor. Did you conduct any analysis of when during the year Weston 3 operates?
I did, but I believe that data is confidential.
Okay, we can move on. Have you conducted any alternatives analysis of MISO prices without Weston 3?
I'm sorry, with alternative analysis I shouldn't say. Have you conducted any alternatives analysis of?
MISO prices without Weston 3. Sorry.
Thank you. That's okay.
To do that analysis, one needs to have the full system data, which only WPSC itself has.
You would agree that system data in MISO is actually available to numerous actors within the MISO system, right?
Yes.
So it's not an accurate statement to say that only WPSC has data about MISO prices. Wouldn't you agree with that?
I would. So perhaps I'll just say that doing this very detailed analysis was outside the scope of my testimony.
That's fair. You would agree that if Weston 3 retired, then everything else equal, MISO prices would go up, right?
I think this is kind of an irrelevant question because you wouldn't retire the unit without replacing it.
I think that the statement is true because you are talking about having a power plant replace it at the Weston site or close to it. And so you would typically stage a retirement, right? But in any event, it's a hypothetical question for you. If Weston 3 retires, MISO prices, all else equal, would go up, right?
Yes, that's correct.
You have not analyzed whether WPSC could reliably provide power to its customers on the coldest days of the year without Weston 3, correct?
This is the type of detailed reliability analysis that WPSC needs to be completing. And no, that is not part of my testimony.
Thank you. You would agree that weather in Wisconsin is different than weather in Georgia?
Yes.
I know it happened while you were an undergrad, but do you know anything about Winter Storm Uri?
Objection vague? What
It's
do
a
you know?
named storm. Does she know anything about Winter Storm Uri?
Do I know anything about Winter Storm Uri? Yes.
Okay. Are you aware that that the storm caused blackouts for over 9.9 million people?
Subject to check, sure.
Are you
I'm
aware
sorry.
that the
I'm sorry. Say it again, ma'am.
Subject to check, sure. Sounds about right.
Are you aware that the storm killed hundreds of people, many who died because they lacked electricity and heat in Texas?
Objection. Lack of relevance, foundation. I don't know why we're talking about a storm in Texas for purposes of this cross-examination about WPSC's rates.
Because it was a major event within the utility industry and has caused organizations like NERC, MISO, and other regulators to redouble their efforts towards reliability. It's cited in multiple pieces of testimony at FERC and in other places for the new rules within MISO, and it's a framing event for the industry and how they plan for resource generation. So she's aware of it, and I think I have like 6 questions on it.
Your Honor,
it's relevant to the testimony in this case.
That doesn't address the foundation argument. The attorney just testified to his opinion as to the significance of an event and its relevance to this case. None of the witnesses for WPSC has brought in Winter Storm Uri, and again, given 2 opportunities in rebuttal and surrebuttal, did not bring this up. And so why are we now talking about it where the attorney gets to make assertions about its causes and subsequent events without any test in the record or evidence?
Because I was arguing the objection. That's not the question posed to the witness. My questions are going to be much more targeted than that.
Everybody take a breath. Do we raise the issue of Winter Storm Uri in testimony?
Not specifically, Your Honor. It is raised in other places, particularly within our generation resource plan, which the witness testifies about. And it's certainly raised in some of the documents that are quoted by Mr. Arndt. And again, it's a framing event for generation planning within MISO.
One minor point on that, Mr. Arndt did not introduce any exhibits other than the MISO document to his testimony. So to the extent he's quoting anything that may have also mentioned the Storm Uri, that's not part of the record.
I don't disagree with that. I'm saying it's part of the background to those documents. I think it's a fair question. And we've actually taken more time arguing about it than my questions were.
Well, but that's not the point. That's like saying, why bother setting a revenue requirement if you're going to have a deferral?
I understand, Your Honor. Apologies for that last comment. I'll withdraw it.
So the witness has established that she is aware of this storm, and the applicant is testing her knowledge of this storm as it relates to system planning what impact of a winter storm will have on resource planning going forward into the future. I think I'll allow this line of questioning. So go ahead. Do we have a pending question?
I think we did, but I can restate it if that's easier for everybody.
Let's read it back.
Okay.
So last, quite right before the objection, I believe.
I'm sorry, there's like a question and then he started again and I'm not clear on the question.
You want to read what you have first and we'll let you know.
Are you aware that the storm caused blackouts for over 9.9 million people subject to?
Oh, she partially answered that one. So maybe we talked over her answer.
And then I have, and I think that might be the problem. And then I have many who died because they lacked electricity and heat in Texas. So I think there might have been some crosstalk there because that's what I have.
Okay, so why don't you restate the question then?
Are you aware that the storm caused blackouts for over 9.9 million people?
I don't have the number of customer outages by winter storm memorized, so I'm not sure I can confirm this without a source.
Are you aware that the storm killed hundreds of people, many who died because they lacked electricity and heat in Texas?
Again, I don't memorize number of deaths by winter storm.
Are you aware that are you aware that temperatures only dropped to 5 degrees Fahrenheit at the coldest in Texas during Winter Storm Uri?
Objection. Where's the foundation here?
I'm testing her knowledge as I believe I was permitted to do by Judge Newmark. And if she says she's not aware of that, then she's not aware of it.
Overruled.
But this is not okay.
Did you understand the question, Ms. Metz?
I think it's relevant to note here that the power system in Texas is very different from in Wisconsin, but subject to check, I would accept that.
Okay, and on redirect, it's a perfect opportunity to present that side of your story.
And one way that they're different, right, is that winter temperatures can be 25 or 30 degrees colder during cold spells in Wisconsin. Are you aware of that?
Yes.
Have you done any analysis of whether WPSC would be able to provide reliable electricity to its customers without Weston 3 if Wisconsin experiences a severe weather event like Winter Storm Uri?
My testimony recommends that WPSC complete a detailed reliability analysis before retiring the unit, but does not itself include that reliability study.
So the answer is no. You haven't done any analysis to see if WPSC could provide reliable electricity without Weston 3 during a severe weather event like Winter Storm Uri?
That is outside the scope of my testimony.
Have you done any analysis of the cost to customers from severe weather events if WPSC retires Weston 3 early?
To the extent that Weston 3 is currently losing money, retiring it would be a benefit to ratepayers.
Except when prices escalate significantly during severe weather events. Wouldn't you agree with that?
I think there would be some more detailed analysis that would need to go into what the marginal unit is during the severe weather event to make that determination.
Right, and you haven't done that analysis, right?
No.
Do you know what an endogenous shock to supply is?
No, I do not.
Are you aware that technological changes can shift the supply curve in markets?
Yes.
Would you agree that the fracking boom on the Marcellus Shale is such a technological revolution that changed the energy markets in the United States?
Yes, I would.
Do you know what optionality is?
I think that's a word that depends on the context. Can you give me some context?
Yeah, in the context of an economic analysis.
Then yes.
What is it?
Preserving the ability to pursue multiple different paths depending on how conditions change in the future.
And that preservation of different paths has a value, right?
Yes.
And you can call that option value in an economic analysis, right?
Yes.
Would you agree that new technology has the potential to change the supply of generation capacity?
Yes, it could.
Would you agree that new technology with respect to battery energy storage systems has the potential to change the way the bulk electric system works?
Yes.
Have you done anything to analyze the likelihood of new generation or storage technology reaching commercial operation between now and 2031?
Could you restate the question?
Have you done anything to analyze the likelihood of new generation or storage technology reaching commercial operation between now and 2031?
I'm going to object to that. When I asked questions of WPSC's witness about events taking place in 2031, the WPSC's objections were sustained with respect to things outside of the timeframe. And so I think a symmetrical rule should apply to Ms. Metz's testimony.
It's not a symmetrical rule in this case because option value is something that exists in the test year. What she has testified is that the test year is relevant to the future events that would occur later. But option value as relates to Weston 3 was raised in Sir rebuttal by Mr. Arndt and absolutely has to do with the economics of Weston 3 as it operates in the test year. What happened in the other case of those objections was a future construction project related to another unit that has no bearing on the test year. So it's not
a question. Go ahead.
Thank you.
Reread it back.
Question, have you done anything to analyze the likelihood of new generation or storage technology reaching commercial operation between now and 2031?
No, that's not part of my testimony.
Would you agree that if there is a chance that new technology reaches commercial viability between now and 2031, then WPSC's customers could benefit from waiting to replace Weston 3 with new generation resources?
I think we can't possibly know that because WPSC has not done any sort of alternatives analysis of Weston 3 relative to the alternatives that are available now, let alone alternatives that might become available.
Have you done anything to analyze the value of delay for WPSC's customers?
The delay is costing WPSC's customers because they're continuing having to pay high fixed costs on this unit that is earning net negative revenue.
Right, and a technological shift could change that paradigm. And in fact, you don't do any analysis of any costs beyond the test years, right?
I think it's highly likely, based on the technological shifts we're seeing now, that the grid would become less and less well suited to Weston 3 because we'll need resources that can cycle quickly and ramp up and down to balance renewables. And Weston 3 is not capable of doing that and will in fact become damaged by doing that.
Right, but you're aware that numerous companies, and including the federal government, are spending millions, if not billions of dollars researching things like long duration batteries as we sit here today, right?
Yes.
In fact, in Boston, there's an entity that's researching liquid metal batteries under the auspices of Harvard. Would you agree with that? Have you heard of that?
I mean, objection foundation, where do you have any document? Like, you're just bringing in facts.
He's asking the witness to confirm the statement. That's a fair question. I will interject though and ask, I think you said you had 6 questions for the witness.
No, I said on the Winter Storm Uri, and I've asked all those, and I've moved on to another topic. Okay. I think I have a couple more pages.
All right. So what do we have?
Are you aware of technologies like liquid metal batteries that could be long duration and could become commercially available between now and 2031?
Yes, I'm aware that long duration energy storage is nearing commercial viability.
And so by keeping Weston 3 and waiting for the commercial viability of those long duration batteries, it could be replaced with something better than what's available today, correct?
If Weston 3 can be replaced today at lower cost to ratepayers, I don't think it benefits ratepayers to wait just in case something better comes along.
Turning to Weston 4, you actually find that the unit has a positive energy margin, correct?
Marginal and declining, but positive in several of the years that I studied.
And you reviewed WPSC's forecast for Weston 4 and agree they continue to show high near-term use of the unit, correct?
Could you specify which modeling you're referring to?
Yeah, it's on page 21 and 22 of your testimony. Of your direct testimony.
Yeah, so I'll note that the gas conversion of the unit was hard-coded into this Plexos modeling.
But I'm not talking about the gas conversion time period. I'm talking about in the near term prior to the conversion, as you reference on page 21 and 22. It's actually that sentence that ends at the top of page 22.
Yes, the company's Plexos modeling shows utilization in the range of 74 to 82% in the 2020s with that gas conversion hard-coded in 2027.
So high near-term usage before the gas conversion. You agree with that?
I would need to look back at the exact trajectory of which year has which capacity factor.
You testify that the years 2021 and 2022 were driven by the impacts of the COVID-19 pandemic and the war in Ukraine. That's at page 26 of your testimony.
That's correct.
What is the basis for that statement?
Those are the major world events that were happening in those years.
In fact, the energy sector was most impacted in 2020 because of lockdowns and decreased economic activity related to COVID-19. Do you agree with that?
Yes, the COVID-19 pandemic started in 2020.
Actually, it started in 2019, which is why it's called the COVID-19 pandemic. Would you agree with that?
I don't know the origin of the name of COVID-19.
Thanks. Worldwide energy usage declined in 2020, didn't it?
I'm not sure about that.
And energy use increased in 2021 to above pre-pandemic levels, didn't it?
Subject to check.
Do you think that the COVID-19 pandemic had a positive effect on demand for electricity?
My understanding is that the pandemic generally reduced demand.
But not in 2021, right?
I'm not sure what geographic area you're talking about, and I don't have data on total energy demand off the top of my head.
Are you aware that the COVID-19 pandemic increased costs?
Of general consumer goods?
All goods. Isn't that fair?
Yes, there was inflation during the pandemic.
It was abnormal inflation caused by supply disruptions, lockdowns, lack of labor, major effects on the world economy, and an exogenous shock to supply, correct?
Yes.
And Are you aware that the COVID-19 pandemic and stimulus associated with responding to the pandemic increased inflation?
I am not an expert on the causes of inflation.
Are you aware that absent a deflationary shock like a recession, those costs will remain higher than they would be without the COVID-19 pandemic?
My testimony does not cover the causes of inflation and deflation.
Okay, but you testified that 2021 and 2022 were outlier years because of what you called major world events. Is that a fair summary of your testimony?
Yes.
But you didn't do any analysis of how those world events actually affected the energy market. True?
The war in Ukraine caused gas price spikes, which is one of the major causes of the net revenue results that we see for Weston 3 and 4 in those years.
Yeah, let's talk about the war in Ukraine. When did the war in Ukraine start?
I don't have the date off the top of my head.
In fact, it started in 2014, right?
Your Honor, what he's okay. I don't understand the relevance. I don't understand the foundation, but I'll let the witness answer.
Subject to check, yes, there's been conflict in that region for many years.
All right, the Russians invaded Crimea in 2014, right?
Correct.
Are you predicting when the Ukraine war will end?
No.
So how do you know that the Ukraine war is not going to continue to affect energy prices in Wisconsin and increase the viability of Weston 3?
Given that we saw a return to negative revenue in 2023, even as the war continues, those are the conditions that I would expect to see going forward.
Right, so you just backfilled a cause for the data that you reviewed as part of your analysis. Isn't that true?
The invasion itself caused turmoil in the gas market that has since subsided, despite the fact that there's ongoing conflict in that region.
Well, you just testified you didn't do any analysis of the energy markets related to those world events. Are you saying that now you've done some analysis in the span of 45 seconds?
No, I am not.
Thank you. Could it be what would happen if the Ukraine war escalates further?
Objection calls for speculation. How is the witness supposed to opine on geopolitics?
She opined that those two events caused increased net revenue and that those are outlier events because COVID-19 and the Ukraine war somehow only occurred in 2021 and 2022. So I'm testing her knowledge of why that's a cause of those 2 years. Fundamentally undermines her analysis.
No, I'm sustaining that objection, cause for speculation.
Could it be beneficial to WPSC's customers if there's another major event that causes an exogenous shock to natural gas supplies?
The sky could fall tomorrow, but based on the evidence we have right now of what the world is like right now, Weston 3 is losing money.
Actually, you don't know that it's losing money in 2024, do you?
No, I only have I can't have complete data for 2024 because 2024 is not over yet.
So the statement that it's currently losing money, that was an incorrect statement, right?
Weston 3 lost money in 2023.
You testify that as demand for coal decreases and the coal industry contracts and consolidates, supply will become more and more concentrated in a smaller number of customers or suppliers, I'm sorry. That's at your direct on page 33.
Okay, where would I find that?
It's line 13.
Thanks.
That's correct.
What is the basis for that statement?
the fact that 10 mines collectively owned by only 4 companies produced 87% of the coal in the Powder River Basin in 2022.
Right, and you're speculating about what the future will hold for those 10 mines and 4 companies, aren't you?
I mean, how could it be the case that as more mines close, we'll have more mine owners?
You might have the same number of mine owners, wouldn't you, Ms. Metz?
Sure, that could possibly happen for a while.
Do you have any information that the 4 companies have plans to consolidate further?
No, I don't have information specific to these companies.
And you're aware that industry consolidation is subject to antitrust protections?
Yes.
In fact, if demand is decreasing, then market power should also decrease, correct?
I don't think that's a statement you can make generally.
I think you can, because the demand market is lowering. So the suppliers will have less power to dictate prices to those customers. Wouldn't you agree with that?
Sure.
Yeah, and that's the definition of market power, is the ability to dictate prices, right?
Yes.
And as demand decreases, all else equal, prices should decrease, correct?
I'm sorry, all what prices?
As demand decreases, all else equal, prices should decrease, correct?
If you're living in a perfect microeconomics world, then yes, that is what would happen. But if there's such deep disruption in the industry caused by many, many coal units closing, then I don't think that that's a foregone conclusion.
You're presupposing that somehow there's going to be big disruptions in the industry, they consolidate and then gain market power. There's multiple steps to your speculation about the future of that industry. Would you agree with that?
Yes, I think determining what the future of the coal industry is and how market power will evolve over time is complex.
Right. And the first order effect to a decrease in demand is a decrease in price. You agree with that?
In general, yes.
So you're actually suggesting, kind of paradoxically, that a decrease in demand will cause an increase in pricing. Isn't that true?
Again, because the broader closure of coal units across the United States, there's the potential for larger disruptions in the coal mining industry.
Have you quantified that potential in any way?
No.
If the coal industry is selling less coal, that means they also need less labor and less transportation, correct?
That's correct.
So the industry as a whole become less susceptible to labor and transportation shortages, correct?
Again, supposing that these things scale evenly and that there aren't broader disruptions in the industry, you can generally say that, yes.
I want to switch gears to the benefits of an IRP. I think you testified earlier that you've heard about the shale revolution. Do you agree with that?
Yes.
Excuse
Prior
me.
to the-
Yes.
I've got a really bad hand cramp in my hand.
Oh.
Can we just take 2 minutes?
Yeah, let's take a 5-minute break.
I'm sorry.
That's okay. Just going to recess 5. How are you doing?
Good.
It's
Got a mini massage and now my hands are mentholed up. My arms. I'm sorry for the interruption.
No, not at all. Let me know if you need something else.
Dinner?
Longer break. Yeah, dinner. DoorDash. What do you want? All right. Do we have everybody we need? Let's get back to our, do we have a pending question or we were in the middle of?
No, she answered yes.
Okay.
And Your Honor, I've heard from the people in the room that they're tired of sick of me talking. So and the court reporter's probably sick of writing me down. So we'll tender the witness back. Thank you, Ms. Metz, for your patience with me. And whoever wants to ask questions next, feel free.
Okay, so we'll ask for more cross. Not hearing anything. All right, redirect.
Yeah, I just have some brief redirect.
Sure.
Hi again, Ms. Metz. Do you recall Mr. Arndt's testimony earlier today?
Yes, I do.
Your Honor, this isn't redirect, I don't believe. This is now testimony asking about testimony that occurred prior to Sierra Club's opportunity to direct their witness.
Okay, let's hear the question and then we can object.
Okay. Do you recall Mr. Arndt's testimony about whether or not he had conducted an all-in economic comparison of Weston 3 to potential replacements? Do you recall that testimony?
Objection, Your Honor. He testified prior to her opportunity to ask these questions was before my cross.
Your Honor, there was questions put to the witness about her relative qualifications to PSC or to WPSC's witnesses, and I'd like to follow up on that.
Okay, so ask a question about that.
Ms. Metz, have you, in the course of your work on IRPs, conducted an economic comparison between units and the cost of their all-in replacement?
Yes, I have.
Okay. You directed that numerous discovery requests be put to WPSC in the course of this proceeding. Is that, oh, sorry. Did you direct that any discovery requests be put to WPSC in the course of this proceeding?
Your Honor, we're back to discovery. Like this should have come out in the pre-filed testimony.
Your Honor.
I don't know where this is headed, so I'm going to let her ask. I think maybe I'm expecting we're getting to responding to the questions on our qualifications. If there's a new topic, let us know, but I think I'll allow it for now.
Counsel for WPSC asked you whether you conducted a whole set of analyses about the impact of Weston's retirement in your testimony. Is that correct?
Yes.
Okay. Did you ask WPSC if they had performed similar analyses in the course of discovery?
I did, and WPSC was unable to produce any alternative analyses that they'd done over the past 10 years, and they were unable to produce any reliability analyses with results specific to Weston 3 and Weston 4.
Your Honor, I believe that was actually in her testimony.
Yes, you're right. So we don't need to, okay. So redirect is to, cure any misconceptions or to respond to anything brought into the in-cross that you need to seek clarification for benefit of the record or rebut. But because the witness wasn't able to answer fully, that's totally fair. But if it's something that's in the record, like I said, that stands. It's not the last word wins. It's the whole entire record will be reviewed by the commission, and to not deny something now doesn't admit to it or reverse your position on anything. So, just so we're clear, go ahead.
Understood, Your Honor. There was just a laundry list of analyses, and I don't know that all of them were specifically addressed. So, but thank you. If a unit is out of service during a severe weather event, can it help customers avoid price spikes?
No, it cannot because it's offline.
Does a forward-looking economic analysis of Weston compared to alternatives of the kind you recommend allow a utility to incorporate hypothetical technological changes in the course of that analysis?
Your Honor, cross you can lead, redirect you should not be allowed to.
Okay, can you rephrase?
Why is your testimony about the need to conduct forward-looking analyses consistent with the, sorry, scratch that. How do you respond to the criticism of your recommendation that WPSC conduct a forward-looking economic analysis with reference to the optionality benefit of Weston?
Your Honor, that is outside the scope of my cross.
They asked about the optionality. There was a big point about the optionality benefits of Weston, and I'm asking about whether or not the optionality benefits of Weston are relevant to the recommendation of forward economic planning.
I don't think that was the question. I think your question was about forward-looking economics. And again, I think you're leading and outside the scope of the cross.
I asked about forward-looking economic analysis, which is a recommendation in the testimony.
Okay. I'll allow the question. You want to restate it first? If you can, we'll read it back. Just let me know.
Let's just read it back.
Okay, go ahead. Let's read it back.
Question, how do you respond to the criticism of your recommendation that WPSC conduct forward-looking economic analysis with reference to the optionality benefit of Weston?
One of the benefits of completing a forward-looking analysis is that WPSC could include multiple scenarios, including what it thinks are probable trajectories for the development of new technologies, such as long-duration energy storage. And then it could actually see what are no-regret solutions that come up across many of these scenarios. What actually makes sense to do to preserve optionality, instead of claiming without basis that one particular action that's similar to the status quo is the best solution for optionality.
Your Honor, I'll just reiterate, I don't think I asked a single question about WPSC's analysis. And to the extent we're going to restate what Ms. Metz's criticism of WPSC is, or anything that WPSC did, that is outside the scope of the cross. All the questions were directed at Ms. Metz's testimony and Ms. Metz's analysis, and that should be the scope of the redirect.
Okay, next question.
What is the relationship between gas prices and coal plant utilization?
If gas prices are lower, coal plants tend to be less economic to run.
What happened to gas prices in 2021 and 2022?
They spiked.
And what was the effect of that spike on coal plant utilization?
We saw a temporary increase in the utilization and the net revenue at Weston 3 and 4 in those years.
That's all I have, Your Honor.
All right. Thank you very much. You're excused.
Thank you.
Take our next witness, which is let's see. So let's go off the record. So all my little green stickers are gone. So vote solar, are we excused? Are there no questions?
We did, Your Honor. I had one clarification on your comment on Exhibit 12.
Okay, and we're off the record. Yes, go ahead.
You asked that be refiled with a cover page.
Oh, yeah.
There is one in there. The second page.
Okay. Maybe I missed something. So
right before that is the cover page there. And then we put the first page is our cover.
Oh, okay. I don't know why I thought that. Okay. It just wasn't. That's fine. Okay. Sorry. Yeah, that's fine. I get it. Thanks for raising that. And that's the only thing, right? Yeah.
Yeah, that'll be you have the same comment for next week's hearing too, the identical exhibit.
Yeah, I won't remember that, so just
Okay.
I'll try. Okay, so we're good with Ken Worthy, and he'll the witness will verify by affidavit. That's the plan, right?
Correct.
Same thing with Perry and Walmart.
We intend to verify by affidavit, Your Honor.
Okay, great. And I just lost my indicators here. So what about Bauer?
Hi. Oh, yes, Your Honor. We excuse Bauer and Pollack.
Okay,
They will verify by affidavit, but I do have Lane Collin here to take the stand.
All right, well, let's do that now. Okay, there you are.
See here?
Yeah, it's just he's raising his hand in a very very close-up way. All right, there you go. All right, raise your right hand. You swear or affirm, tell the truth, the whole truth, nothing but the truth.
I do.
All right.
There
Your
we go.
witness, go ahead.
Good afternoon. Could you please state your name for the record?
My name is Lane Collin.
Did you prepare and cause to be filed direct testimony, rebuttal testimony, surrebuttal testimony, and 3 exhibits?
Yes.
And do you have any corrections to either the testimony or the exhibits?
No.
If I were to ask you today while you are under oath, the questions set forth in your testimonies, would your answers remain the same?
Yes.
All right, Mr. Collins is available for cross-examination.
All right, questions? Does the applicant have questions still?
Yes, Your Honor, we do have a few questions.
Okay, go ahead.
Good afternoon, maybe even evening, Mr. Collin. My name is Patrick Proctor Brown. I'm an attorney for applicant WPSC. I think we've been in proceedings before, but I don't know that we've met. So thank you for testifying. You've recommended different options for WPSC's recovery of its remaining investment balance in the Columbia Power Plant, correct?
That's correct.
Your recommendations are not predicated on a conclusion that WPSC's investment in Columbia was imprudent, correct?
Correct.
Instead, your recommendation is based on reducing rates for WPSC's current customers, correct?
That's correct.
Why is it necessary for the Commission to decide the treatment of WPSC's remaining investment in Columbia now, when it will continue to operate well into the 2nd year of the period covered by this rate case?
Well, I answered that in my direct testimony and repeated it in my rebuttal testimony. The reason it's necessary is because the company has 2 test years in this proceeding, 2025 test year and 2026 test year. And the revenue requirement for Columbia 1 and 2 is reflected in the 2026 test year on a traditional declining cost basis, assuming a 17-year amortization period. And doing nothing, as the company proposes, other than status quo, is effectively a decision. And so the Commission does have to make a decision in this proceeding.
But in fact, it's possible that Columbia will continue operating after the scheduled retirement date. Would you agree with that?
Well, there are a lot of possibilities. It could also be shut down before that scheduled retirement date.
And you're aware that the cadence of rate cases means the rate case for 2027, you'll have information about the actual retirement of Columbia during that rate case. You would agree with that?
Well, assuming that it actually retires in 2026. Other than that, it's always a forecast. But for that matter, the 2 test years in this proceeding are forecast test years. And so they're predicated upon assumptions. And at this point, the company's assumption is that Columbia 1 and 2 will be retired at the end of May of 2026. And without action by the Commission to reduce the rate-making effects post-retirement according to my recommendations, extend the amortization period, levelize the costs, and securitize, the company's proposal is by default adopted. And there's no reason to delay a decision on that.
That's actually not really true, right? So the retirement date for Columbia matters much more on the operations, maintenance, and energy side. Would you agree with that?
I would not.
Because the plant and the balance will remain the same after May, and the forecast will just continue to the end of 2026. Don't you agree with that?
No, I do not.
You recommend that WPSC defer the revenue requirement impact of an earlier than planned retirement of Columbia, but not the impact of a later than planned retirement. Why?
I'm sorry, you broke up at the end there for me or faded out or something. Recommend that WPSC defer the revenue requirement impact, and then I lost you.
Oh, okay. So most of the question, I'll just start again, I think. You recommend that WPSC defer the revenue requirement impact of an earlier than planned retirement of Columbia, but not the impact of a later than planned retirement. Why?
Well, that's correct, because I'm interested in the effect on customers. And if there is an earlier retirement, then there is a lower cost to the company. Now, the company could have rebutted that recommendation and simply said, well, it needs to be, symmetrical, if you want to use that word. And the company did. So both options are in the record. But I don't think it's necessary for me to make a recommendation that is beneficial to the company. If that's your recommendation, which it is, your witness put that in and supported it. I don't need to support it.
I don't think anybody was asking you to, but so you chose that position because you're being paid by WEG, and you expect
Objection,
the
Your
company
Honor.
to.
That is not Mr. Collins' testimony. It's not.
I think it was pretty close to his testimony,
It's not.
actually.
He did not say he testified in this way because he was being paid by WEG. It's not true. That is not what he said.
I'm sustaining that objection. You better change gears on that kind of topic. It's just
Okay. That's fair. In your opinion, as an expert in this area, and regardless of who you're representing, would it be more equitable for such a deferral to apply in both circumstances, either if it's later retired or earlier retired than some assumed date?
Aside from the editorial comment in your question, the commission has taken the position in prior orders to address both circumstances.
Thank you. On page 8 of your rebuttal testimony, you state that the commission has the authority to remove Columbia environmental controls from the 2026 test year base revenue requirement and to direct the company to seek authority to securitize its remaining investment. And you say if the company doesn't do that, it will forgo recovery of that investment. Is that an accurate summation of your testimony on page 8?
Can you give us a line number for that?
I think it's the Q&A that starts at 7.
Okay, thanks.
It essentially risks foregoing recovery of a return of and on the environmental costs. But that is not my recommendation that the company or that the commission not authorize a return of and on the retired plant costs or specifically the environmental retired plant costs. My recommendation is that the cost be recovered, both a return of and a return on. And what we're trying to get to here is a means of achieving that end. Now, I don't really understand why the company is pushing back so hard on this, because the company has agreed that it will follow the lead of Wisconsin Power and Light. It is the minority owner of Columbia 1 and 2. It already has committed to pursue securitization financing. And yet there's this constant pushback from the company in its rebuttal answer, rebuttal testimony. I don't understand that.
I don't believe that there's any testimony where we committed to securitization in this docket. What's the basis for your statement there?
Oh, are data requests not sworn statements of position?
I don't think it says securitization in the data request response, does it?
Oh, it certainly does. And I cited it in my direct testimony.
Okay, we can move on.
Thank
You're
you.
not a lawyer, correct?
Well, thank God. Yes, that's correct.
Good answer.
Thank you.
That's the best answer I've heard tonight. All right.
Okay, well, maybe we can liven this thing up a little bit tonight, okay? I think that might be the last witness, so maybe we could go out with a jump and,
No, we're not done yet. Not after.
Oh, darn it. Okay. All right.
What is the basis for your non-legal opinion about securitization?
You'll have to give me a little bit more specificity.
Right. So we just summarized your testimony saying that the commission can exclude the revenue requirement and essentially force the utility to securitize Columbia. What is the
That's
basis for that?
excuse me, that's an incorrect statement.
Okay.
I did not say that it could refuse recovery. I just simply said that it can remove it from the base revenue requirement, direct the company to pursue securitization financing, and then it's up to the utility as to whether or not it does so. But like I said, that should be a moot issue. The company is already committed to following the lead of Wisconsin Power and Light.
All right. What is the basis for your testimony that the commission has legal authority to undertake that course of action?
Can you direct me to my testimony where I said that the commission has legal authority? I simply said that the commission has authority to remove the dollars, the cost recovered from the base revenue requirement, direct the company to pursue securitization financing through an application to seek a financing order and recovery through a securitization charge.
Right. So what is the basis for your statement that the commission has that authority?
I'm not an attorney, and I understand that there is environmental trust bond financing available in the form of securitization financing, and the legal aspects of it, I'm not opining on. I'm just talking about the rate-making aspects.
Is there any basis for the statement that the commission has authority to remove Columbia from the base revenue requirement?
Well, yes. I mean, it has done so previously. For example, on the WEPCO, 100 million, well, actually it was about $117 million securitization financing of the environmental costs of Pleasant Prairie. And the way that was handled is that the return of and on the environmental retired plant costs were removed from the base revenue requirement. The commission then allowed WEPCO to defer carrying costs at its weighted cost of capital from the date that the cost recovery was removed from the base revenue requirement until the date at which the securitization financing closed. And I think that's fair. The commission, of course, has many options in terms of influencing the utility's behavior. For example, it could reduce the rate of return after a certain date to a debt-only rate of return, or even no return at all within the permissible options for the commission to take.
Right, and you testified that you're not a lawyer, so when you say it's permissible, that isn't based on any legal training or any analysis of the legality of those commission actions. Would you agree with that?
It's the general use of the word permissible.
Okay, and actually, the Pleasant Prairie Power Plant was subject to a negotiated settlement that the commission approved, correct?
The substantive terms, that's correct, but the commission still found that reasonable. Settlements don't happen and are not approved in and of themselves. They have to be approved as a just and reasonable outcome by the utility commission. In this case, the commission did so.
Is it your understanding that the commission has the authority to deny any return of a prudent investment upon retirement?
I don't have an opinion on that. That's a legal issue. You're asking me for a legal opinion? I can't give you one.
That's all I have. Thank you.
All right.
Oh, you're welcome. Thank you.
Any other cross? I think the commission may have had some questions. Yeah.
We do. Yep. Good evening, Mr. Cullen. Evan White's on behalf of the commission. I just had one quick point of clarification to ask you about. And I guess maybe page 17 of your direct is maybe the best example. And the question I have relates to some of the terminology that you use. For example, on lines 6 through 7, on page 17, you talk about environmental plant costs. Earlier on that page, lines 1 or 2, you refer to environmental retired plant costs. And then later on line 17, you talk about environmental costs. I just wanted to ask if the difference in those terms had some sort of significance, or if they should be used interchangeably, or how you were using those terms.
I was using those terms interchangeably.
And as it relates to those terms then, what specifically are you referring to? Because I just want to get the terminology correct, because I think there's a statutory term as well for environmental control costs, which relates to the securitization that was being discussed earlier. So I just wanted to, for the record, ask when you use those terms, what you're referring to.
I'm referring to the remaining undepreciated retired plant costs that are identifiable as environmental controls. And the statute defines what the environmental control equipment is, what environmental control activities are, and the retired plant costs clearly fall within the definition there. And I say that not as an attorney, but because that was what WEPCO relied on for its environmental trust fund financing, the securitization of the Pleasant Prairie environmental retired plant costs.
That's all I have. Thank you.
All right. Any redirect? Oh, yeah, redirect. Go ahead.
Oh, no, I don't have any redirect, but I have a question for you, Judge, and that is, would it be helpful to have me file Mr. Collins' testimony and replace those interchangeably, the interchangeable words with environmental controls everywhere?
Well, I don't know. I think we've clarified it here. Do you have an opinion on that, Attorney Whites?
I think with the clarification, it might be more effort.
Okay. That's fine. Sure.
I'll defer to Your Honor.
I think there's going to be a refiling anyway. So, well, no, you know what? Let's not, because then the transcript is rendered meaningless or senseless. Let's say.
Very good.
So we'll keep that as is, and we'll deal with it on the transcript.
Okay. Thank you so much.
Thanks for the question. Okay. So we do have commission staff left. I think is there only question for witness Kraft at this point, and the rest are going to be just swearing in their testimony.
That's my understanding, Your Honor. We do have some limited cross from Ms. Kraft.
Okay. So let's see how long that takes. So you can call your witnesses, but it doesn't look like we'll have too much longer to go if there's no questions for the other witnesses. So let's proceed.
Your Honor, may I be excused?
I'm sorry. Yes. You talk so much like a lawyer that I thought you were just part of the group here.
Oh, no, please. No. Okay, thank you.
Yes, you're excused. Thanks.
All right. Commission staff would first call Justin Adams to the stand.
All right. I think you're the first one to connect with us this morning. So, all right. Do you swear or affirm to tell the truth, the whole truth, nothing but the truth?
I do.
All right. Your witness.
Good evening, Mr. Adams. In this proceeding, did you file or cause to be filed direct, supplemental direct, and rebuttal testimony?
I did.
And did you also file or cause to be filed 2 exhibits?
I did as well.
And do you have any additions or corrections to make to either your testimony or exhibits at this time?
I do. I actually have 2 of them that I'd like to address. So the first one happens to be in regard to my rebuttal testimony on page 7 of my rebuttal. Wait until you pull that up, Judge.
Oh, you know what? Don't wait. Go ahead.
Okay. So on page 7, starting at line 13 through 19, I basically lay out a plan to supplement the record with the acknowledgement of a media portrayal of the recent announcement of the Federal Reserve to cut interest rates by 50 basis points. I think that's no longer necessary because applicant witness Joe Zagantz actually brings that up in his Sir rebuttal testimony. So at this point, I don't plan to file supplemental testimony regarding that.
Okay.
And then, okay. And then for the second correction, this is in my direct testimony, starting on page 17. And on page 17 of my direct, let's see here, starting at the question on line 3, the response to that question, I used the term earnings growth twice within that section. That's actually a typo. It should say dividend growth in both instances of that.
Other than I was just going to ask, other than those two corrections, do you have any other corrections, or is that the extent of your modifications?
That's the corrections that I have. I do have a comment in response to a question that applicant witness Joe Zagantz brought up.
And we'll get to that in a second.
Okay.
With the corrections that you noted on the record here today, are the statements and representations in your testimony and exhibits true and correct to the best of your knowledge?
They are.
All right. Then I would move on to, have you had an opportunity to review the Sir rebuttal of applicant witness Bulkley?
I have.
And do you have any comments in response to your review of that testimony?
Actually, in this case, I don't have any responsive to applicant witness Bulkley, only in this case in response to Zagantz.
Okay. Then let me ask the same question as it relates to applicant witness Zagantz and his Sir rebuttal.
Yeah, so in his Sir rebuttal, let's see, starting on, I believe, page 7, he requests more information about staff's construction of the inflation estimates that are used in computation of the revenue requirement. And so I just wanted to clarify that commission audit staff buoyed their estimate of inflation for the test years based on reporting from March of 2024. And then within that, to reconstruct staff's inflation estimate, it takes the estimates that comes from both of those sources, Blue Chip as well as the U.S. Economic Outlook, and then does a 2-month rolling average of the values that are provided of those sources. So that's how it would be reconstructed if there's interest to do that on the applicant side.
Thank you. I don't have any further questions. The witness is available for cross.
Okay, do we have any questions? No? All right, thanks very much. You're excused.
Thank you.
Next, commission staff would call Akanksha Kraft to the stand. Okay, see you there. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
I do.
All right, go ahead.
Thank you. Good evening, Ms. Kraft. In this proceeding, did you file or cause to be filed direct and Sir rebuttal testimony?
Yes.
And did you also file or cause to be filed one exhibit?
Yes.
Do you have any additions or corrections to make to either your testimony or exhibit?
I do have one correction to make to my rebuttal testimony.
And what is that?
On page 2, line 8, I refer to Exhibit PSC DRR response to PSC Craft VBL 08012 024-3, and it should actually be referring to Exhibit PSC Craft 1.
And with that one correction, are the statements in your direct Sir rebuttal and exhibit correct and true to the best of your knowledge?
Yes.
And have you reviewed the Sir rebuttal of applicant witness Magna?
Yes, I have.
And do you have any comments that you wish to make regarding that Sir rebuttal?
I do have one comment that I would wish to make about that Sir rebuttal. It is in relation to page 3 of Sir rebuttal testimony of David Magna. He makes a comment there stating that for calculating the 3,078 line miles on an average per year to achieve optimality during the 2013 to 2017 time period, that there might be some miscalculations or misassumptions on staff's calculations. And I wanted to just clarify that I base my calculations to come up with those numbers on the information that was provided by WPSC in response to data requests PSC-craft-VBL -0801 2024-1A. And so I just wanted to clarify that or add that.
Thank you. With that, I don't have any other questions, and the witness is available for cross.
All right. Did the applicant have questions?
Yes, thank you, Your Honor.
Okay, go
Can you
ahead.
remind me of your name? I'm sorry.
No problem. Lauren Zank.
Zank. Okay, thank you.
Good evening, Ms. Kraft. As I just said, my name is Lauren Zank. I am one of the attorneys who represents the applicant. Ms. Kraft, do you have your direct testimony handy?
I do.
I would like to direct your attention to page 7 and beginning at line 6 of that testimony. I'm just going to paraphrase here, but this testimony seeks further information from the company regarding its requested increase in forestry costs in the test years. Is that right?
Yes.
After you filed your direct testimony, company witness Mr. Magna submitted rebuttal testimony. Is that right?
That's correct.
And the company also produced various responses to discovery requests, right?
Data requests, yes.
Fair enough. Ms. Kraft, do you have your Sir rebuttal testimony in front of you?
I do.
On page 5, beginning at line 19, you asked WPSC to provide more information relating to its forestry management miles for 2013 to 2017. Is that right?
Yes.
And then going up to page 4, line 7, you also offered that the company should correct any miscalculations in the data you present. Is that fair?
Yep.
And one other thing you requested was definitions or explanations of how Mr. Magna was using the terms, quote, tree growing into primary, end quote, and, quote, tree not growing into primary, end quote. Is that fair?
Yes.
And you just testified that you had a chance to review Mr. Magna's Sir rebuttal, correct?
Correct.
Does Mr. Magna's Sir rebuttal address the information that we just went over that you requested from the company?
Yes, it does.
Is there anything that you think is missing?
Just the one clarification that I added in response to the Sir rebuttal testimony. Barring that, I don't believe so.
Thank you. Now, Ms. Kraft, are you familiar with the direct testimony of your colleague, Ms. Probst, as it relates to the forestry adjustment?
I am not.
Okay, you did not review Ms. Probst's adjustment on the forestry program?
I did not.
Okay, fair enough. Nothing further. Thank
Okay.
you, Ms. Kraft.
All right, great. Any other cross? No, redirect?
No redirect. Thank you.
All right, thank you. All right, thank you, witness Kraft. You're excused.
Thank you.
So our next witnesses.
Andrew Field.
Yep. All right, see you there. Raise your right hand. Do you swear or affirm? Tell the truth, the whole truth, and nothing but the truth.
I do.
All right, go ahead.
Thank you. Good evening, Mr. Field. In this proceeding, did you file or cause to be filed direct, rebuttal, testimony, and 2 exhibits?
I did.
And are the statements and representations in your testimony and exhibits true and correct to the best of your knowledge?
Yes.
Do you have any additions or corrections to make to your testimony or exhibits at this time?
I don't, other than to point out that there will be a delayed exhibit added at a later time.
And that was going to be my next question. Are you planning to submit any delayed exhibits in this proceeding?
Yes.
And what would that be?
That would be for the final update to fuel costs based on the market prices of energy at a later date, and any other adjustments addressed in the direct and sure rebuttal.
Thank you. With that, I don't have any other questions, and the witness is available for cross.
All right. So yeah, we've marked that exhibit PSC field 3 on the offered evidence list. Any cross? No? All right. Thanks very much. You're excused.
Thank you.
Next, commission staff calls Mitch Horry to the stand.
Hi there. Raise your right hand. Do you swear or affirm? Tell the truth, the whole truth, and nothing but the truth?
I do.
All right. Go ahead.
Thank you. Good evening, Mr. Horry. In this proceeding, did you file or cause to be filed direct testimony?
Yes, I did.
Are the statements and representations in that direct testimony true and correct to the best of your knowledge?
Yes.
Do you have any additions or corrections to make to your testimony at this time?
No, I don't.
Thank you. That's all I have, and the witness is available for cross.
All right. Any questions? Not seeing any. Thanks very much. You're excused.
Next, commission staff would call Samantha Jervich to the stand.
There you are. Raise your right hand. Do you swear or affirm? Tell the truth, the whole truth, and nothing but the truth?
I do.
All right. Go ahead.
Good evening, Ms. Jervich. In this proceeding, did you file or cause to be filed direct, supplemental direct, and sir rebuttal testimony?
I did.
And do you have any additions or corrections to make to your testimony at this time?
I have a correction to make to one of my exhibits.
I'll get to that next.
Okay, sorry.
So as far as your testimony, no additions or corrections?
Nope.
Turning to your exhibits, did you file or cause to be filed 5 exhibits in this matter?
I did.
And it sounds like you do have a correction to make to one of your exhibits.
I do to my first exhibit, XPSC Jervik 1.
And what is that correction?
My cover page incorrectly lists Wisconsin Electric Power Company when it should say Wisconsin Public Service Corporation.
And other than that correction, are the statements and representations made in your 5 exhibits true and correct to the best of your knowledge?
Yes, they are.
And do you have anything additional to add at this time?
No.
Thank you. The witness is available for cross.
All right. Good catch. I missed that. Any questions? No? All right. Thanks very much. You're excused.
Thank you.
So
Next, commission staff would call Cara McFerrin to the stand.
Hello. Raise your right hand. Do you swear or affirm? Tell the truth, the whole truth, nothing but the truth?
I do.
Okay.
Good evening, Ms. McFerrin. Did you file or cause to be filed in this proceeding direct and serve rebuttal testimony?
I did.
Are the statements and representations in your direct and serve rebuttal testimony true and correct to the best of your knowledge?
Yes, they are.
And is there anything that you need to add or change in that testimony at this time?
No, I just wanted to point out that my rebuttal testimony addressed an error in my direct testimony.
Thank you. With that, I don't have any other questions.
All right, any cross? Hearing none, you're excused. Thanks very much.
And last but not least, commission staff would call Deborah Probst to the stand.
I see you there. Raise your right hand. Do you swear or affirm to tell the truth, whole truth, and nothing but the truth?
I do.
Okay.
Good evening, Ms. Probst. In this proceeding, did you file or cause to be filed direct, supplementary direct, rebuttal, and serve rebuttal testimony?
Yes, I did.
And did you also file or cause to be filed 5 exhibits?
Yes.
Are you intending to submit any delayed exhibits in this proceeding?
I am. I'm going to be filing a revised data request response or DRR exhibit for the additional responses that staff has received to our data request responses, plus the delayed exhibit for the public comments after the public hearing and all the comments have come in.
Are the statements and representations made by you in your testimony and exhibits true and correct to the best of your knowledge?
Yes.
Do you have any additions or modifications that you would like to make at this time?
The only change will be the change to my rebuttal testimony to account for the items being redacted in Corey Singletary's rebuttal testimony that we talked about before.
Thank you. I don't have anything further. The witness is available for cross.
Okay, any questions? None? All right, thanks very much. You're excused. That's all of our witnesses. So thank you everyone for joining us today. Full day of work. I'm just gonna make sure I have this in place before I forget. The new corrections, new filings here we're gonna expect. Okay. All right, so is there anything else we need to address before we adjourn?
Nothing from applicant, Your Honor.
Okay, all right. So I did want to mention just briefly, in the email that I sent out to parties and staff to the service list, there was a notation at the bottom reminding parties about allowed activities at the public hearing session. So this is reiterating what's in the FMO, and I just wanted to draw everyone's attention to that. We will be having the public hearing sessions on October 10th in Schwabenon. So just be familiar with that. Also, there are so that's the directions for the parties. There's also directions for the public in the notice of hearing that deals with the ability, the opportunity to file a comment, including a written comment. It's noticed in the public comment section of the notice, so please be aware of that as well. Otherwise, I think that's all we need. We'll just be expecting the refilings according to our schedule and according to the decisions we've made here today and the comments we've accepted and reviewed here from the offered evidence list. So I just wanted to make sure it's clear that now that we've gone through the documents and vetted them, I can receive them on the record once we have, and I will do so for the ones that we've already verified, and we'll do so for the remaining items that once they're verified by written affidavit. So notarized affidavit. So any questions about that? I've worn you all down. No questions. All right. Okay, so I think that's all we need to do. I appreciate everyone attending and paying attention and being productive here. So thanks very much, everyone. We're adjourned.
Thank you.
Thank you, Your Honor.
Thank you.
Thank you,
Have a
Your
good
Honor.
weekend, everyone.